It already started. Mr. Kelly's already on it. Volume off until it's our turn or something. I don't know. I'll double check on Mr. Kelly. No, it's great. No, we have to do all this. Maybe back in a minute. I texted Kelly. They might ask, like, he might tell me to have me move to this next year, just because he's going to do that. Yeah, he's going to do it. So we see what he says, okay?
All right, ladies and gentlemen, I have 9 o'clock. We have at this point 72 participants, 74 participants. So I'm going to ask if you're not actually speaking to me right now, keep it muted, or your computer muted or your tablet or whatever you're on. I'm going to call the criminal dockets first, then the civil docket. Claudia Vasquez versus state. That's she is in custody.
That is correct, Your Honor. We have sent the plea paperwork and the judgment's ready. So I do not know if Mr. King Doss is here.
Yes, Your Honor, we're here.
Okay, and
All
I
right.
have the paperwork and I'm getting ready to send it your way.
Thank you. All right, now we're up to 80 participants. State versus Caleb Guerra.
Good morning, Your Honor. Council's present. I don't know if Mr. Guerra is on. I can check. What we need, Judge, is, okay, he's on this morning, Your Honor. He's the 254 area
Yes.
code. He's calling in from Waco.
Yes, go ahead.
And this is a case that we're getting worked out with the state, but we're also trying to coordinate it with what Mr. Guerra is doing in McLennan County. And so I just need some additional time to hear from his attorney as to what's going on over there.
Okay, I'll ask you to get with Norma and get a date.
Thank you, Your Honor.
Judge
Robert
Wilson,
Adam, yes.
I'm sorry, it's Jennifer. I'm here today instead of Norma.
Okay, thank you. State versus Robert Adams, Mr. Cedillos.
That case was reset, Your Honor. We got a reset date from Jennifer.
Okay, and when is that?
I think
It's reset for 12/7, Your Honor.
12/7, thank you. State versus Moses Medina. Mr. Adams online, Eddie Adams. Right, no show. Arwin Mitchell.
I'm here for her, Your Honor. I don't know if she's on yet. They did get the invitation. I'll check and inform the court.
All right, thanks. I've got 4 screens of participants. I'm not going to scroll through all 4 trying to look for. I'll
Okay,
show for right now.
all right.
State versus Jesse Nelson. All right, Mr. Nelson, I see you. I've got you muted. Mr. Flores, your attorney, has a contested hearing in Bexar County, and whenever he finishes that, he will log on, so I'll mark you present. Jesus Lopez.
Same announcement, Your Honor. I'm here for him. That's a trial case, and don't know if he's on there yet or not. I'll check, and I'll inform the court.
I'll mark him no-show for right now.
Mhm.
Jose Mendoza.
Your Honor, counsel's present. Let me see if he's on. I don't know if he's one of these phone numbers. He's not on camera.
Jose Mendoza. Mark him no-show for right now. Joseph Marshall.
I'm here, sir.
All right. Mr. Keendaws. Okay. Didn't he answer just a moment ago? All right, I'll mark you.
Yes, sir.
He did answer just a moment ago, Your Honor.
He may have got kicked off. Max Marroquin Jr.
Counsel's present, Your Honor. I don't know if he's on. Let me check and see if he's on, Judge. I don't see him on a camera. He might be a phone call.
Mark him no show for the time being. David Jones.
Your Honor, counsel's present. He's at my office trying to log in right now.
I'm here, sir.
All right.
I'm here.
I'm marking you down. Thank you.
Okay, sir.
We'll confer, Judge.
Max Marroquin Jr. again. Recall. Javier Lara.
He is present with counsel, Your Honor. We'll confer.
Henry Brown.
I'm here, sir.
All right, Mr. Brown, Mr. Flores is in court in Bexar County. All right, and you popped up just for a moment. Would you answer again?
Yes, sir, I'm here.
Okay, Galaxy.
Yes, sir, I'm here. Yes, sir, I'm here.
Okay, I've got you.
Okay.
Okay, your attorney has a contested hearing in Bexar County. He will be on later this morning.
Okay, sir.
Please leave your phone muted until then. All right, Arwen Mitchell, saw her log. Doug Coronado.
Your Honor, counsel's present. I did speak to him over the weekend. Let me see if he's on. I don't know if he's on right now, Judge. I don't see him.
Okay. I'll recall. Rios.
Mario Moreno present as attorney for that case, Your Honor.
Okay, is Mr. Rios here at all?
I believe I did see him, but you broke out on my end. I'm not sure if you heard his name.
I'm
is that
present, Your Honor.
Rios?
Yes.
Okay, I'll mark you present.
Yes.
James Joseph Allen.
Council's present. This is Adam Crawshaw.
Yes, sir. And there's a 210 ends in 405. It's lit up. Is that your client or? Mr. Allen, are you present?
I spoke to him on Friday, Judge. I do think that's him. 1 second and I'll verify. He is aware. And
yeah. Someone has a phone with a 210 area code. The last 3 digits are 405. What's your name?
Doug Coronado.
hold on just a second.
Mr. Coronado is my client. You called this case earlier.
All right, I'll mark you present. Okay.
Judge, can you give me a second?
Yes, I'm going to mark him no show for right now. We'll see if he appears.
Okay, I'm going to mute myself and call my client because he knows.
Lionel Lozano.
Good morning, Your Honor. Mr. Lozano is present with counsel. He is, I was just texting him a moment ago. He's in the participant list, is the phone number, the 210 number ending in 579.
Okay, I'll mark him present. Filiberto Sanchez. Mr. Adams.
Judge, I'm present for him. I spoke with him over the weekend. He said he'd gotten the notice from the court and he knew how to log on. I'll try to contact him and tell him. I think he'll be appearing by telephone.
Okay, I'll mark him no show for right now. Gilbert Silva.
Your Honor, he is present with counsel this morning.
Present.
David Mora. Mr. Daniel.
Sorry, Judge, I didn't realize I was still muted. Mr. Moore is here in my office with me, and he's present.
Thank you. James Knoll. Right, Mr. Shaughnessy's just logging in. All right, Mr. Shaughnessy, James Knoll. Now. I'll mark him no show and recall.
Your Honor,
Yes.
this is Adam Crawshaw and James Joseph Allen. He is logged in. I just saw him in the participants.
I'm present, Your Honor.
Okay, thank you. I'll rename you.
I'm present, Your Honor.
We
Yes,
have you.
thank you. I'll rename you. Please keep your phone muted. Virgil Riley.
Your Honor, he is present with counsel this morning.
Up here, Your Honor.
Thank you. Michael Ray Shower.
Morning, Judge. Tony's present for Michael Ray Shower. That was a recall from last week. He was a no-show. We still haven't gotten in touch with him. We've been in touch with his mother, so we'll continue to try to get in contact with him.
All right, he has open warrants, so we'll just leave it at that.
Yeah, we're aware of that. Thank you.
George Silva.
Good morning, Your Honor. As you know, Mr. Silva is currently in custody.
Yes, ma'am.
My understanding is that today's setting was just to get new dates so we could coordinate all the other cases on the same dates, Judge.
All right, if you would work with Ms. Poppy on that.
I'll get my office to do so. Yes, sir.
Tommy Ray Ard is in custody.
Yes, Your Honor, he is in custody this morning.
Mark, you conferring. Cody Baker. Cody Baker.
I'm here for him, Your Honor. He knows to be online. I'll check on him.
No show. Shaina Perrell. Shaina Perrell. All right, that's Mr. Flores' client. I'll mark her no show. Julio Salazar Jr.
Counsel's present, Judge. We'll try to get in contact with him if we could recall.
No show. Jared Simlinger.
He's present, Your Honor. He's on the Pena Tapia guest. He's in my office.
Dylan Solis.
He's present with counsel, Judge. We'll confer.
Dominic Alvarez.
Counsel's present. I believe I saw him online. Dominic, if you can speak up.
I see a Dominic. Asking Dominic to unmute. Is that him, Mr.?
Hello?
Yes.
I'm here, sir. Dominic Alvarez.
All
Present.
right, I'll mark you present. Thank you.
Thank you.
Find his,
Cnty Avila.
Counsel's present. I don't see him online. It's been about a couple weeks since I've spoken with him. I sent out a text to try to get a hold of him, but have not
All right.
been in touch with him yet.
Mr. Avila. Sebastian Geckler.
Your Honor, Mr. Geckler is in my office trying to log on. We'll have paperwork to submit later on today.
Thank you. Brooke Lee Gonzalez.
She's present with counsel, Your Honor. She's number 9992 is the end of her number.
Yes,
Thank
I'm
you.
present.
And Judge, we're asking to reset that case to Wednesday. I've conferred with the district attorney's office. We have a plea offer. We need to execute plea paperwork.
Okay, that's fine. So what I'm going to ask you to do, and that's the other attorneys on civil or criminal cases that are being reset. We don't have the multi-part carbonless forms. So just go to chat and send me a chat message that has the cause number. You don't have to put cause number in front, just the cause number, client's name, and the date it's being reset to. Because
Okay.
we're going to be sending out notices. My chat is automatically saved. You can set up your chat attorneys so that it will automatically save and you'll know when you've promised to be anywhere.
And give me that information, Judge. Cause number, client's name, and what was the other part?
Date that it's being set to.
And then last question, Judge. Is it all right if we do signature on the documents?
If you do what?
Do you mind if we do e-signature on the documents, or do you need her to sign them in person?
I would much prefer an e-signature,
Okay, thank you, Judge.
so we don't have to keep printing and scanning and scanning and printing.
Yeah, what I'll do is once they get it to me, I can do an e-signature with her and we'll do that for her.
All right, thank you.
Thank you, Judge.
See you Wednesday. Trinidad Marroquin. Trinidad Marroquin. Mr. Briggs is answering the docket in Frio County. I'll recall Christopher Ward.
Yes, Your Honor. Council's present. Mr. Ward's on under Anderson and Associates. He's in my conference room.
Okay. I saw that. I saw that.
Yes,
Go ahead.
Oh, there's some additional discovery we'd like if it exists before we make a decision what to do. So we plan to ask for a reset today, if we could.
All right. If you will get with the coordinator, Jennifer Poppy, either through chat or email or calling the office, I'd appreciate it. She is online.
Okay. Thank you, Your Honor.
All right. I have a note that the next three cases, State versus David Denon, Eric Doyle, and Dayton Martin, have all been given attorneys and 1124, or hired an attorney, and they all have 1124. And then the next page is in custody, has 1124. So State versus Antonio Morales.
He didn't show up this morning, Judge.
He did or did not?
He did not.
Okay. Right, and are you in Floresville?
Yes, sir.
Okay, because I knew there were a couple of people sitting around outside. All right, I will mark no show and recall.
And Your Honor, you had skipped Eric Doyle. He was on the previous page. That's going to be a pretrial diversion, and he should be at the probation office. He was on the previous page. I think it was in between that one client that you had mentioned that was hiring an attorney.
Okay, and I will answer and apologize for that. I was told he was to be here for arraignment on 11/24. Nobody gave me a pretrial diversion message. He did show up here and we told him to come back 11/24.
Okay, I'll call him and figure that out.
Okay, so we'll leave him for 11/24. If you can get that done more quickly, that's fine. Just
Well, yeah, I'll have him show back up to the probation office.
Okay.
All right.
Francisco Rojo.
That was a no-show, Judge.
All right. Okay, on the criminal edition, State versus Priscilla Rodriguez.
And Your Honor, that's going to be a plea. Paperwork will be in shortly.
Okay, and I'm going to go back to the Francisco Rojo. He did too show up here. He is in
Mr.
our
Doyle.
lobby, and he
Okay,
needs
go
an
back to probation.
interpreter.
They gave you the wrong information, so just head on.
Sorry, Ms. Sawyers, go ahead.
Okay, Mr. Rojo is here in our lobby, but he needs an interpreter, he informed us. We were going to put him on the computer, but he does not speak English.
Okay.
Get him interviewed, I'm sorry.
If you can, yes, ma'am. So I'll mark him present and needs interpreter. All right, now I know a number of people were admitted after we started the docket.
Tim?
Just on the criminal cases, is there anyone whose name was not called, or at least not called after you appeared?
Judge
Your
Philip,
Honor, Jose Arturo Mendoza.
One at a time, one at a time. Mr. Barrera's higher up on the Hollywood Square here. Go ahead, sir.
Jose Arturo Mendoza, he is on page 2. He is now on the Zoom call, Judge.
I'll mark him
Yeah, I'm
present.
on the Zoom call. I wasn't. My audio wasn't working when I log in.
All right, and please remove your hat, sir.
Yes, sorry.
All right, Mr. Adams.
Yes, Judge Filiberto Sanchez called me. He is on here on a telephone number ending in 7331. Mr. Sanchez? Mr. Sanchez, unmute yourself and announce for the court, please.
All right, 7331.
Yes. Or that's the number he gave you.
Mr. Sanchez, I'm asking you to unmute your phone. You should have just gotten a message about that. Well, I'll change the name, but I still need to hear from him.
Mr. Sanchez, if you can hear us, please unmute your phone so the judge can hear you.
All right. Anyone else?
Yeah, Mr. Jesus Lopez.
All right. All right, Ms. Carrillo,
Hello?
it's one of your clients. Yes, Mr. Lopez. I will
Oh, okay.
mark you present.
And Your Honor, I texted you that information. May I be excused till Wednesday?
Yes.
Thank you, Judge.
Okay. Anyone else?
Judge, did you call Joseph Lawrence Marshall?
I did.
Okay.
He answered, I believe, but you did not.
Okay, I was on another call.
Yes, he's present.
Good, okay.
All right. Anyone else on criminal cases?
Judge Ed Shaughnessy for James Richard Novell. I spoke to him on the phone this morning. I don't know if he logged in or not. He said he was going to log in by phone.
He did not answer, but there's a number of phones. All right, I've got a 2-1 code that ends in 579. I'm asking you to unmute.
Your Honor, this is James Noel. I am present, sir.
Did you get that, Your Honor?
Yes, let me change the. Okay, phone number 210, code that ends in 233. I'm asking you to unmute. What's your name?
Your Honor, this is Brian Lissy, civil docket.
Your Honor, that's an expunction set on the civil docket this morning.
All right, well, we've got him. We know who he is now. 281 area code that ends in 734. I'm asking you to unmute. They hung up, okay. All right, I am going to open up some breakout rooms and Jennifer, are you okay on us doing the assignments in the breakout rooms?
Yes, sir, I am.
Okay, I am going to make you the host because only the host can do that. If you would make me the co-host so I can still mute people, I would appreciate it.
Yes, sir, 1 second.
And the civil dockets ought to be real quick to call. We'll call those and then I'll let start working on breakout rooms. Wilson County, 1312-721 in the interest of BDW, a child.
Your Honor, with that is CDW 1300-721. Did I hear you correctly?
Yes.
Your Honor, Anthony Bancroft for the movement, Sheldon Walpole, we are present.
Good morning, Judge Rasheen Mazaheri for respondent Laura Walrope. We are present.
Okay.
I would like to go in a breakout room and speak with Mr. Bancroft before I announce ready or not ready.
Okay, and let me, you have to get those breakout rooms from Ms. Poppy.
Yes, Your Honor.
And is the Attorney General involved in this at all now?
The Attorney General is present, Your Honor, Corey Calvano. I don't see that we have an interest in this part of the matter, Your Honor.
Okay, all right. Are both sides in agreement with that?
Yes.
Yes, Your Honor. I'll go into a breakout room. That's fine.
All right, then I'll excuse you if that's all you have, sir. 15-60359 in the interest of PRS, a child. Leslie Sokonowitz? All right. In the interest of 18-12-965, in the interest of DJ, a child.
Commissioners present, Your Honor.
All right, this says trial on the merits. Is it still 2 hours?
Well, Ms. House filed a motion to withdraw on Friday. And my understanding is that Mr. Jimenez does want to represent himself. But I told him I needed the court to officially discharge her before I could talk to him.
Okay.
And I haven't heard from Mrs. House's office. I emailed her and called them. They haven't called me back.
Judge, we're here and we actually did send correspondence. We sent correspondence over. Our client wants to proceed as a pro se. He's here. It's my understanding. And if we filed a motion for withdrawal so that allow him to do that, he is in agreement to this so that he can proceed representing himself, Judge. And so I just like, I guess, I don't know if he's on to speak for himself to give me the official okay that he's going to proceed so that I can be released.
Okay, and what's his first name?
And his name is Eric Jimenez.
Your Honor, he's actually here with my client in another room, but I told him I couldn't talk to him until she was officially withdrawn.
All right, Ms. Pereira, if you could
go get him.
Get him, please. While we're waiting on that, 19-2-180 in the interest of Selena and Jaylee Talamantes.
I'm present, Your Honor. We need about an hour and a half for the temporary order.
Andres Cedillos representing Jason Talamantes, Your Honor. I'm present. And Jason Talamantes is present.
Yes, I'm present.
In the Office of the Attorney General is also present, Your Honor, and I'd be happy to speak to either of the attorneys about the necessity of our involvement.
Okay, and I'll direct the attorneys to confer in a breakout room.
I gotta log on in a minute.
All right, Ms. Pereira, was Mr. Jimenez back?
Yes, Mr. Jimenez.
Okay, are you Eric Jimenez?
Yes, sir.
All right. Ms. Jimenez, your attorney, Ms. House, has indicated that has filed a motion to withdraw and as your attorney and indicates that you wish for her to withdraw and for you to proceed representing yourself in this case?
That's correct.
Okay. All right. Are you still going to be ready to try this case this morning?
Yes, sir.
Okay. All right then. Ms. House, if you will send, I just checked on the e-file system. I didn't see a motion to withdraw. If you will send me a copy of that in chat.
Okay.
I'll sign it back and I'll go ahead and do that verbally. Ms. Pereira can confer with Mr. Jimenez.
Thank you, Judge.
Thank you, Judge.
All right, expunction, State versus Brian, it's in Ray, Brian Lissy.
Your Honor, counsel's present. All of the green cards have been returned on this case. We verified that with the district clerk's office.
And what is the date of the alleged offense?
Let me pull that up for you, Your Honor. It is December 23rd of 2018.
All right, thank you. All right, I'll mark you number 1. My computer will work. Expunction, in Ray, Mike Ramirez.
Your Honor, that's a little odd because we had already previously done an expunction on this case, but at the time that we did it, the driver's license number was incorrect, so we had to resubmit a new petition, but there may not be an existing file on this case, because my understanding is everything was expunged, but there was a little issue with the driver's license number.
Okay, number 2. Henry Bruce Phone.
And that's an expunction. All of the green cards have been returned on that, Your Honor.
Number 3. Rochelle Riza et al. Versus Ashley Brown.
Good morning, Your Honor. Marisa Aragon. I am present for the movement, Rochelle Rizzo. I saw somebody present named Ashley, but I don't know if it's the Ashley, the defendant on this case. So maybe if we could get her called on Zoom or in the hallway. She was sent notice and was noticed to be here.
All right, is Ashley Brown online?
Yes, I am.
Okay, Judge. Judge, this was our motion for summary judgment. No response was filed by Ms. Brown. So, I mean, procedurally, I think that we can present an order, but I'll defer to the court. Otherwise, we announced 2.5 hours for our motion for summary judgment.
All right, and what sort of case is this?
This is it's an issue having to deal with a trust and kind of suit to quiet title.
All right, and Ms. Brown, are there other people present there with you?
No, sir, my counsel is not here. I need a continuance.
Okay.
Judge, I have not received anything from any attorney for Ms. Brown. She has filed a pro se answer, and so at this point, I do not believe she has counsel.
All right, Ms. Brown, who is your attorney?
Courtney Hillard.
Courtney Hillard or Dillard?
Hillard with an H.
Judge, if I may, I just spoke to Attorney Hilliard. He's had a death in his family, and this is an emergency that arose. I just happen to be on, and I'm talking to him via text, so.
Okay.
But I'm not here to stand in his place.
Ms. House, Ms. House, are you able to confirm that he was retained on this case? Because I hadn't gotten anything or heard from anything.
I'm not able to do that. I'm just letting you know about the circumstance of Mr. Hilliard.
Okay, thank you.
Can you text him and ask him that, say the judge is asking, is he retained on this case? And it's Riza, R-I-Z-A versus Brown in Wilson County?
I will ask him, Judge. Thank you.
Thank you. Randall Bird versus Sparkle Car Washes of Texas et al.
Your Honor, are you able to hear Mr. Taylor?
Apparently not. I didn't hear anything. I see Mark Taylor online.
Okay, let's see.
I see him nodding.
He's not coming through. Mr. Taylor is petitioner's counsel. I am local counsel on this case, Your Honor. There are a couple of motions that are set. I know that they set a motion. Mr. Taylor has filed a motion to compel. Okay, he's trying to get on. Okay.
Yeah, it looks like he's trying to get on a different way. Okay.
Yes, Your Honor. We filed a motion to compel responses. And my understanding is that opposing counsel has filed a motion to transfer venue.
All right, is there anyone from his firm on?
I don't know, Mr. Lawrence. Never met him, Judge, but we are ready on our motion to compel. Can you hear us, Mr. Taylor? And we do have our client on. He's up on the screen as Randall Bird, Your Honor. Okay, come on, Mr. Taylor.
Okay. and that just goes. Well, hold on, somebody's calling in with,
Can you hear, Mark Taylor, Your Honor, can you hear me now?
yes.
I don't know what's wrong with the audio through the Zoom on the computer, but it was not, I can hear you, but you can't hear me, obviously, so I apologize. Yes, Your Honor, Mark Taylor, along with Sylvia Rodriguez here on behalf of Mr. Byrd. There are two matters set. There's a defendant's motion to transfer venue. We have filed our declarations. We filed a response. There are no controverting declarations that have been filed, and I'm happy to go through those issues with you. I don't know where Mr. Lawrence is. Second, we have a motion to compel production of documents. I did receive, after I filed the motion to compel, just within the last week or so, written responses to the discovery requests that were due over 2 months ago, and a handful of documents. But apparently there are substantial additional documents that have not been produced to date. And so we're going to need a little bit of time on these. You know, I don't know where Mr. Lawrence is. He had filed a motion for continuance saying that he was quarantining for COVID reasons. The motion for continuance said that he had been exposed on October 19th. I know I talked to him. He was working in his office on Wednesday because I talked to him in his office on Wednesday. He did say that when I talked to him again on Thursday, that he had no symptoms. The test had come back negative. And so we didn't see that there was a basis for continuance, and I'm not sure why he's not on the line today. But we're prepared to go forward both on the defendant's motion to transfer venue, which we believe should be denied, and very briefly on our motion to compel.
Okay, I will ask you to just call his office and report back. And when I ask for announcements in a few minutes, what's going on, I hate to rule on something and then we have the attorney show up late.
I'll do that right now, Your Honor.
For somewhere else. All right. And give me just a moment. All right, is there a Rachel Comiskey at your office, Mr. Taylor? No, okay.
Your Honor, no, Your Honor, she's not with my office.
Okay, I
believe
there's a way to,
okay,
there's a way to merge audio and video, so you take the two boxes and put them together. But the only person that will let me merge you with is Rachel Comiskey, and I didn't think that was the same.
No, Your Honor. I've never had this issue before Zoom, so I'm not sure what's happening with my computer today. I apologize.
Okay. All right. And Ms. House, did you have a report?
Yes, Judge. I spoke to him, and according to him, he has not been officially retained to represent the party on this case. So it sounds like maybe there's a misunderstanding, and this particular party needs a short reset to call Mr. Hilliard to perfect, this representation. But as of today, he's not, the requirements to retain him have not been fulfilled. And he has no notice of appearance on this case, Judge.
All right, Ms. Brown, I expect we're going to go forward with this very shortly, but I will give you until 10 o'clock to report back that you either have hired Mr. Hilliard or not.
Yes, sir.
Okay.
Judge, I have a question. You asked me to chat you in order of withdrawal. Do I need to wait for that order, or is it okay that I just sent it?
I have it right now. If you'll give me just a moment, I'll post it and you can have it.
Thank you, Judge.
Okay, and in the Peeler case, time estimate for today?
Your Honor, we have a motion for referral to the special master that we think will take 10 to 15 minutes of all the motions to exclude experts. And then if Your Honor denies that, we have two motions to exclude experts that we believe will take about 2 hours total.
So 2.5 hours?
Yes, Your Honor.
All right, Ms. House, this document, it actually says final decree on the name, I see, but it's an order on motion withdrawal, so I just posted that to everyone.
Okay, thank you, Judge. We'll correct. Thank you.
All right, and Mr. Barrera, on your 3 expunctions, have you submitted your orders?
We did, Your Honor. We filed orders with the court.
Okay. All right. I always want to go back and just look at the file and just make sure that there wasn't an answer you weren't made aware of filed or something. But barring that, I will sign all those orders today.
Thank you, Your Honor.
And do y'all want to go ahead and talk to Ms. Poppy about getting breakout rooms for everyone? And then we'll see where we stand on the civil cases.
Yes, please let me know if you do need a breakout room. I've been putting some of the civil folks in rooms.
And Your Honor, we'd like to remain on docket and ask to be excused, my client and I.
That's great. You already have dates?
We have dates, we posted them. My one client that has not shown up, if he does show up, I can be available by phone and I'll get back on.
Okay.
Thank
All
you.
right. So so you're excused then. Do we have I have a plea on Vasquez. Anyone else we have pleas for?
Judge Filiberto Sanchez showed up. He is in the courthouse lobby. I believe Ms. Sawyers can verify that.
Yes, he is here, and I also see his name on showing up that he's on his phone.
Yes, I thought he was. Okay, yeah, he's marked present.
We're going to remain on the docket. We need a new date, Judge.
All right. You get those from Jennifer Poppy, so confer with her about that.
Okay, thank you, Judge.
And Judge Priscilla Rodriguez will be a plea this morning as well.
Okay. All right, let me know when you'll have the paperwork on those.
And Your Honor,
Yes.
I had Arwen Mitchell. She's logged on.
Yes, I marked her down.
And the phone, Mr. Jesus Lopez is by phone. I just saw him. He's down there with all the phone numbers.
Yeah, I'm Jesus Lopez. I'm here.
Okay.
Yes,
So
right.
this is going to remain on docket, so I'll just get a date from Jennifer.
Yes.
Okay, Your Honor. Are my clients excused?
Yes.
Thank you.
As soon as you send me the chat message.
Okay.
Yes.
Thank you.
Jennifer, this is Ed Shaughnessy. Could I get a breakout room with the prosecutor?
Who's the prosecutor, please?
Miss Whitney, I believe.
Okay.
Thank you.
And Ms. Poppy, this is Steve Barrera. If I could get a breakout room with Mr. Leday.
Yes, sir, I'll get that right away.
This is Mike Ramirez. I'm just now joining.
And Mr. Ramirez, you can log off.
Okay. Thank you, sir.
Ms. Poppy,
Yes, sir.
this is Doug Daniels in Houston. I have a civil case pending there, but I don't see that I have anything set today. I did receive notice of this Zoom, so I joined, but I haven't heard my case called, nor do I see my opposing counsel on the meeting.
Sir, I was informed that on a criminal case, they were trying to contact the wrong Doug Daniels, and I believe that's you, sir.
Okay.
So I apologize. I think that was just done incorrectly.
That's okay. May I be excused?
Judge Wilson?
Judge,
I'm muted. Yes, you're excused.
Thank you.
And Ms. Poppy, whenever Ms. Whitney becomes available for breakout, may I have a breakout room with her as well?
Yes, sir. I have you on the list.
Thank you very much.
Judge Wilson, just to inform you, there is a civil case, fourth one down on Talamantes versus Talamantes. They have already conferred and are ready.
Yes, Your Honor.
All right. Give me just a moment. Okay, and which one of the civil cases was ready to proceed?
The Talamantes case, Your Honor, 19020180.
In the interest of JMT and SJT.
And Your Honor, Mark Taylor is back on the Randall Bird versus Sparkle Car Washes matter. I contacted Mr. Lawrence's office. They said he was on a call. The secretary said she Skyped him. I don't know where he is. And so I don't know whether he's planning to attend or not. I couldn't figure out from the secretary. She said she notified him, and that's all she could do.
All right, well, I'm going to ask Ms. Poppy. We haven't heard anything from him, have we?
Sorry, sir, from who?
It'd be Paul Lawrence.
Paul Lawrence. Paul R. Lawrence.
We have not, to my knowledge. No, sir.
Okay, well, we'll hear that first. Now, with all the attorneys on Peeler, I take most everybody's at their office so they can work on other things.
Yes, Your Honor.
True, Your Honor, yes.
Yes, Your
All
Honor.
right, why don't we call that at noon? Because there's several short matters plus pleas. Noon may be optimistic, but or do y'all want to go to lunch and we call it at 1?
Why don't we make it 1 o'clock, Judge?
Your Honor, that's fine with KMG, Kiewit Mining Group.
Okay, I'll recall this for 1 o'clock. If you'll make sure that someone has sent me a link to a box with whatever things, I'd appreciate it. We'll see y'all at 1 o'clock.
Thank you, Your Honor.
Thank you, Your Honor.
And if the state will let me know when they have prosecutor available, we'll start on the plea. But first of all, Bird versus Sparkle Car Washes. Okay, there's a motion to transfer venue that. All right, Mr. Taylor.
Yes, Your Honor. I'm sorry, Mark Taylor on behalf of the plaintiff.
Okay. It's the defendant's motion to transfer venue?
Yes, it is, Your Honor.
And you said that you were opposing it, you were not opposing it?
No, we do oppose it. We have filed 2 declarations for Mr. Bird establishing the facts to support venue in Wilson County, and we filed our response. Essentially, Your Honor, this involves, among other things, claims relating to fraud in connection with an agreement to settle a prior lawsuit that involved transfer of stock in a corporation in Mexico to Mr. Bird. That stock was purportedly transferred to him while he was living in Wilson County. It turns out that the defendants did not own the stock that they purported to transfer, and that's part of the basis for the action that we brought before Your Honor. And the case law we've cited in our response to the motion transfer venue is that in order to establish venue for a fraud claim, you just have to provide proof of fraud committed in the county where the venue is alleged, and that fraudulent representations made or communicated to a resident of a particular county give rise to venue in that county. And that's the Rogers versus B&R development case out of Fort Worth. And the first case I referred you to was Brown Company versus Terrell out of Amarillo, the Amarillo Court of Appeals. The declarations we filed for Mr. Bird established that he was living in Wilson County at the time of these events, but the stock was purportedly transferred to him while he was living in Wilson County, and therefore the representations and misrepresentations were made to him while he was living in Wilson County. There are no controverting declarations. There's been no reply filed to our response. And so, Your Honor, we believe that venue is established as a matter of law in Wilson County, and we'll ask that the court deny the motion.
All right, give me just a second.
interviews on the line, on the phone, not on Zoom. Yeah, I know. I'm doing.
All right, and I'll take judicial notice of the contents of the clerk's records, including the fact that the notice was sent out on October 21st of today's hearing. And I've also read the plaintiff's response and the declarations or declaration of Randall Bird, and I'll deny the motion to transfer venue. If you will get me an order in chat, I will sign that and post it back to the clerk this morning. All right.
Yes, Your Honor. Well, should we just upload it to the court's website, or what's the best way to get the copy?
If you have it right there, if you'll just send it to me in chat here on Zoom,
okay.
I will sign it and send it back.
Yes, Your Honor. I'll get my secretary to send that to me, and then I'll forward it to you.
Thank you.
The second motion we had, Your Honor, that was before the court today is our motion to compel production of documents. Your Honor, we served requests for production of documents with the petition, and the responses were due in mid-September. After filing the motion to compel, and I emailed Mr. Lawrence repeatedly trying to get documents, finally filed the motion to compel. After I filed the motion to compel, I received written responses to the discovery request, along with some documents. I was told that there are boxes of other documents in a warehouse that we can go through and see if there's anything responsive. I told Mr. Lawrence that's not the way that you respond to document requests, that you actually have to go through them and find the documents and produce them, which they have not done. Your Honor, we've requested that the court enter an order compelling the production of documents. They can be compelled to do so within 5 days. And we've asked for recovery of attorney's fees. I would submit to the court that because I've had to go through a number of emails, because I had to file the motion to compel and appear for the hearing today, then appropriate award of attorney's fees, in my opinion, would be $1,000. So we'd ask the court to compel the production of responsive documents within 5 business days and provide us $1,000 in attorney's fees for having to go through this process.
When they say boxes of documents, do you have any idea of what sort of volume they're talking about?
He said there are 5,000 or 6,000 pages of documents in a warehouse or in storage that in Houston, and he expects me to drive to Houston and go through boxes of documents instead of them pulling responsive documents. And I started practicing law in 1987, and that's kind of the way we did things back then. But that process has changed over the years, and it's certainly not something that we require parties today. You don't make somebody go sit in a warehouse and look through documents that you don't want to go through and find yourself and produce.
Most people are concerned about letting folks just rummage through all their records, but
typically,
if you will
that's right,
submit your order on that, did you want to put any testimony on about attorney's fees?
Yes, Ron, I'd be happy to do that.
You solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Okay. All right.
My name is Mark Taylor. I'm an attorney licensed to practice law in the state of Texas and have been doing so since 1987. My practice consists primarily of business litigation and business bankruptcy. I have appeared in courts throughout the state of Texas as well as in other states, and I'm familiar with the reasonable and necessary attorney's fees charged for matters such as this. In this case, we served discovery request for production of documents with the petition. The responses were due in mid-September. I did not receive any written responses until after numerous attempts to get opposing counsel to provide documents. We ultimately filed the motion to compel production of documents and have received responses within the last week to 10 days with some documents, but not all. And we've been invited to come to Houston to go through 5,000 to 6,000 pages of documents to determine what other documents are responsive to our request. It's my opinion that based upon what's occurred in this case and the amount of time that I've had to put in to just trying to get the documents, as well as prosecuting the motion to compel, that a reasonable and necessary attorney's fee would be $1,000 for my efforts to date, Your Honor.
All right. Do you have your proposed order?
Yes, I'll submit that to you on chat as well, Your Honor.
Okay, I appreciate that. I'll tell you what I'm going to do. I am going to give them 20 business days if there's that many documents, but I will condition the award of $1,000 in attorney's fees, that if they produce the documents within 5 days, they don't have to pay the attorney's fees. If they don't, then 20 days. So they can either spend the money to get the documents looked at this week, or they can cut you a check.
Thank you, Your Honor. I appreciate it. And I'll revise the order to reflect Your Honor's ruling.
All right, thank you.
Thank you very much.
All right, thank you.
And that's all we have for today.
If that's it, you are excused.
Thank you.
Your Honor, just wanted to inform the court, Nick Silva, I'm waiting for Ms. Whitney to get back with me. We just need to get new dates on him. Is it okay, Your Honor, if I excuse myself temporarily so I can answer the docket in Frio County?
Yes.
I'll be back on, Judge, in just a minute. Thank you, sir.
All right, give me just a moment.
Judge Wilson, I needed to ask if Mr. Leday was available to join a breakout room.
Just go ahead and do that.
Mr. Sean Keaton Dulles has been in the breakout room. Just wanted to make sure that Mr. Leday was okay.
I'm available.
Okay. If it doesn't come up any longer, you may have to hover over the breakout room icon.
Right, and you can, usually you should be able to go to breakout rooms at the bottom, and they'll still show the attorney in the breakout room, but if there's I think there's a green dot if they're actually in it, if they're available.
Yeah, he just went in now, sir.
Okay.
Judge?
Yes.
My name is Leslie Sakanovich. I'm sorry, I was having trouble buffering in, but I'm here in the civil docket. It's CVW 1500359.
Yes, sir. I had that marked as no show. What's going on?
I'm representing the movement, which is Miss Anna Locke. And so we probably would need about 10 or 15 minutes of the court's time. It's a motion for enforcement of a divorce decree.
Okay, and who's supposed to be on the other side?
The other side is supposed to be Mr. George Silva. I was in communication with him last Wednesday, Thursday, and Friday. I forwarded him the Zoom invite, and I also amended the Zoom invite to include him as an invitee on the for the hearing this morning. I think he's pro se.
Online.
Judge, I'm here, Your Honor.
Well,
yeah, so I'm going to ask the two of you, Miss Poppy, Jennifer Poppy, to put you in a breakout room. So you can confirm. All right, going through. Going back through the civil docket before we get started. 13/27/21 in the interest of BDW. The attorney's in a breakout room, good. All right. The Silva child needs to confer in a moment. In the interest of the Jimenez, Ms. Pereira, you're conferring. All right. In the interest of the Talamantes children, what announcement?
We're ready, Your Honor, about an hour and a half.
We're ready on 1 hour.
Typically have okay. And does anyone have copies of whatever temporary orders are in place?
Yes, Your Honor, I have a copy.
If you would post those to me in chat.
Sure.
Judge Wilson, I apologize, but I need to know what the names are that need to go in that breakout room on the second case.
George Silva and Leslie Sakanowitz.
Okay, thank you.
Okay, and Ashley Unique Brown, Ms. Brown?
I am here, Judge. I'm not sure.
Yes, I'm trying to get him the invite. Just a moment.
So representing to me that Mr. Hilliard is going to make an appearance on the Zoom hearing?
I believe he's calling in.
Okay, I'll recall in a few minutes.
Your Honor.
And do we have an attorney for the state, Ms. Whitney, to do the plea on Vasquez?
I can pull up. Let me pull her up, Your Honor. Yes, sir. Yes, on Claudicia. Yes, sir. I'm ready to go on that one.
Okay, and do we have her at the jail? If we could get her, is the jail online?
They were earlier.
I saw the bailiff, I thought.
I'm sorry, who was that again?
Claudicia Vasquez?
Yes, I have her. Let me get her, Your Honor. You need her?
Please, we're going to do a plea.
And Your Honor, before you begin,
Yes, ma'am.
I have the date posted after several tries, but I posted it correctly. The new dates for my clients, Arwin Mitchell and Jesus Lopez, and it's in the chat.
All right, you're released. Thank you.
Thank you. My clients are released also, right?
Yes.
Thank you.
Your Honor, the same holds true with me on Mr. James Noel.
Yes, sir. If that's all you have, you're released.
Thank you. May I be excused? And I'll excuse my client.
Yes.
Thank you so much.
All right. And Ms. Whitney, do you have I've got a scan of the judgment. Do you have the judgment in a format?
I don't have the judgment, but one of my admins has it, and if you need it, I can get it sent to you.
Yes,
Do you want it sent?
Please.
Just email to you?
Emailed or posted in chat.
Okay.
All right. Calling State of Texas versus Claudicia Vasquez. Are both sides ready?
State's ready to proceed, Your Honor.
Defense is ready, Your Honor.
Okay. Are you Claudicia Vasquez?
Yes, sir.
Is that your true and correct name?
Yes, sir.
Are you the same Claudicia Vasquez who on or about June 10th, 2015 was placed on deferred adjudication probation for the second-degree felony offense of possession of a controlled substance with intent to deliver?
Yes, sir.
And you understand, ma'am, that on that day, the judge found there was enough evidence to say you were guilty, but did not do so. The judge placed you on deferred adjudication probation. And if you successfully complete everything that you're supposed to do on deferred adjudication, the case against you will be dismissed and you'll have no conviction. But the state has alleged that you've broken the rules of your deferred adjudication. And if that is true, then you could be found guilty today and sentenced to anything that is a legal sentence for a second-degree felony, 2 to 20 years in confinement and a fine up to $10,000. Do you understand that?
Yes.
All right. Now, specifically, the state is alleging that you violated rule number 11 of your deferred adjudication probation. They're alleging that you failed to report your probation officer and that you failed to report your probation officer in July through December of 2015. And that you actually have failed to report your probation officer from July of 2015 to September of 2020.
Yes.
So do you understand what it is the state's alleging that you did wrong?
Yes.
All right, and just if there's people who are trying to get on, about 3 times I've had a little beep beep. I don't know if it plays over the broadcast for everyone else to hear, but I get a little beep beep when somebody appears, or maybe Jennifer Poppy. Maybe Miss Poppy's admitting people. And just every time I look.
It's also from people going in and out of break rooms, sir.
Okay. All right, I typically don't get a beep on that, but they may have changed. They update this all the time. Okay. All right, ma'am. So do you understand what it is the state's alleging you did wrong?
Yes.
Okay. Can you speak, read and write the English language?
Yes.
Okay, I want to show you some documents that appear to have your signature. They're titled Written Waiver and Consent to Stipulation of Testimony. Let me ask, is this your signature on page 3?
Yes.
And do you swear or affirm everything that appears above your signature on page 3 is true and correct?
Yes.
All right. And is this your signature on plea bargain agreement?
Yes.
On written waiver of time to file motion for new trial?
Yes. Yes.
Okay. On the certification of appeal?
Yes.
All right. Did you read these documents yourself, or did your attorney, Mr. Keendaws, read them to you?
Yes, he read them to me.
Did you understand these documents before you signed them?
Yes.
Okay. And are you satisfied with the work that Mr. Keendaws has done for you?
Yes.
And do you understand, man, that the plea bargain agreement you have with the state is not binding on me? I do not have to follow it. If I decide not to follow it, I will allow you to withdraw your. So do you understand what I'm saying there?
Oh, I couldn't hear you that good.
Okay. All right. You understand that the plea bargain that you have worked out with the state's attorney, I do not have to follow that. I don't have to go with it.
Mm-hmm.
But I'm not going to follow it, I will let you withdraw your plea.
Mm-hmm.
Do you understand that?
Okay.
Got to answer yes or no, Chloe.
Yes.
And if I do follow the plea bargain, on the other hand, and the sentence I impose is not harder on you than what you have agreed to, you will not be able to appeal this matter. Do you understand that?
Yes.
All right, counsel, do you believe your client understands the nature of the rights she's giving up, the stipulations of evidence she's making, and the consequences of her plea bargain?
Yes, Your Honor.
All right, ma'am, I'll find that you made your waivers of right and your stipulations of evidence knowingly, intelligently, and voluntarily. And I will approve them, and I will ask you to the allegation that you failed to report your probation officer as required by paragraph 11 of your probation terms. Is that true or not true?
True.
All right, I'll accept your plea of true, and I'll ask what evidence the state has to substantiate the violation.
Your Honor, at this time, state would offer State's Exhibit 1 and its attachments.
No objection, Your Honor.
All right, without objection, State's Exhibit 1 and its attachments are admitted into evidence. Do both sides rest and close at this stage?
State rest and closes, Your Honor.
Defense rest and close, Your Honor.
All right, I'll find that there's enough evidence to substantiate the violation, and I will also find that a change needs to be made in the disposition of this case. Are both sides ready for that hearing?
State is ready to proceed.
Defense is ready, Your Honor.
All right. Is there a waiver of a pre-sentence investigation report?
Yes, Your Honor.
Okay, what is the plea bargain in this case?
Your Honor, at this time, the state is asking that the defendant's probation be revoked, that she be adjudicated, that she be confined in the Texas Department of Criminal Justice for a term of 6 years, that she be credit for time that she has already served, that being 48 days worth of credit.
That is the agreement, Your Honor. And also, she has a charge out of Gonzalez. We would ask that this to be run concurrent with whatever sentence is imposed in the Gonzalez case.
That's typically required as a matter of law, but all right, what sort of case is the Gonzalez case?
It's also a possession charge, Your Honor. I believe it's 1 to 4 also.
Anything else from either side?
Nothing further from the state, Your Honor.
Nothing from the defense, Your Honor.
Okay, I will follow the plea bargain agreement in this case. I will find you guilty of the second-degree felony offense of possession with the control of a controlled substance with the intent to deliver. And I will sentence you to, is it 6 years?
Yes,
6 years, Your Honor.
All right. Is there, plus the rest of the terms and conditions of your plea bargain agreement with the state, is there any legal reason why sentence should not now be imposed?
No, Your Honor.
Right. It is the order, judgment, decree of the court that you be taken by the sheriff of Wilson County, transported to the authorized receiving agent of the Department of Criminal Justice. You will be confined for a period of 6 years. Your sentence will commence today. It will run concurrently with any other sentences you may be under, and you will receive credit for the time you have spent so far in jail on this charge. All right. You understand, ma'am, that because I have followed the plea bargain agreement in this case, that you have waived the right to appeal and you may not appeal?
Yes.
Okay. I will find that you made your post-trial waivers knowingly, intelligently, and voluntarily, and I will approve them. And I will certify to the Court of Appeals that you've waived the right to appeal and you may not appeal. That concludes this matter.
Thank you. And Cordesia,
Yes.
get in touch with Mr. Hilly on your Gonzalez case. All right.
Okay.
Judge Wilson, there are two folks that have joined here recently. One's a phone number and the other is under Bubba J.
Your Honor?
Yes.
This is Les Kanovich. I got to put in a breakout room with Gilbert Gonzalez, but I need to be put in the breakout room with Gilbert Silva. I need to be put in a room with George Silva. So I don't know if George Silva is on the line or not.
Okay, he is. Ms. Poppy is doing the breakout room, so.
I'll do that right now. Did you also need Anna Locke as well?
Yes.
In the same room?
Yes, please.
Okay.
Thank you.
Miss Poppy, one of those numbers that logged in is our client who got kicked out. So he's back in that waiting room trying to get in that you just referenced.
Yes, everyone that was in the waiting room has been in.
Thank you.
Accepted in.
Judge, at the court's convenience, I'd like to approach on the Rizzo Brown matter.
All right, give me a moment.
Sure.
Okay, I just posted the Vasquez plea package and judgment. Okay, what's going on in the Brown case? Rizzo versus Brown?
Yeah, the alleged attorney, Courtney Hillard, reached out to our office about 5 minutes ago, and my assistant spoke to her, and I'm not sure, confirmed that they have not been retained by Ms. Brown. So we would like to go forward. I feel like this issue is relatively time sensitive and would like the court to let us proceed today.
I'd like a continuance, please, Your Honor.
And we would argue against that, Your Honor. You know, like I said, our motion's been on file. This case has been pending for over 4 months, since June. Ms. Brown's had notice of this hearing for almost a month. And depending on the court's ruling today, it could mean that my client and the minor children she's caring for of the decedent before this court, the case before this court, could be able to have a house to live in. So it is urgent that I would argue to the court, very time sensitive. Plus, Ms. Brown didn't file a response to the motion as required by Rule of 166. So I'd like to send a proposed order, actually, is what I'd like to do.
Let me open up the file.
Sure.
Mr. Hillard had my response, but I'd like to get other counsel. for discovery. I believe Mr. Hillard did speak with the clerk to have this reset.
Okay. Has anyone heard from Mr. Hillard?
I have not, sir.
All right, I'm sorry, I'm gonna have to ask are the files right here? Hold on. I was able to pull something up earlier, but I'm getting an error message.
There was a Hillard that is coming in and out of the room to let in, but before I can let them in, they logged off. Oh, they're there. They're there, sir.
All right, Mr. Hillard?
Good morning. I apologize for being late.
All right, yes, sir. I just, there's been some confusion this morning about whether you've been retained in the Darnell Scott versus Ashley Brown case.
Yes, Judge. I was going to respectfully request that maybe about 2 weeks reset on the matter, if at all possible.
Well,
because I know we don't have an appearance on file.
Have you been retained and are you making an appearance?
Well, not quite. So I did want to appear. I have met multiple times with Ms. Johnson, also goes by Ms. Brown. But I believe an agreement can be worked out by the end of the week.
I would be hesitant, Judge. You know, like I said, I've had my motion on file. If the court grants my motion, it means that my client and the decedent's minor children would get to live in the decedent's home. So there's just, that's the urgency. Otherwise, absent that, you know, my client's not going to have anywhere to go now that her lease is up here in November. The motion's been on file. No response was posted in conformity with Texas Rules of Civil Procedure. I think that procedurally, you know, I should be able to present an order to the court.
Give me a moment.
Sure.
And has there been any response made to the discovery request, the admissions, or?
My apologies. Judge, we eventually got some response after the 30-day requirement, a few documents, but it wasn't responses. It wasn't like answers or objections or anything like that. It was just some documents sent, I think maybe 40, 50 days after or so, the time frame. They were due 30 days. And so they weren't timely, and the documents we did get were just some documents, not necessarily responses, but it seemed to be what Ms. Brown was relying on.
And were the requests for admission served with the petition?
No, the request for admissions, the discovery was served after the fact. The admissions and the production was served after the fact. And so Ms. Brown had, 30 days. She could have retained counsel at that time. I'd like the court to note at any time in the past 4 months, at any time. I mean, technically, she still hasn't even retained counsel. So that's
I've been battling COVID.
Judge, I don't know that Ms. Brown's been battling COVID since June 30th, but.
All right, Ms. Aragon, let me hear from the defendant. Go ahead, Ms.
Sure.
Brown.
Yes, sir. I've been battling COVID since the end of July. So I've had a hard time with being able to retain counsel and get to places to be able to take care of everything that needs to be handled while under quarantine.
And Your Honor, if I may, all we're asking for is even a week at most. Just to have time to prepare, and I do apologize to opposing counsel.
All right, I will grant motions for summary judgment. Ask that be reduced to writing. That is not it'll be a final judgment, but you've got your 30 days to, your time to file a motion for new trial.
Correct.
It's my expectation, based on what I've seen so far in the file, that I would go ahead and order that possession of the property be turned over. And is this property still being paid for? I take it from HUD?
Yes, Judge, HUD paid for it with the Special Needs Trust.
Okay, no, well, I mean, is it paid for?
It was paid off by the Special Needs Trust, so paid off to HUD. So there's no payment on it.
Okay, is it insured?
I believe there's insurance on it, Your Honor. We're trying to kind of figure out what Ms. Brown has done since decedent passed, because when the property was insured, paid off through his Special Needs Trust money, and Ms. Brown has been in there since the passing of decedent. And so we're trying to sort out all the logistics. I am hoping it still is.
Okay, well, if there's any money at all in the trust, you need to make sure you get that insured.
Absolutely, Your Honor. Okay, so can I prepare an order and present it through the chat that you're going to grant the motion and possession of the properties to be turned over to the executor of the estate immediately?
Yes.
Thank you.
Again, I would entertain a motion for new trial, but I would not expect, even if that gets granted on some issue or part of some issue, I would not expect that it would change in order for possession of the property.
Excuse me, I don't know if I can speak. This is Rochelle Rizzo.
Ms. Rizzo, it's okay. She's my client. Ms. Rizzo, I'll be in touch with you shortly.
All right, and I just muted Ms. Pereira, but do you have an announcement on that case?
Yes, Your Honor. We have an agreement I wanted to read into the record.
Okay, let me find that.
I'm going to be on there twice because they're going to be using my computer. My name will be on there twice.
Okay, in the interest of DJ, a child.
Yes.
Both
Yes,
sides-
Your Honor.
Right. Go ahead.
Your Honor, we've come to an agreement on final orders. The parties are going, if I could read that into the record.
Yes, but if you'd start over because we heard we and nothing else.
Okay. The parties have reached an agreement on final orders. This was a suit affecting parent-child relationship. The parties have agreed to be joint managing conservators, with mom having the exclusive right to designate the primary residence, receive child support, and determine where the child gets the education. The other rights will be independent rights. My client will be restricted to the Wilson County and contiguous counties. Child support shall be $550 beginning November 1st. The parties have agreed to every other weekend visitation for Mr. Jimenez beginning this weekend, and starting after school and dropping off of school on Mondays. And they have a holiday schedule in which they're going to recognize Christmas Eve, Christmas Day, Thanksgiving, and New Year's Eve and New Year's Day. And those will be odd even. And the parties have signed an agreement as to that I will incorporate into the order. And that's our agreement, Your Honor.
All right, Mr. Jimenez, you heard what was read in the record by the other attorney. Is that your agreement with in this case?
Yes, sir.
Okay. All right then, Ms. Pereira, how long do you expect you will need to get that typed up?
I could do it in a week or two. I was looking for the schedule. I didn't see you on Wilson County anytime soon. Do you know if your next date?
It's, you'd have to get the coordinator's office on that.
Okay, that's fine.
I mean, we have some flexibility in that it could be a criminal day. Because Mr. Jimenez, let me tell you that what's going to happen is Ms. Barrera is going to get this reduced to a final written judgment for me to sign. If you agree with her that the document she has produced is what your final written judgment is, then if you will just sign off on it, show that you approve it, you don't need to be here whenever we come back, because I'm going to set a date for what's called an entry hearing. And if there's a dispute, if you, Ms. Barrera, can't confer and come to an agreement on what the order is that reduces this agreement to writing, then you'll have to both be back on that date and we'll have a hearing about it. But if you're in agreement that what she has typed up is what you agreed to, if you'll just sign off on it, she will file that electronically and nobody needs to be back in court. And let me go and just pull a date at random. Okay. Okay, actually, all right, Ms. Poppy, what would be a good date?
Sorry, sir, I've been doing all the criminal stuff over here. For what, sir?
Just an entry date for this this case.
In the interest of DJ, a child.
And how far out are you looking? Are you looking for next open setting?
Like a couple weeks, maybe the end of November.
The 24th should be fine, sir. We have not maxed out.
Okay,
yet.
that's fine, Your Honor.
Okay, it's just an entry, all right. If you will just send me a chat message, Ms. Barrera, that has the cause number, the style, and that date, I would appreciate it, and after that, you're released.
Okay, thank you, Judge.
Your Honor, this is Leslie Sakana. I was wondering if I could approach the bench.
Yes, sir.
Yes, Your Honor, we just came out of the Zoom room with Mr. George Silva. We've agreed to a 30-day reset to be able to resolve this. So we'd like to have the first available 30-day civil date on the Wilson County docket.
All right. That doesn't matter which judge, so.
Sir, if it does not matter which judge, the 1st
No.
of December is available.
Yes, doesn't matter which judge. That's fine. So December 1st at 9 o'clock?
Yes, sir. And if you will send me a message in chat with cause number, style, and that date, I would appreciate it. After that, you're released. And Mr. Silva, you need to make sure you're back here on that date too, okay?
Yes, Your Honor.
Thank you.
Thank you, Your Honor. December the 1st, 9 o'clock.
Yes.
Your Honor, this is Mario Moreno for Jose Rios. I spoke with Whitney and coordinated with Ms. Poppy, and I put the information into chat. At this time, may me and my client be excused?
Absolutely. Thank you.
Yes, sir, Your Honor. Thank you. Have a good day.
Okay. All right. And Mr. Bancroft, Ms. Parker, Ms. Zahari, they're all still conferring? Okay. All right. So ready to start on Talamantes?
Yes, Your Honor.
Yes, Your Honor.
All right. Let me see if that document ever.
I think it did. I think it finally
went
did.
through. I mean, but it was taking forever to download it. So let me see if it. Here it is. Open file. This is a photocopy or photos of the pleading.
Yes, Your Honor. That's how my client sent it to me.
All
She
right, give
took
me a
photos
minute.
of each page.
Judge, I have a.
Hold on. Okay, I've got a hard copy here. Let me look at this.
Okay.
Okay. In the interest of the Talamantes children, are both sides ready?
Yes, Your Honor.
Yes, Your Honor.
And what witnesses are you expecting?
I just have my client.
And my client,
client?
Jason Talamantes.
Okay, and who are the clients? Jason Talamantes and
Samantha Sendejo.
The Office of the Attorney General is also present and ready, Your Honor. Sorry.
okay, are you expecting to be involved in this?
There's a possibility maybe I can help out and figure things out. The state does have an interest.
Okay. All right, and let me ask Ms. Fuller, what are you attempting to change?
Your Honor, we're asking that the court order that Mr. Talamantes be supervised with the children, that his holiday possession is limited, that he's ordered to pay child support, and that he's ordered to take a pattern intervention course.
Okay, and Mr. Cedillos?
Your Honor, we're not asking for supervision. My client is willing to take a course. Up until September, early September, there was unsupervised visitation, and it was a 50-50 split between the two by agreement for over a year, at least a year and a half.
Okay, and what has changed to make Ms. Sendejo want to have supervised visitation?
Recently, there was an incident of family violence. It's my understanding that there are charges pending against Mr. Talamantes. My client has obtained a protective order, and Child Protective Services became involved and imposed a safety plan requiring that Mr. Talamantes be supervised. So he has been supervised by one of his parents.
And Your Honor, there was no finding of family violence. It's just a protective order against Ms. Sendejo. But he is allowed to see the children through the protective order. The protective order doesn't protect the children.
And if I may, Your Honor, the protective order was agreed upon, but I would think that the language of the protective order suggests that the findings were actually made, because it does say that the court finds that the necessary elements needed for a protective order to be issued have been agreed to. And the necessary elements are that the family violence has occurred and is likely to occur again. But regardless of that fact, the incident that occurred is the incident. And my client will testify as to what transpired. Based on that, we're asking that the court change the current order and temporary orders. There have been some other things as well that my client will testify to.
All right. And what court are the charges pending in?
They haven't been filed yet.
Are you expecting him to go to county court or district court?
Probably county court, Your Honor.
Okay. All right, let me ask Ms. Sendejo and Mr. Talamantes to raise their right hands. Do each of you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay. And your name, ma'am?
Samantha Lynn Sendejo.
Your name, sir?
Jason Talamantes.
Okay, you can put your hands down. All right, go ahead, Ms. Fuller.
Would you state your name for the record?
Samantha Lynn Sendejo.
Could you tell the court the names and ages of your children with Mr. Talamantes?
Jaylee Talamantes, age 9. Selena Talamantes, age 4.
Ms. Sendejo, Mr. Talamantes' counsel represented to the court that even though you are the primary conservator under the existing order, there had been a period of time when you and Mr. Talamantes were doing a 50-50 possession. Is that correct?
Yes, ma'am.
And how long did that, for how long did you do that?
We did that about roughly a year and a half, from February 2019 until September 2020.
When did you stop doing that?
September 2020.
Could you tell the court the reason why you stopped following the 50-50 possession agreement?
Yes, ma'am. I actually spoke to you, Ms. Fuller, and you explained that the current custody order that we had from the Attorney General's office didn't exactly say we needed to do 50-50. He was actually court ordered standard possession custody.
So it's your testimony that at the time the agreed Attorney General's custody order, as you referred to it, was signed, you were mistaken in understanding that it required you to do a 50-50 possession split.
Correct. Yes, ma'am. I believe that was required.
And once you've learned that it was just a standard possession order, did you start following the standard possession order?
Yes, ma'am, immediately.
Has Mr. Talamantes been supervised by anyone since September of this year during his possession periods?
Yes, ma'am. It was actually the end of August, I believe August 19th, when CPS became involved and required Mr. Talamantes to be under a safety plan.
What are your obligations under the current safety plan?
Mr. Talamantes was required to move into his mother's house and be supervised at all times during the children's visits with him.
Could you tell the court what caused Child Protective Services to become involved?
Yes, ma'am. The day that the incident occurred, do I need to say what happened?
Yes, let's start with the date of the incident.
Okay.
When did the incident occur?
I believe it was August 17th. Mr. Talamantes and I were in my vehicle with my two children. We were coming back from the Meet the Teacher event here in Floresville. And Mr. Talamantes has expressed before that he didn't think face-to-face learning was a good idea for our children. I thought it would be best. And since my court order has said that I can make the educational decisions, I decided to move forward and enrolled my children in face-to-face learning. We went to meet the teacher. Afterwards, on the drive back to his home, he began to express that he still didn't think it was a good idea. He appeared to be upset and then began to bring up our personal relationship that does not involve our children. I just drove straight to his home. Once he got out of my vehicle, he was still arguing with me, still upset, and I motioned. He was outside my vehicle yelling to me, so I motioned to him as like a cuff around my ear, basically like, can't hear you. So that appeared that he began to look angry, and he walked speedily back to my car. At that moment, I was fearful. I drove straight forward. I didn't know what he was going to do, so I drove forward. And at that moment, he punched my back window on my passenger side where my 9-year-old daughter was sitting. And I drove at the end of his property towards his dad's home, made a U-turn to leave his property. At that moment, I stopped in my vehicle because I saw him outside his house firing a firearm to the ground approximately 8 times. At that moment, I did not drive forward. I stayed in my car. Me and my children were very scared. We were screaming. We didn't know what to do. I actually called his dad, who lives on the same property with him, in hopes that his dad would come out and see what was going on and maybe diffuse the situation. Mr. Talamantes was staring at me when firing his arm. He wasn't close, but he was looking at me, taking a few steps.
Ron, I'm going to object to the narrative.
Okay. Well,
Sustain the objection.
Okay. Ms. Sendejo, you said that you called Mr. Talamantes' dad. Did you also call the police?
Yes, ma'am. Once Mr. Talamantes went back into his home, I drove straight off the property, went straight to my house, and called the police.
Did you obtain the protective order following this incident?
Yes, ma'am.
Do you remember when you obtained the protective order?
I know early September, the temporary protective order had me and the children on it. Whenever we went to court, I believe September 20th or 21st, they took the children off and only had me on the protection order.
Okay. And is it a 2-year protective order?
Yes, ma'am, that's correct.
Ms. Sendejo, is this incident the only reason why you're requesting supervised visitations today?
No, ma'am.
Could you tell the court the other reasons or the other reason that you feel compels supervised visitation in this case?
So I do have a few reasons. One reason would be his behavior. I feel that it's has only gotten worse. In the beginning of the year, in I believe around January, he made a trip to Colorado with a few friends and were transporting illegal drugs from Colorado to Texas, and all him and his friends were arrested and charged in another county for that incident.
Ms. Sendejo, how do you know about that?
Mr. Talamantes called me while he was after he got arrested, while he was in jail.
Any other reasons? You've mentioned that there were other reasons besides this.
Yes, ma'am, he is currently with a girlfriend that lives with him who has multiple CPS cases, who has a CPS case currently right now. And I just feel like that's not the best fit.
Sorry?
I'm gonna object to hearsay.
Okay, I'll overrule that objection. You can ask her about her knowledge later, but I'll overrule that objection.
And Ms. Sendejo, you can continue.
Okay, I also have concern of an unusual amount of cash flow entering his home. He did send me a text and called me. He bought a vehicle for $10,000 cash, when my current understanding is he is employed making about $9 an hour, which is unusual for me to understand.
Ms. Sendejo, since you brought up the income issue, you are asking the court to order Mr. Talamantes to pay child support for your two children, correct?
Yes, ma'am, correct.
And your current order does not include an order of child support, is that correct?
That is correct, yes, ma'am.
And as far as you know, you've just testified that Mr. Talamantes makes $9 an hour. Is that your understanding, that it's his current income as well?
That is my current understanding, yes, ma'am.
Do you know where Mr. Talamantes works?
He works at, I'm not the exact title. I know it goes by Mobile Lube Works here in Procedural, Texas.
Mobile what?
Lube Works? I'm not,
Okay.
I'm not sure exactly what it's called, the actual company.
Thank you.
Ms. Sendejo, coming back to the reasons for supervised visitation, you've testified about the potential drug use. Any other behaviors that you've observed personally that made you concerned about your children's safety?
Throughout the 2 years that we have been separated, Mr. Talamantes has became angry with me, has made his way into my home, has taken property that was given to me when we separated. I never reported it because I feel like it would be a bigger issue. I always try to keep the peace. But this last incident, I was fearful. My children appeared to be fearful. I couldn't do any, help at that point. Couldn't help him.
And Mr. Talamantes has been supervised since, like you said, about August of this year by one of his parents. Would you say that those visitations have gone well?
No, ma'am.
What makes you say that?
I've personally seen his mother get upset whenever my daughter is crying to leave me. She cries to leave me and she cries to leave him. She's 4 years old. The way she speaks to her, I don't come and agree with. And
is his mother the one currently supervising the visitation?
Yes, ma'am.
Do you think there is another family member who's better suited to supervise the visits?
I do. Yes, ma'am. I believe his father would be a great fit for a supervisor.
Where does his father reside?
His father lives on the same property as Mr. Talamantes, not completely next door, but he lives on the same property.
And besides the reasons that you've just stated, are there any other reasons why the father would be a better supervisor?
Yes, I believe his father would be more neutral. I believe my children are being coached and being told untrue things, and I feel like his father wouldn't do that to them.
When you say that the children are being coached, is there a recent visit you can describe to the court that would show that your assumption is correct?
Objection, Your Honor. Hearsay.
I'll overrule the objection. It may be hearsay, I don't know. We don't know yet.
Ms. Sendejo, could you describe the the last visit that the children had with Mr. Talamantes, could you tell the court how you found them when you picked them up?
When I found them, my daughter was upset. She was crying. But later that night, they did express that they were involved in adult conversations. They were asking me why we had to go to court. That they also said they were asking me if I wanted daddy's money, that if that's the reason why I wanted them full-time was because I wanted daddy's money. They also, my daughter also asked me if I liked females and if I was gay, because that's what she was told by her grandmother. And they had so many questions about. They also brought up income tax. They asked, what does it mean when daddy gets to file one kid and I get to file one kid?
Okay, hold on. Mr. Cedillos?
It's narrative and it is hearsay.
I'll sustain the narrative objection.
I'll move on, Your Honor. Ms. Sendejo,
And you're muted right now, Ms. Sendejo. Go ahead, Ms. Fuller.
Ms. Sendejo, if you could unmute yourself.
Yes, sorry.
Okay, that's okay. Ms. Sendejo, so if Mr. Talamantes is supervised by his father, are you comfortable with continuing with the standard possession order?
Yes, ma'am.
What about the holiday possession? Are you comfortable with Mr. Talamantes having the children for a week over Thanksgiving or for about 2 weeks during the December break?
I would ask to get that shortened.
Do you know how so? Like how short?
Not exactly, maybe a few days. I believe our current order has let him have them the end of the last day of school until December 26th. If we could just do the week of Christmas, maybe a 1 week at a time. I wouldn't do any more than that.
Okay. Do you know if Mr. Talamantes' dad has agreed to supervise him and the children?
I do not know.
Would you say you have a reasonable relationship with him?
Yes, ma'am.
Ms. Sendejo, you're also asking that Mr. Talamantes be ordered to complete a veteran intervention course. Could you explain why?
Yes, ma'am. I feel like that will help Mr. Talamantes. It's not necessarily an anger issue. I believe it's a personal issue between him and I. I feel like that would help him let go of things and help us move forward.
I'll pass the witness, sir.
Go ahead, Mr. Cedillos.
Ms. Talamantes, can you hear me okay?
Actually, hold on just a moment. Let me interrupt before you start that. Ms. Mazaheri, I believe I saw you back. Did you have any announcement? Mr. Bancroft?
Yes, Your Honor, we do have an announcement for the court.
And it is?
I'm sorry, did you hear me, Your Honor?
Yes, and the announcement.
Yes, Your Honor. With respect to the motion for enforcement, we have agreed to drop that, and we have reached agreements that we would like to read into the record.
Okay, Ms. Mazaheri is not coming back. She stepped away from the desk, it looks like. So we'll try to, between the next witness, we'll try that.
Yes, Judge.
Okay. Go ahead, Mr. Cedillos.
Ms. Sendejo, can you hear me okay?
Yes, sir.
Okay. On page 6 of the order that you signed with the Attorney General's office, isn't it true that you all agreed that it would be 1 week on and 1 week off?
Yes, sir.
Okay, and you signed it and he signed it, is that correct?
Yes.
Okay. So it was not and the 1 week on and 1 week off, it seems that the girls were very happy with that, weren't they?
I'm not sure, sir.
Okay. This past weekend, the girls wanted to stay a little bit longer because you wanted them for the Halloween day, and Mr. Talamantes allowed you to have a couple hours and but the girls didn't want to go. Is that correct?
That's what Mr. Talamantes texted me, that the kids wanted to stay with him and not come with me for the 5 to 7 holiday Halloween. Yes, sir. That is what he said.
Okay. So they seem happy when they're with him. Is that accurate?
Yes.
Okay. As far as the incident where that started the protective order incident, did you run over Mr. Talamantes' foot? Is that why he slammed on the window?
No, sir.
Do you know he ran over his foot?
I did not run over his foot, sir.
Okay. Is there an active CPS case going on?
Yes, sir.
There is. Okay.
Yes, sir.
All right. Ms. Talamantes, do you think you would benefit from you and Jason going to a co-parenting class?
Is that question to me, sir?
Yes. I'm sorry, Ms. Sendejo, you think you and Jason would benefit from going to a co-parenting class?
Sure. Yes, sir.
Okay. And the protective order is only to protect you, is that correct?
Yes, sir.
It's not against the girls.
It was temporarily, sir, until we went to court. Yes, sir.
Okay, but it's not against the girls, is that correct?
Yes.
Okay. All right. And the disagreement about enrolling them in school, Jason was concerned about his daughter, the daughters going to in-person learning during this pandemic. Isn't that correct?
Yes, sir. We had a conversation at my home, and we agreed that both children would go. I had wanted my oldest to go. He said my youngest should go, so we decided both of them would go. A week later, when I text him, "Hey, I enrolled the kids. This is meet the teacher," that's whenever he informed me that he actually did not agree. I was under the assumption we did agree at first.
Okay, your youngest daughter wasn't ready. Also, wasn't is that true? Wasn't she having potty training issues?
No, sir. She was ready. She was 4 years old. She was ready to go to pre-K.
Okay. I'll pass the witness, Your Honor.
Ms. Fuller?
Ms. Sendejo, just to clarify, when you testified that you believed the order was reflected a 50-50 possession agreement, did you continue with the 50-50 once I advised you regarding the standard possession order?
We did not continue. No, ma'am.
I'll pass the witness, Your Honor.
Mr. Cedillo?
Nothing of this witness, Your Honor.
All right. And Mr. Bancroft, Ms. Mazahari, were you ready to read that into the record?
Judge, I'm ready.
All right, go ahead.
Your Honor, Ms. Mazahari and I have conferred this morning. We have agreed to drop the motion for enforcement at this time. With respect to the motion for forensic examination, we have agreed that Sheldon Walpole, Laura Walpole, and Brooklyn Walpole shall all three see Dr. Richard Dist here in San Antonio for the forensic examinations to include an alcohol assessment for Mr. Walpole. Mr. Walpole has agreed to pay the fees for all three parties to be evaluated. We have entered into an agreement for a temporary restraining order with respect to the motion for a protective order that is set to be heard tomorrow morning. And Ms. Walpole has agreed to contact the county attorney's office to have said motion for protective order dismissed. And I think that it concludes our agreement thus far. Ms. Mazahari?
I agree, Judge. Just a point of clarification. We're going to discuss with Dr. Tice whether he wants to call it forensic examination or psychological evaluation, but we'll work on an order to come.
Yes, Judge, that's correct.
Okay, and do you need a entry date?
I don't believe so.
I don't think so, Judge. Ms. Mazahari and I are working very well together. We've had no issues in the past. We should be able to get something logical to the court soon.
Okay, I will put reset on request, order to follow.
Thank you, Judge.
Thank you. May we be?
And just so I'm clear, Ms. Parker is Mazahari is in.
Ms. Parker has passed away.
Oh, well, obviously she's, all right. I'm sorry, I did not know that. I wasn't trying to make light. Okay, I will put order to follow and y'all are excused.
Thank you, Judge.
Okay, your next witness?
I'd like to call Mr. Jason Talamantes.
All right. And Mr. Cedios, if you had a chance to speak to Mr. Talamantes about his Fifth Amendment rights?
No, I haven't, John.
Okay. All right.
I can't hear Mr. Cedios.
Okay. All right, Mr. Talamantes, there's some kind of background noise. It sounds like you've got a microphone that's out in the wind or that you're drumming. What's making racket?
I think it might have been echoing. I had my computer leaning against something.
Okay.
Does that sound better?
It sounded better for a minute. Now it's back.
How's that? I'm sorry. It's my volume.
That's fine. Well, it's better anyway. All right. Mr. Talamantes, I need to tell you that it's my expectation that Ms. Fuller is going to ask you about the incident that was described by Samantha Sendejo. I understand that you've been arrested on that incident. She may also ask you questions about what has been described to me as an incident where you were arrested while driving back from the state of Colorado with what I assume are cannabis-related products. No, sir, I'm talking, you're listening. You have the absolute right under both the United States Constitution and the Texas Constitution to not answer any questions that might tend to incriminate you. You don't have to answer any questions that might tend to show that you've committed a crime. All right. However, you must either waive that right and answer questions, or you must assert that right. And actually, unless you waive the right, you won't have to answer these questions, but you have to either do it one way or the other. You can't answer a few questions that might tend to incriminate you and then decide, well, I don't want to answer any more questions. That's because this is a civil lawsuit. In a criminal lawsuit, you don't have to answer ever any questions about that might tend to incriminate you, and the finder of fact, either the judge or the jury, if you decide not to answer those questions, cannot hold that against you in any way. But because this is a civil case and not a criminal case, if you start answering questions that would tend to incriminate you, you have to continue to answer them. You can't decide in the middle of the trial that you want to assert your Fifth Amendment rights against self-incrimination. And if you decide that you don't want to answer any questions that might tend to incriminate you, the finder of fact, which is me, could hold that as a circumstance against you. Meaning I could decide the reason you don't want to answer questions about that offense or that alleged behavior is because you did commit a crime. And I am going to ask Ms. Poppy to place you in a breakout room with Mr. Cedios so you can discuss with him whether you wish to waive your rights or not. That's your question, but the county attorney is not online, but there are people from the DA's office online, and the county attorney would be able to get a transcript and possibly even a video copy of your testimony if you decide to testify. Ask Ms. Poppy to place Mr. Talamantes and Mr. Cedios in a breakout room.
Yes, sir, I will do that.
And does anyone else have an announcement or anything?
Hey, I have prepared a proposed order on the summary judgment and sent it in the chat. May I be excused, or would you like me to stick around?
No, that's fine. I have not downloaded.
That's fine, Judge. I just didn't know if I needed
I'm about
it.
to download that, but yes, go ahead.
Okay, so if I can be excused, then I'll excuse myself and then just follow up with the clerk for copies of the signed order. So thank you so much for the court's time.
You're welcome.
Have a good one.
And Judge, we're ready on Priscilla Rodriguez. She's in custody. If Mr. Ernst is available, we can start anytime the court's ready.
Okay, well, we've got to finish this up, and then let me ask.
Sure.
Your Honor, we're still going over paperwork with her at the jail.
Okay, all right, well, we'll hold off then. All right, I'm going to work on the plea papers for a minute, looking at them. If people will let me know when Mr. Cedillos comes back, if he doesn't speak up.
Andrew, can you hear me? Andrew Flores?
Yes.
Okay. I have the bill of costs that Priscilla is going to need to sign. If I send that over to the jail, email it to them, can you let whoever's over there know that it's coming?
Yes. I'll call the
Okay.
jail right now.
All right, thank you.
All right, Mr. Cedillos, you're back. You're muted.
Yes, I'm back.
Is your client back?
I don't see him.
He's still in the breakout room, sir. Do you want me to force shut it?
Can you do that with just one, or do you have to shut them all down?
I have to shut them all down, but I have none open right now, and then I can reopen them.
Okay, that's fine. Just do that, please, ma'am.
It'll be 50 seconds or so.
If you want to join.
He's back, sir.
Okay. Mr.
He
Cedillos,
just
did
went
you
back
have?
in the breakout room. Sorry.
Okay.
I'll
That's your
shut them
fault.
all again. sir, he's back in.
All right, Mr. Cedillos, did you have an opportunity to speak with Mr. Talamantes?
Yes, I did, Your Honor.
Okay, and does he wish, go ahead.
Yeah, he'll answer any questions.
Okay. He will not answer questions.
No, he will.
He will. Okay.
He will.
And do you believe he understands his rights and he's making a voluntarily and an intelligent waiver of his right against self-incrimination?
Yes, I do, Your Honor.
All right, go ahead, Ms. Fuller.
Would you state your name for the record?
Jason Talamantes.
Mr. Talamantes, what's your current address?
101 First Street, Floresville, Texas.
Who else is residing there with you?
My mother and her husband.
Do you have another home where you reside?
Yes, ma'am.
And where is that?
That is Business Loop 181 North 236.
When was the last time you resided there?
Last week. Only like on Thursdays and on the weekends I stay over here.
Okay, so you go to your mother's home on Thursdays and on weekends when you have visitations, correct?
Yes, ma'am. Yes, ma'am.
At all other times you reside in your actual home, correct?
I'm actually back and forth quite often. I would say it's about 50-50. Sometimes I come straight from work and I shower over here and I stay here overnight.
Who resides with you in your home? Not your mother's home, your home.
Okay, in the 236 Business Loop, that'd be Katerina Barrera and her daughter, Aria Barrera.
Is it true that there is a currently pending CPS case involving Ms. Barrera's daughter?
No, ma'am, not at all.
Mr. Talamantes, is it true that Child Protective Services became involved with Ms. Barrera's daughter because of the incident that Ms. Sendejo testified to of you discharging the weapon?
Yes, ma'am, for 30 days, but that has been closed for over a month. Mine as well.
Okay. And were you a part, was there a safety plan as far as you know?
Yes, ma'am. There was a 30-day safety plan.
And what did that safety plan require you to do?
Just supervised visitation when I was around my kids. I was able to be around children or anything like that. Is just my own children.
Mr. Talamantes, I think you're misunderstanding what I'm asking. I'm asking you if there was a safety plan involving Ms. Barrera's daughter.
Yes, ma'am.
Okay. And that's a separate safety plan from the safety plan for your children, correct?
No, ma'am. They were all together in one safety plan. And CPS did reach out to me and say that that was an error on their part, that she should have never even been involved in any of the paperwork that Samantha was asking for.
Okay. Mr. Talamantes, was Ms. Barrera's daughter present as you were discharging your weapon on the day of the incident?
She was inside of the house, yes, ma'am. She was inside the residence. I was outside.
Does Ms. Barrera have any other children?
Yes, ma'am.
How many children does she have?
She has 8 altogether.
Where are the 7 children?
The others have other homes that they stay with. I know CPS was involved in some of her previous children. There was cases on them.
Okay. And do you know, has Ms. Barrera explained to you why she had CPS involved with all of her 8 children?
Yes, ma'am.
Okay. Did it cause you any concern?
No, ma'am. All of that was years and years and years ago.
And do you know the reasons why CPS was involved with her children?
No, ma'am.
You never asked her?
I know some details, but I don't know the specifics.
And what are the some details that you know?
It was due to the other parent. And then he was in and out of their life, and he was in a lot of other mischief. At one point, whenever she had custody of her children, I know that he came and barged in the door, and the CPS just said that it wasn't a safe environment. But that was many years ago.
Okay. And it's your understanding that that's the reason why she doesn't have custody of her children, right?
that's one detail that I was told.
And Mr. Talamantes, Ms. Sendejo testified that you informed her of your recent arrest for drug possession. Were you arrested or detained for drug possession?
Yes, ma'am. I was detained, and the car that I was driving.
Mr. Talamantes, let me interrupt you. So you were detained, and when was that?
The date, it was December 1st.
Was it December 1st of last year?
Yes, ma'am. I apologize.
Mr. Talamantes, if the court ordered you to do a hair follicle drug test, would you agree to a hair follicle drug test? Let me put it that way.
If we were both requested to do one, I'm not sure why I would be needed to do one for something that was a year ago, and I have had no other charges. And well, I'll just leave it at that.
Okay, so Mr. Talamantes, would I take it to mean that you would agree to hair follicle test if the court ordered my client to do the same? Is that correct?
Yes, ma'am. Both parties. Yes, ma'am.
Did Child Protective Services drug test you?
No, ma'am. They said that drugs were not the issue. That Samantha had made it.
Objection, non-responsive, Your Honor.
Sustained. Mr. Talamantes, please answer the questions. If Mr. Cedillos thinks that he needs to follow up and get more information out, get an explanation out, he'll ask you questions in a moment.
Yes, sir. Yes, Your Honor.
Mr. Talamantes, did you take your children to a Halloween party this weekend?
Yes, yes, ma'am.
Okay. Where did you go?
We went to family members in San Antonio.
And who else went with you?
It was just me, Katerina, and my two daughters, and then her daughter as well.
And Mr. Talamantes, isn't it true that your mother is supposed to supervise you with your children at all times according to the safety plan?
No, ma'am. That safety plan is no longer in play. That was a 30-day safety plan.
Mr. Talamantes, do you have any paperwork from CPS today showing that you were not required to be supervised this weekend?
Yes, ma'am. If I can have 1 minute, I do have the 30-day protection plan, and it has the dates on it.
Mr. Talamantes, let me move on. I'm not asking you to show the document.
Okay. I apologize. Yes, ma'am, I do.
It's your understanding that the CPS plan is no longer, the safety plan is no longer in place, correct?
Yes, ma'am. I have been in touch with CPS, and they have told me that my case is closed.
Mr. Talamantes, let me ask the next question. Where do you currently work?
It's called Lube Works in Floresville, Texas.
Do you work full time?
Yes, ma'am.
How much do you make per hour if you're salaried?
I believe it's $10.25 an hour.
How long have you been employed there?
Going on 2 years. There was about a month that I didn't work there between out of the 2 years.
Do you have health insurance available to you?
No, ma'am.
So you'd agree with continuing to pay for Medicaid, correct?
Yes, ma'am.
Mr. Talamantes, could you tell me, well, let me ask it this way. Did you discharge your weapon on the day of the incident as Ms. Sendejo described it today?
Not in the way she described it, no, ma'am.
Did you discharge a weapon that day?
On my property, yes, ma'am.
Okay. What kind of weapon was it?
It was a Glock 19, 9mm.
How many times did you discharge it?
I believe it was 6 or 7, and that was all that was in there. I had no more ammunition at that point.
Where were the children at that time?
200 feet away at my dad's property.
Okay. Where was Ms. Sendejo?
200 feet away at my dad's property as well.
Could you see them as you were discharging your weapon?
I could see Samantha.
Okay. Do you think Samantha could see you?
Yes, ma'am.
And I assume it's safe to say that the children were in the car with her, correct?
Yes, ma'am.
I'll pass the witness, Your Honor.
Mr. Cedillos?
Mr. Talamantes, up until early September of this year, you and Samantha had 50-50 visitation with the children.
Yes, sir.
And that was by an agreement which you found on page 6 of that order that is in the judge's hands. Is that correct?
Yes, sir.
Okay. And it's your understanding that everything had been working out fine until September with that 50-50?
Yes, sir.
Okay. Have you ever heard Samantha complain of the way the visits were going?
No, sir, never. As a matter of fact, she would call me if she needed anything. I would give her money to take the kids out to see movies. If she needed anything, I was there. I was available.
How about babysitting?
Yes, sir. Babysitting would be my mother. She would always drop the kids out to my mom if she needed anything. On once or twice, I would say she had a boyfriend drop off the kids here, and she would take off with boyfriend. And there was never an issue. I mean, of course I wasn't happy with it, but I would never say anything about my kids being dropped off at the babysitter, as long as it's my mother.
And this last weekend, were the kids happy? Were your daughters happy with you this during the Halloween weekend?
Yes, they said they had a blast, and they were given toys as well as candy, and those were their new favorite toys.
Hold on, slow down, sir. Your voice started to break up. Ms. Cavazos, were you able to hear that?
No, he was choppy.
All right, please start over with that answer.
Yes, they had a great time with me the holiday, I apologize, this Halloween weekend. They were given toys as well as candies, and those were their new favorite toys. They had a great time.
And this past weekend, Samantha was going to take him for a couple of hours by an agreement you all had reached that the attorneys had worked out. Is that correct?
Yes, sir.
And what happened with that agreement?
My oldest daughter, Jaylee, she right away she expressed that she didn't want to go.
Objection to speak your say, Your Honor.
I wanted to make it.
Sir, whenever there's an objection, you need to let the attorneys and the judge talk.
Sorry, yes, sir. Yes, Your Honor.
Response to the objection?
Your Honor, it's what was his observations of the children.
Overrule the objection.
Go ahead and answer. Were they? How were they? How was your oldest daughter?
She wanted to stay with me. I tried to make it fun for her and tell her that she was going to see her other cousins, and she responded that some of them were rude to her and she would rather stay with me, and that she knew she was going to see her mom on Sunday.
Okay. You notified Ms. Talamantes, is that correct?
Yes, I notified Ms. Sendejo. Yes, ma'am. Yes, sir.
I'm sorry, Ms. Sendejo. And
Yes.
She was okay with you not taking your daughters over for the 2-hour party, Halloween party. Is that correct?
Yes, sir. I even told her if she would like to speak with them, that would be fine. I would love to exchange the pictures of the costumes, and we did so. We did not speak on the phone, but we did exchange pictures of the costumes.
Okay. Let me move on to the CPS plan. It's your understanding that there's only a 30-day safety plan. Is that correct?
Yes, sir. There was, and they reached out to me and let me know that was closed. And there's no longer.
Mr. Talamantes, you're breaking up, and there was an objection.
I apologize.
Okay. I heard the answer was yes. It was your understanding there's a 30-day safety plan?
There was, yes, sir.
Okay, and I'll sustain the objection to anything after that as far as what CPS told him later.
Jason, on the incident where your weapon was discharged, was your tell us briefly about it?
Was there a what? I'm sorry.
The incident where the weapon was discharged. Tell the court briefly about it.
Yes, sir. Like Miss Samantha said, we went to the school and we met with the teacher, and I had told her, I said, if we're gonna argue or anything like that, maybe it's better if you just go alone. And she informed me that she would much rather, if I had any questions, I can ask the teacher and get it straight from them, as opposed to just being told what they told her. So I agreed to go. We went, so the teacher we met with did say that in no way is it good to enroll anyone in pre-K. Definitely wait as long as you can, because
Objection, that's the hearsay, Your Honor.
Sustained.
I'm sorry, what was the objection about?
Hearsay.
Okay. So there was a disagreement about enrolling your youngest one, or both of them live? I mean,
yes,
for
yes, sir.
In person.
And the teacher said it's not a good idea for the youngest.
Okay. Jason, was your youngest potty trained at that time when she was enrolled in school?
She knew how to use the toilet, but she did not know how to pull down her own underwear, or she didn't like to flush it herself as well. And wiping was also a problem. So I would say no.
So you had an issue with that as far as the in-person school?
I reached out to the teacher via email, and she did say that she knew something was up, but she was not made aware of her potty training issue.
Was that the only disagreement? Was that the cause of this incident? This disagreement with your daughters?
Yes, that was the only thing we really disagreed on so far was school. And I agree that school is good for them, a learning good environment where they can make friends. But as of right now, I do not feel like it's safe.
So Jason, have you ever lost your temper before with Miss Sendejo and with your daughters being around?
No, sir.
Okay. Do you think you need a battering intervention class?
No, sir.
Do you think you and Ms. Sendejo would benefit from a co-parenting class?
No, I don't know. That's tough to say. I'm sure that there could be some benefits.
Okay, Jason, you testified earlier that you're willing to take a hair follicle exam if Ms. Sendejo is willing to take one too.
If need be, yes, sir.
Okay. You don't earn any kind of overtime at Lube Works, do you?
No, sir. As a matter of fact, whenever we were doing the 50-50, when I would have my kids on my week, I would even get out at 4 on weekdays, and I would be with them until 7 o'clock because 7:30 was their bedtime.
Would you like to continue the 50-50?
Yes, sir. That would be a dream come true for me and my kids.
Okay. If this judge should rule that it's not 50-50, would you like to talk? Would you like to have expanded visitation with your daughters? And I explained expanded visitation. Would you like that in the alternative?
Yes, sir.
Okay. Do you think you need to be supervised? Have you ever lost your patience with your daughters?
No, I definitely have never lost my patience with my daughter. If anything, I will literally tell them, hold on 1 second, let me think how to explain this to you. I'll walk away. I'll think of how I can make them understand what's going on. But no, sir, I never lose my temper. And as far as for discipline, I'll make them stand in the corner until they're ready to apologize. Not 5 minutes, not 10 minutes, just till they're ready to apologize.
Okay, you feel pretty strongly about taking care of your daughters, is that correct?
Yes, sir.
I mean, you used to get off from work early?
Yes, sir. They already knew that 1 week I would work as long as I can. I would stay late. And then the following week I had my children. So I would leave at 4 o'clock every day. And even at that, they would get off the bus at 3 and my mom would be there by 3:30 at my job with my kids just so they could say hi.
Okay.
Sometimes they would wait there till 4 and I would join them and we would take off home.
And this past weekend, your daughters, and every other weekend when you've had them since September, your daughter have been happy with you.
I'm sorry? They've been happy?
Your daughters have been happy with you the past weekends that you've had them.
Oh, yes, sir. Yes, sir. They have a blast with me. My youngest, she says, Dad, do you know that every morning you wake us up singing a song? We just have a blast.
You heard Ms. Sendejo's testimony about the girls crying, being around you. Is that accurate?
They cry whenever it's time to part with me, and they also cry when it's time to part with mother as well. All of this is so new. Whenever we were doing 50-50, there was no tears. Everyone knew what was expected of them. Everyone knew mom's week's coming, dad's week's coming. Everybody knew the rotation.
Okay. You have no other children, is that correct?
Yes, sir. No other children.
Okay. I'll pass the witness, Your Honor.
Go ahead, Ms. Fuller.
Mr. Talamantes, do you understand that your current order does not order a 50-50 possession? It orders a standard possession order.
I was not made aware of that until she went ahead and decided that's what she wanted. It was my understanding that it was 50-50 and that was ordered by, I had never noticed that she was able to keep them from me.
Okay, Mr. Talamantes, but you agree with me that the order actually orders that you have standard possession, correct?
Today, yes, ma'am. I could say I do know that. Yes, ma'am.
So let me go back to the incident that you attempted to describe to the court. So from what I understand, you told the court is that you and Ms. Sendejo had an argument regarding the children's education. And you got so angry that you chose to run inside, get your weapon, and discharge your weapon 6 to 7 times as a reaction to your anger over Sendejo's decision, correct?
No, ma'am. I actually had it on my waist the entire time we were arguing, and I didn't even think of it. I knew it was there on my hip, but I was never intended on using it until my foot got ran over and the car was 200 feet away facing me, ready to run me over again.
Okay. Mr. Talamantes, did you have any injuries?
Yes, my foot was very hard to walk on. It had
let me interrupt you. Did you report the injuries to the police?
Yes, ma'am. They took photographs and they also made a police report as me being the victim and her being the aggressor. She has no such police report.
Hey, Mr. Talamantes, do you have a copy of the police report for the court to see today? I'm not asking you to show it to me. I'm just asking you if you have it.
Yes, ma'am. There is one. Yes, I have it somewhere in my files.
Mr. Talamantes, so it's your testimony that my client allegedly ran over your foot with her car, and that's why you started shooting your weapon, correct?
Yes, ma'am. I made a police report as well and pressed charges.
So you started discharging your weapon, why?
To keep her away from me. I didn't want her to drive towards me again because I really did feel like she was intent on running me over that day.
Okay. And where were you located when she allegedly ran over your foot?
About 10 feet from my house. She left skid marks all the way down my driveway.
Okay. So instead of going back into your house, you chose to stay out and start discharging your weapon, correct?
I had made my way up my steps, and then like she said, she did this motion and called me over. So I did approach her vehicle. Once I got about to where the blinker is, that's when she punched on the gas and ran over my foot. And I never made contact with the back window ever.
Mr. Talamantes, that's not what I'm asking you. I'm asking you if you chose to discharge your weapon instead of going back into the house after she allegedly had run over your foot.
From where I was after I got ran over, that is where I jumped to my feet, pulled out my firearm. It came straight out and pointed straight down. I never pointed it at anyone or up in the air. It went straight up, straight down. I fired my shots so that she would not come towards me again. And then I went inside kind of simultaneously. As I was shooting the ground, I was backing up towards my house.
Okay. And Mr. Talamantes, you knew that your children were in the car, correct?
Yes, ma'am. That is why I did every shot towards the ground. Other than that, in the state of Texas, that's considered a deadly weapon, a car.
I'll pass the witness room.
Mr. Talamantes,
Yes.
your property, is that dirt, caliche?
It's, I would say dirt. It's dirt, yes, sir.
Okay, I'll pass the witness on.
Ms. Fuller?
Nothing further.
All right, and Mr. Calvano, I guess I have been leaving you out. Do you have any questions to this witness?
No, Your Honor, I believe counsels have covered all the information I need.
Okay, all right, your next witness or anything else?
We rest, Your Honor.
Mr. Cedillos?
Just a few more questions on the medical support. Mr. Talamantes, you're not earning $3,100 a month, are you?
No, sir.
Okay. If I represent to you what the Attorney General's office told me, when they established your medical support at $73 a month, was it 73, Corey?
It's established at $74, correct?
$74 a month. That was based on what you were earning working for another company. Is that correct?
That would be, to my understanding, yes, sir. That would be the only way that figure came from.
Okay, you're not earning that much anymore.
No, sir. I've not in a long time.
Okay, I'll pass the witness.
Nothing further, Your Honor.
Nothing further.
Anything other than argument? Anything else other than any more testimony from either side?
No, Your Honor.
All right, Ms. Fuller.
Your Honor, like I've indicated to the court in the beginning, we're asking that the court modify in temporary orders the current order requiring that Mr. Talamantes be continued to be supervised by a family member, by his dad, if possible, and that his holiday possession is limited, and the child support is ordered based on the child support guidelines. Mr. Talamantes has testified that he makes $10.25 an hour and works full time. We would like Mr. Talamantes to take a pattern intervention course. It troubles me that he takes what's happened very lightly and doesn't understand the impact this incident had on the children. Not just this particular incident, but his life choices since the order was rendered about almost 2 years ago. And my client is right to be concerned, not just because of what happened in August, but also because what's been happening since the order was rendered. Thank you.
Mr. Cedillos?
Well, up until 6 weeks ago,
I'm sorry, I can't hear you.
Okay. Your Honor, up until 6 weeks ago, this couple were raising the children 50-50. It was only this one incident, disagreement about the children's education during this pandemic that raised an issue. The children have been fined. What was that? The children have been fined. He was under a 30-day safety plan. He's not under any kind of safety plan now. We're asking for unsupervised visits, Your Honor. If the court doesn't see fit to order a 50-50 split as they did by agreement, then at least we'd like unsupervised expanded visitation with his daughters, Your Honor. That's these girls are happy with their dad, and we'd also ask that the court order a co-parenting class.
Right. Anything else from anyone?
If I may, Your Honor?
Yes.
The state's position is that on the prior order, the gross income that was determined was found to be $1,646. That was per month. The current income based on $10.25 an hour would be $1,776 as a gross income. The state previously had a finding and the court ordered medical support reimbursement at $74 a month. The state is okay with that medical support remaining at $74 per month for reimbursement. And the state would also offer any assistance if the court wants to make any kind of findings in child support. I would be happy to help.
Okay, anything from the parties, for the attorneys for the parties on child support? Additional?
No, Your Honor.
Okay. Mr. Cedillos, I agree with you. There's a whole bunch of things that in the record that show that Mr. Talamantes has been an involved and good parent. And you said there's just this one incident, you know, but then there's the old joke about, other than that, Mrs. Lincoln, how was the play? A firearm is not, it's not funny, Mr. Talamantes. I know I made the joke, but it's not funny. A firearm is not an exclamation point that you put to a conversation you're having in order to make a point. It's a deadly weapon, and it's designed to kill and to maim people. And I own firearms, and there's uses for firearms, but this is not one of them. And to use a firearm in that manner is unacceptable. Whether it's criminal or not is for some other court and some other day to decide. It's absolutely unacceptable to do something like that in front of children. So I will modify the present plan to order supervised visitation by one of Mr. Talamantes' parents. It has to be supervised by one of his parents. I am not going to reduce it right now, but it will have to be supervised by one of his parents. And if they're not able to take the full share of the holiday visitation and supervise it, then it will have to be reduced because of that. I will order that Mr. Talamantes needs to complete a batterer's intervention program, which hopefully will give him some insight into how he can make a point on something he feels strongly about without resorting to a firearm. I will order a co-parenting course, and I will chastise both parties for talking about my children, my daughter. If you're talking to the school, yeah, it's your child. But when you're dealing with each other, there ought to be some R's mixed in there because you're both parents. Is the petitioner objecting to a hair follicle test for herself?
Your Honor, my only issue would be the cost. My client has an affidavit of indigency on file with the court, and I understand that hair follicle tests are pretty expensive. Besides, there's been no testimony to indicate that my client, that there is any suspicion that my client has ever used drugs or been arrested for any drug-related offense.
Okay. I will order Mr. Talamantes to take a hair follicle test within 3 business days from today. I guess that means we'll just make that by the end of the day on Friday. And that report needs to be turned over to, both the attorneys. And I will also give him 2 weeks to turn over to Mr. Cedillos to give to Ms. Samantha Sendejo a money order, whatever the cost of the hair follicle test is for Mr. Talamantes. He will turn over a money order or cashier's check payable to the lab, a local lab, for the full price. Mr. Cedillos, let Ms. Fuller know that, and I will give Ms. Sendejo 5 days to pick that money order up and go and take the hair follicle test. I don't know if there's a lot of reason to do that, but I don't know if there's not. And again, if that happens, the results have to be made available or made to both attorneys. And I will order child support and reimbursement for medical expenses be set at the level requested by the Attorney General's office. All right, what else do we need to look at on this case?
I think that is all, Your Honor.
That is all, Your Honor.
How long do we need for an entry date?
I can prepare the order today. We can set it if you'd like, just in case.
Okay. All right, how about the 10th?
November, that's fine.
November 10th?
Fine, Your Honor.
It says no more settings, but I expect that won't be an issue, so
Okay.
we will add this on for November 10th. For an entry, if you've got it resolved before then, no one needs to be here.
I have a question, if I may, Your Honor.
No, sir, you need to direct your questions to your attorney.
I apologize.
Room with him. If you need a breakout room with your attorney, then Mr. Cedillo, you need a breakout room with your client.
I can call him, Your Honor. We can talk.
Okay, I will be on for a while. Okay, so I'm gonna put, what was that, the 10th? 11/10 entry. Okay, and my computer is locking up. That's not correct. It does something to where all of the documents I try and download that are sent to me in Zoom are not available to me. I can't actually open any of them. The only thing I can do is reboot my computer. So we're going to be in a recess, let's call it until 12:15, to give me an opportunity to reboot my computer. And hopefully by then I'll be able to dispose of things because I'll have access. All the documents I've been sent, I can't open. So I'm going to go ahead and leave the meeting. Ms. Poppy is still the host.
And Mr. Cedillo and Ms. Fuller, I'll email you information from the Attorney General's office concerning medical support and child support.
Okay, thank you.
Ms. Fuller?
Yes.
Ms. Fuller, can you call me or my line? I don't know if your lines are direct at your office.
I can call you. I have, or I can give you my cell number, whichever way you'd like to do that.
You don't want to give out your cell on Zoom.
I'm not as concerned as you are, but yeah, I mean, I guess I can email it to you if you'd like.
Just call me. I just have a quick question. It's something about the one of the children's birthday this Wednesday.
Right. Okay. So just the office number then, right?
Yeah, just the office.
Okay.
Yeah,
I'll do that.
I'll be here.
Let me mute myself. Thanks.
Ms. Sawyers?
Yes, sir.
I received, I have my computer rebooted, but all the documents that I downloaded that I were corrupt and I could not open them, even after I rebooted, I still can't open them. I don't know if you were copied on two Microsoft Word documents. One says Bird v. Sparkle, and the other just has order denied motion to transfer venue.
No, I did not receive those. Paula, possibly they were civil cases.
Yes, they were civil cases.
Okay, Paula,
They were
you
from
hear
Mark
me?
Taylor. If you look at, it was at 10/19/8. He may have sent them just to me.
I don't show them in the chat to everyone, and I did not
Okay.
receive an email.
Okay, and I also received a PDF chat from, I think this went to everyone, from Marissa Aragorn at 11:09 a.m. on the estate of Scott.
Yes, sir, there is an order in chat to everyone from Marissa Aragon.
Okay. Would you download that and email it to me? Because what seems to, sometimes I can go back and reopen them after I reboot the computer, but they get corrupted when I download files, and I think it's my computer.
Okay. I will download that one and email it your way.
Okay, and if we could get Priscilla Rodriguez to, is she in custody? Not in custody?
Yes, sir, I have her. I'll get her.
Okay. All right, and Mr. Flores, do you have announcements on your clients?
I'm sorry, Judge, you broke up on me. Were you talking to me?
Yes, do you have announcements on your clients?
Yes, Judge, on Mr. Nelson, that's a trial for sure, Judge. And on Mr. Brown, that's a trial. And the last time I talked to Ms. Perel, she also wanted a trial. That's a state jail, Judge. I'm guessing somewhere down the line we'll be able to work that out, though.
All right, well, do you need to confer with the state on any of these?
I've already conferred over this past year on Brown and Nelson, but I probably need to talk to somebody on Perel because I'm not sure I have an offer on that.
Okay, well, Miss Poppy is doing the breakout rooms, and she is the host right now.
Who would you like to speak with? Mark or Lorena?
I'm not sure who has the case. Either one is fine with me.
Jennifer, I'll speak with them. I believe Mark's getting ready to do a plea.
Okay, 1 second.
Judge, when I try to download that one that's in chat from Aragon, it's telling me that it cannot be opened because it is corrupt or damaged.
Okay, so I guess Zoom is damaging them because I can't imagine that, you know,
well, it could have been her
ones that
PDF program.
What's that?
It could have been her PDF program that did
Absolutely, but the Mark Taylor sent me two Word documents that are both corrupt, and I had this a couple of times last week.
Oh no!
I had corrupt documents the last week or 10 days on Zoom. That probably I've had in the last 5 years. So Zoom is in there somehow in the fault. All right, we'll just have to go and contact the attorneys and say resend everything.
Okay, Paula, on the Taylor, Aragon and Taylor attorneys.
All right, so are we ready in Priscilla Marie Rodriguez?
Yes, Your Honor, defense is ready.
It's ready, Judge.
Okay, are you Priscilla Marie Rodriguez?
Yes, sir.
Is that your true and correct name?
Excuse me?
Is that your true and correct name?
Yes.
Ms. Rodriguez, are you, pardon me, are you able to speak, read, and write the English language?
Yes, sir.
And are you a United States citizen?
Yes, sir.
Okay, despite your representation that you are a United States citizen, I need to caution you that if that is not true, any plea of guilty by you or finding of guilt by me could result in your deportation or exclusion from this country and or a denial of naturalization benefits. Do you still wish to enter a plea today?
I mean, what was that? I'm sorry.
Okay. I have there's certain warnings. They're called admonitions I have to give you. One of them, I have to ask you if you're a United States citizen. And if the answer is no, then I will tell you what the consequences might be. And if your answer is yes, you are a United States citizen, then I still have to tell you what the consequences could be if you're not a United States citizen. So
Oh, no, I'm a United States citizen.
okay, but I have to tell you, if you're not a United States citizen, you could be denied the right to enter this country. You could be denied the right to remain in this country, and you could be denied the right to become a citizen of this country. So do you still wish to enter a plea today, knowing all that?
Yes.
Okay. Do you have any history of mental health problems or mental illness?
Yes, sir.
What sort of problems?
I have PTSD, insomnia, ADHD, major depression, major bipolar.
All right. Have those issues kept you from being able to speak with your attorney, Mr. Ernst?
No, sir.
Have you been able to understand what he's told you about what your rights are and what your options are?
Yes, sir.
And have you been able to make him understand what it is you want to do?
Yes, sir.
Okay. All right. Counsel, do you believe your client is competent to stand trial?
Yes, Your Honor.
All right. Ms. Rodriguez, you stand charged by indictment with the state jail felony offense of possession of a controlled substance, methamphetamine, in an amount of less than 1 gram. That's alleged to have been committed on or about May the 2nd, 2019, here in Wilson County. That alleges a state jail felony, which is punishable by confinement for not less than 180 days and not more than 2 years, and by a fine not to exceed $10,000. So do you understand what you're charged with and what the range of punishment is?
Yes, sir.
You understand that the plea bargain agreement you have with the state is not binding on me. I do not have to follow it, but if I decide I'm not going to follow it, I will let you take your plea back.
Yes, sir.
If I do follow the plea bargain agreement that you have worked out with the state, and the sentence I impose is not harder on you than what you've agreed to, you understand you will not be able to appeal this matter.
Yes, sir.
I want to show you some documents that appear to have your signature, titled Admonitions to the Defendant for Plea to the Court. Let me ask, at paragraph 2.11, is that your signature?
Yes, sir.
And at verification?
Yes, sir.
Do you swear or affirm that everything above where it says verification is true and correct?
Yes, sir.
And did you also sign at the certification of appeal?
Yes, sir.
Agreed punishment recommendations?
Yes, sir.
Waiver of preservation of evidence?
Yes, sir.
And the discovery compliance.
Yes, sir.
Right. Did you read these documents yourself before you signed them, or did Mr. Ernst read them to you?
I read them.
And did you understand them before you signed?
Yes, sir.
Okay. And are you satisfied with the work that Mr. Ernst has done for you?
Yes, sir.
All right, counsel, do you believe your client understands the nature of the rights she's giving up, the stipulations of evidence she's making, and the consequences of her plea bargain?
Yes, Your Honor, she does.
All right, now I'll find that you made your waivers of right and your stipulations of evidence knowingly, intelligently, and voluntarily, and I will approve them. And do you also believe, sir, you've received all the discovery you're entitled to?
Yes, Your Honor.
And I will accept the discovery compliance certificate. And I'll ask you, to the offense alleged in the indictment, state jail felony possession of a controlled substance, do you plead guilty or not guilty?
No contest.
And you understand, ma'am, that a plea of no contest might be different than a plea of guilty if you were to get into a civil lawsuit over what your behavior was on the day in question. But that for all purposes inside this criminal case, pleading no contest is the same as pleading guilty?
Yes, sir.
Okay. Has anyone promised you anything other than your plea bargain with the state to get you to plead no contest?
No, sir.
Has anyone harmed or threatened you or anyone close to you for your plea?
No, sir.
Has anyone promised you an early release from your sentence?
No, sir.
Okay, I'll find that you made your plea voluntarily and you're not under any compulsion in making it, and I'll accept it. That's what evidence the state has.
We offer states one of its attachments, Your Honor.
No objections.
Without objection, State's Exhibit 1 and its attachments are admitted into evidence. Do both sides rest and close at this stage?
Rest and close, Judge.
Defense rest and close.
Okay. I will find, I've previously reviewed these, and I'll find there is enough evidence to substantiate the defendant's guilt. Are both sides ready for sentencing?
State's ready, Judge.
Defense is ready, and there's a waiver of the PSI.
Okay. All right. What is the plea bargain agreement in this case?
Your Honor, 2 years state jail, probated for 3 years, a $500 fine, court costs of $290, Crime Stoppers fee of $50, 200 hours of community service at 16 hours per month, drug offender education program, standard drug offender conditions, drug test fee of $50, education, drug, and alcohol evaluation, follow all recommendations, monthly probation fee of $60, PSI fee of $25, restitution of $180, and a police officer fee of $5.
All right, ma'am, you heard what was read into the record by the state's attorney. Is that your agreement with the state?
Yes, sir.
Did the state's attorney add anything or leave anything out?
No, sir.
All right. Let me ask, do you have any dependents that you're responsible for?
Yes, I have kids.
How many?
I have 2.
Okay, and do they reside with you?
Yes, they do.
Okay, and does their father reside with you, or do you receive child support?
No, I get disability.
Okay. And do you have a previous criminal history?
Previous criminal history, just whatever I got time served for in Robertson County.
Okay, well, I don't know what that is.
Possession for less than a gram.
Okay. And were you convicted on that case?
No, I got time served now.
Okay.
Yes, Your Honor, she was convicted.
Okay. All right, anything else from either side?
Nothing from the defense.
Okay. All right, ma'am, I will follow the plea bargain agreement in this case. I'll find you guilty of a state jail felony, possession of a controlled substance. I will sentence you to 2 years in confinement, but I will probate that for 3 years. I will reduce the fine to no fine at all, which will change what your monthly payment will have to be. I want to talk to you a little bit about your probation. Do you reside here in Wilson County?
No, I stay in Bear County.
Okay. In all likelihood, your case is going to be supervised out of Bear County, but you will have a Wilson County probation officer. You understand that on probation, if you follow the rules, do everything you're supposed to do at the end of the time, your period of probation, or possibly sooner, if you complete everything sooner, the case against you will be dismissed. You'll have a conviction, but you'll never have to go and do the time in prison or in the state jail facility.
Okay.
State alleges that you're breaking the rules, then you could be arrested and brought back to court, and it would be a hearing on just that. Are you breaking the rules? And if the answer is yes, then the underlying sentence of no fine, but up to 2 years confinement could be imposed on you, and you could have to serve that. If absolutely the only thing you're not doing that you're supposed to be doing is you're not making 100% of your payments on time, you're not going to be adjudicated, being brought back and have your probation revoked just for that. We will give you an opportunity, if necessary, to make larger payments towards the end of the time you're on probation. You may be able to do community service hours additionally to reduce some of your payments, maybe. And if necessary, we would even be able to extend you a period of time to give you additional time to make these payments. So I want to make sure that if a month rolls around that you just cannot make the payment, that you don't fail to see your probation officer just because you don't want to go and tell them that you don't have the money, okay?
Okay.
All right, so you understand that because I have followed the plea bargain agreement in this case, that you have waived the right to appeal and you may not appeal?
Yes, sir.
Okay. All right, then I will certify, find you made your post-trial waivers knowingly, intelligently, and voluntarily, and I will approve them. And I will certify to the Court of Appeals that you've waived the right to appeal as part of a plea bargain, and you may not appeal. And let me ask, the underlying fine was 500 or 1,500?
500.
All right. Okay, because we were going to have to do this anyway. On the judgment I have, it has a fine of 1,550. So let me see if I can edit this. Okay.
Your Honor, the front page should show $1,550. The fine is $1,500, but Crime Stoppers also gets totaled with that on the front page. So it should be $1,550.
Cindy, the fine is 500.
Oh, 500, not, I'm sorry, not 1,500. I missed that. I'm sorry. So
Okay.
550. Okay.
All right. Give me just a moment. I believe that was emailed to me. Okay, so let me make that change. So we need to have $50 in there for the amount of the fine, even if it's zero, because of Crime
Stoppers. Yes, sir.
Fine. Okay. All right. Just a moment. Do we have any other pleas we're going to have, you think?
And Judge, I just have an announcement on Eric Doyle. That was a pretrial diversion. I just want to confirm with probation that he showed up at the probation office.
We did complete all the paperwork with him.
Okay, and Judge, that's on page 7, the second from the bottom. And that's
Okay,
my last.
okay. Oh, if that's all you have, you're excused. I'll go over the docket brief.
Okay, thank you. Thank you, Judge.
Still trying to finish up this judgment. Okay, I'm going to post the plea packet and the judgment right now. Okay. Okay, what next?
I guess you're done. You can go.
Sorry?
Am I done already, sir?
Yes, we need a thumbprint at some point, but.
I'll make sure and get it, Your Honor.
Thank you.
Yes, Ms. Poppy?
Did someone say my name?
I did because your box lit up. I thought you were talking.
No, I think we're ready to go over the criminal docket, and then I believe the only thing you had left was the Peeler case.
Oh, just that. Give me just a moment. A little better. Someone turned on the lights right over my head, so turn them back off. It doesn't glow quite as much. Claudia Vasquez, final judgment. Caleb Guerra, what happened?
It has a reset date of 1/4, Your Honor.
1/4. Okay. Adams 12/7, and Andy Cedillos is the attorney.
That is correct, Your Honor.
Did Moses Medina ever show up?
I never saw him, Your Honor, so I believe that's going to be a nice side.
Okay. Robert Adams again, 12-7. Arwen Mitchell appeared. She got a date.
You got a date of 1/4, Your Honor.
All right, Mr. Flores, Jesse Nelson.
Judge, I'm going to remain on docket and take the 1/4 date. And just so you know, Mitchell and Nelson are co-defendants.
Okay. All right, so is that an available date?
Yes, sir.
Okay, just I'm sure it wasn't 4 or something. All right, 1/4, again, Mr. Flores, if you will send me that in chat, cause number, name, date, I'd appreciate it.
Yes, Judge.
Jesus Lopez, A. Lopez came in late, was it Jesus?
It was, Your Honor, and he was also a 1/4 date.
Okay. Jose Mendoza.
Is a 1/4 date as well.
Marshall.
I do not have anything on Mr. Marshall.
1/4.
Max Marroquin Jr.
I show that he never appeared.
That's what I have. David Jones.
He has a 1/4 date, Your Honor.
Javier Lara.
I have a 1/4 date, Your Honor.
Henry Brown. Mr. Flores.
That's staying as a 1/4 date, Judge, as well.
I mean, it's staying or being set?
That's being said as a 1/4, I'm sorry.
Okay, if you will send me that in chat. Doug Coronado.
Was a 1/4 date, Your Honor.
Rios, did he appear?
He did appear, Your Honor, and I have it reset for 12/9.
Okay. Allen.
A 1/4 date, Your Honor.
Lozano.
I have 1/4, Your Honor.
Sanchez.
I did not. They may have. I don't have a date.
1/4.
Yes, sir, 1/4. The whole page, actually.
Okay, is that Lynn's date or mine?
Let me check.
That's okay, it didn't matter. It's
It
one or
is
the
your
other.
date.
Oh, wonderful. David Mora, everybody's 1/4. How about Noel? No, did he show up?
He did show up, Your Honor.
Okay. I try not to keep up with these as we go along anymore, so it speeds the docket up. Shower, open warrants, Silva.
Your Honor, on these two cases, he does not have warrants. His warrants are on 20-05-126. So both
okay.
of these would be nice eyes today.
Thank you. Excellent. Nick Silva.
At 12/7, Your Honor, and that is going to be for all of his cases, including the Karnes County case.
Okay.
And that is with Judge Ellison.
Excellent. Tommy Ard.
A 1/4, Your Honor.
Cody Baker. No show? He show up?
I have him as a no-show as well.
And Shaina Peril.
Have as a no-show as well.
No show, Judge, that's what they told me.
Julio Salazar.
I have as a no-show.
Simlinger.
Is 1/4, Your Honor.
Solis.
12/7.
Alvarez,
A 1-4.
Avila,
I have as a no-show.
Geckler,
Your Honor, he is doing a pretrial diversion. He's doing an 18-month pretrial diversion. I do not know if he has talked to probation yet, though.
He did.
okay. Gonzalez, 11 Ford for a plea.
That is correct, Your Honor.
Trinidad Marquine, did he appear?
I have him as a no-show.
Christopher Ward,
I did not get anything on Mr. Ward.
all right, let me.
Jennifer, do you have anything
I
on that
believe
one?
we did reset that one. Let me look back through the,
It wasn't in
Chat
the
here.
chat to everyone.
Yeah, I'm not finding him on the chat.
I can look it up and report to y'all at the very end here.
Okay, hold on. 12-9.
Okay.
Kelly was the attorney who appeared. And it says Chris Ward, 12-9-21. No, 12-9-21. Well, we're not doing 12-9-21, unless that was a pretrial diversion.
It is not, Your Honor.
Okay, so 12-9. Is that a date for us here?
I believe it is, Your Honor.
Yes.
Okay, excellent. And for some reason, Acrobat just changes the size of whenever I type notes. It goes up and down. This went back down. All right, all the rest of them had what, 12-4 on this page?
Your Honor, I have
Go ahead.
11-24 for arraignment, but
Okay.
Mr. Eric Doyle, I believe, did his pretrial, an 18-month pretrial diversion today. I believe he talked to probation as well.
He did.
And Dayton Martin, did he hire Stephen Barrera?
Yes, sir. I received notice of appearance from Stephen last week.
All righty. McNutt, 11-24.
That is what I have, Your Honor.
Morales, no show.
That's what I have.
Okay. Quintanilla, 11-24.
Who is the attorney on that, on Mr. Quintanilla?
Yes.
Mr. Shaughnessy?
Okay.
And Rojo needs interpreter. When do we set him?
11-24, Mr. Cedeos.
Okay, and our add-on?
Final judgment. I
That was a
believe.
judgment, yes. All right, cool. Well, I'm sorry we didn't get more pleas, but we got rid of a little bit.
And I will bring the NICI forms over. I'll get those filled out and bring them over to you after lunch.
Yes, I'll be here.
Okay.
All right, anything else from the state?
Nothing further from us, Your Honor.
All right, then you are excused. Try and finish this up. And
I thank you, Your Honor. We'll see you on Wednesday.
yes.
Judge Wilson, do you mind if we run through the civil docket real quick?
No, let's do that.
Okay.
I'm sorry, am I free to go now?
What sort of case do you have, sir?
My name's Henry Brown.
Okay. And what sort of case?
I'm sorry?
His attorney was Mr. Flores, sir, and he was reset to 1-4.
Yes, I just want to make sure just before I cut off. That's
No,
all.
you're free to go. Thank you.
Okay, thank you. Y'all have a good day.
Okay. Okay. In the interest of BDW, they've got it worked out, order to follow.
Yes, sir.
In the interest of PR Silva, 12-1, George Silva is pro se. In the interest of DJ, a child, what day did we give him for entry?
November 24, I believe.
Okay. And Eric Jimenez is pro se. On the Talamantes children on temporary orders, 11-10 for entry.
Okay.
Okay, the expunctions I need to look at, do that.
And the proposed orders are in the file, in the
Thank you,
files
ma'am.
for those expunctions.
Yeah, I want to see if that's the same Brian Lissy. Dealt with him a lot if it's the same one as county attorney. Why I asked what the offense date was, because I'm disqualified if it's one of those cases.
Yeah.
All right. That's Rizzo. It's supposed to be versus Brown.
I did-
Summary judgment was granted. Yes, ma'am.
I did call Miss Aragon's office, left a message that they need to e-file the order because we were not able to download it from the chat.
Thank you. All right, and on the next one, if somebody would contact the attorneys. Same thing.
Did he give you the receipt? The receipt was.
Because I was given two orders that were both corrupt. I couldn't open
Oh,
them.
okay. I only knew of the one. Okay. So I will let them know that they need to do that one as well through e-file. Okay.
All right. Excellent. Well, I will start looking at the documents I was sent. Let me ask, what do the dockets look like tomorrow?
Okay, let me flip to it real quick, sir. We have 20 criminal records right now, and it's a first appearance docket for quite a few of those. So let's see.
And do I have
We have
just
about 13 cases on, sir.
Okay, and do I have any of the civil dockets?
No, sir, you should not.
Okay.
Unless there was an ad today, but you should not otherwise.
Okay. All right, and then on Wednesday, I've got the criminal docket, and then Judge Ellison is taking the docket on Thursday.
Yes, sir, I just found out about that and I updated the links and all.
Thank you.
You're welcome.
I'm gonna go ahead and download these.
Judge, are you there?
Yes,
Are we resuming at 1 o'clock?
yes.
Okay, because I'm going to get something to eat real quick.
Okay, if you need more time, that's fine. Just take your time.
Okay, thanks. I'll be leaving my video on just so you can see I'm not there.
All right, let's give Ms. Cavazos a moment. Okay, we're ready to go?
Yes, Your Honor.
Yes, Your Honor.
Okay, let the attorneys know I have Judge Ellison is going to take my criminal dockets on Thursday so I can work on this case that day. What's caught up? Who all is going to be speaking today?
Your Honor,
Go ahead, Bob.
go ahead, Mark.
Mark Guerrero for the peelers on the motion for the referral of the expert motions to the special master.
Okay.
And Your Honor, Bob Schick arguing in response in opposition to that motion.
Your Honor, Mark Guthrie, Kiewit Mining Group, arguing in response and opposition to that motion.
Your Honor, Clinton Butler here on behalf of South Texas Electric. We'll just be joining with Sam Miguel, Your Honor.
All right, and give me just a second. All right, go ahead, Mr. Guerrero.
Sure, thank you, Judge Wilson. May it please the court. As the court is aware, 20 motions to strike experts have been filed with the court by the parties in this case. Each of these motions involve highly technical matters on the topics of hydrology, geology, soil contamination, accounting, environmental remediation and reclamation specific to coal ash and other contaminants, technical aspects of coal mining and operating a coal-fired plant, geospatial analysis, geophysical surveying, agronomy, wholesale energy production and storage, and real estate property damage valuation specific to environmental claims. Thus far, the court has heard 3 of these motions, meaning that 17 remain, and 15 are currently set on the court's docket at various times through January of next year, including 2 that are to be heard today pending the outcome of this particular motion. 2 of the expert motions remain unscheduled as of now. In addition to the expert motions, as the court is likely aware, 11 different summary judgment motions remain to be set. These are outlined in the peeler's motion, and these need to be set between now and the March 8th trial date around all of these expert motions, around the court's 2-week trial setting in January 2021, and factoring in the several motions that the court has already heard that remain pending. We anticipate, like today's motion, that each motion will take 1 to 2 hours each, meaning that there's an additional 17 to 34 hours of court time that remain. The motions as filed are over 4,000 pages, much of which is technical and scientific data, and this doesn't include the responses and the replies, some of which remain to be filed. The appealers have moved for referral of these motions, the remaining motions that have not been heard yet, to Special Master Carl Baer, who was previously appointed in November 2019 to review the Burns and McDonnell environmental study. In November 2019, the parties submitted to the court proposals as to Mr. Baer's duties with respect to the Burns and McDonnell study. That remains pending before the court, so he actually hasn't reviewed anything as of yet. We are not moving to refer these motions to Mr. Baer solely because the court is busy, although that is a valid consideration. But as evidenced by Steck, San Miguel, and KMG's prior consent to Mr. Baer have Mr. Baer review the Burns and McDonnell study, this case presents highly technical scientific issues. The Transamerican Natural Gas versus Mancius case, which is cited by San Miguel in their response, in construing Rules 171 to the Texas Rules of Civil Procedure, states that the need for technical expertise may be considered in determining whether exceptional circumstances exist to justify the appointment of the master. The Transamerican Court further observed that special masters have been appointed to conduct comprehensive analyses of highly technical data. Here, the parties have already previously acknowledged that technical expertise could aid the court with respect to the Burns and McDonnell study, and the complexity of the case hasn't changed at all. While we have not been provided the Burns and McDonnell study, we expect the technical and scientific issues at issue in that study are substantially the same issues that are before the court in the expert challenge motions. Mr. Baer's prior experience in environmental related claims, such as his prior litigation of such claims at the Environmental Protection Agency, will be helpful in analyzing the over 4,000 pages of highly technical expert challenges in order to determine if reliable methodology was used. I'll take just a second to talk about the case law that was cited in the response to our motion. Importantly, none of the case law that was cited by the opposing parties states that a court may not appoint a special master to make recommendations regarding motions to strike experts. Further, the cases they cite are distinguishable. In particular, Simpson, which is a Texas Supreme Court case. In that case, the trial court referred all discovery motions, past and future, to a special master. At the time the trial court made that referral, it had not conducted a single discovery hearing and basically had done no work in the case to determine if the case was truly exceptional or complex. In analyzing the case, the Texas Supreme Court also noted that the trial judge explicitly stated during a hearing that the matter wasn't complex and that the record did not reflect that any particular motion was complex. Also, by referring the pending motions, which were not complex, plus all future motions, it's clear that the trial court wasn't performing an analysis as to whether each motion was exceptional or complex. This is the type of blanket referral. This is the type of blanket referral that the Supreme Court has found to be an abuse of discretion when a judge says, let's send all discovery matters to a special master. The other cases cited by the opposing party have similar fact patterns to Simpson. In contrast here, this is a different situation. As the court is painfully aware, it's heard multiple discovery matters, is very familiar with the highly technical and scientific nature of the case, and based on our motion, would be referring a distinct and specific subset of motions, which are already filed. We are not asking for the court to refer future motions. This is not the type of blanket referral that's discussed in the Simpson case. The opposing parties attempt to contort the case law into a black and white issue here when it's not. In Simpson, the Supreme Court stated that the exceptional case and good cause standards are not susceptible to precise definition. Although the court may consider the complexity of the case, the rule standards may not be satisfied merely by showing that a case is time-consuming or complicated. The appealers do not argue only that the case is time-consuming and complicated, although it's both, and Simpson recognizes that these are valid considerations, but it also argues that the motions the appealers seek to refer include highly technical scientific matters.
And which motions are those? Is it all of them?
Those are going to be the remaining 17 that the court has not heard yet. Yes, Your Honor. Simpson also pointed to the allegations in the pleadings and the amount of activity in a particular that a particular case has generated as factors to be considered in determining if a case was exceptional. Here again, the allegations in the pleadings and the amount of activity in the case that the case has generated before the court is substantial, both of which can support a finding that the case is exceptional and that good cause exists under Rule 171. As set forth in the Peeler's motion, Mr. Baer has experience in environmental cases, and he's also an engineer. The opposing parties, the coal companies, raised a concern as to whether or not Mr. Baer has the ability to help. And looking at his online calendar, which is updated as of October 20th, Mr. Baer has 11 full working days in November, 15 full working days in December, and the entire months of January and February available. His availability will allow the potential for hearings to be scheduled on consecutive days to save duplicative attorney preparation, which will create efficiencies for the parties. We think that Mr. Baer's technical expertise and focused scrutiny on these motions will help narrow the issues before the court, which is in the interest of judicial efficiency. To the extent objections are filed by either party based on Mr. Baer's recommendations, the court will have a reasoned and technical context in the form of the special master report in which to analyze any issues that remain. The opposing parties raise a sky is falling argument that the use of a special master will overly complicate the case and cause more hearings, but that's just not based in reality. The Texas Supreme Court observed in Simpson that the use of masters is to aid judges in the performance of specific judicial duties as they may arise in the progress of the cause. The reason Rule 171 exists is for cases such as this and for the specific issues such as these highly technical expert issues before the court. As such, the Peelers ask that the court find that this is an exceptional case and that good cause exists under Rule 171 to refer the remaining 17 expert challenges to be heard by a special master.
And are you ready right now to go through these motions and all 17 of them and say what it is that the master would have expertise about? I don't know what he's an expert in all of the laundry list of areas that there are motions pending.
Well, Judge Wilson, looking at the case as a whole, all of the cases, all of the experts build on the different expertises. You can't look at the accounting issues, for example, or the appraisal issues without understanding the contamination issues, which are kind of the core issue of the case. And so there's a relation that is the common thread among all of the cases. And what a special master will be able to bring to the table is he will have an understanding of the core issue, which is the contamination issues, and how that impacts all of the other disciplines.
Okay, what else?
That's all I have.
Right, Mr. Scheck?
Thank you, Your Honor. As you heard, Judge, the premise of the Peeler's motion here is that it would save this court's time to refer these 17 motions, all of which relate to the challenges to expert witnesses, to a special master. The reality, however, if you read Rule 171, which was not cited in the Peeler's motion, Rule 171 gives the parties the right to object to a special master's findings and to obtain a de novo review by this court. Thus, given the history of this case and the parties' inability to agree on much of anything, a referral on this matter would actually lead to 2 sets of briefing, to the special master and then on the de novo review to you, depending on what he did, 2 sets of arguments and more work for this court, because then the court would have to look at not only the briefing and hear additional argument, but this court would also have to review the special master's findings. In the Simpson case that Mr. Guerrero cited, decided by the Texas Supreme Court in '91, the court held that a toxic tort case with 18 defendants on a docket the court agreed was crowded was not sufficiently exceptional to justify the referral of discovery matters to a special master over a party's objection. And the court there said, it simply does not and cannot follow from the fact that our trial courts are busy, as they certainly are, that they do not have time to hear complex cases. Rather, these are the very cases which most need and benefit from the supervision of an experienced trial judge. And that's precisely what we have here, Your Honor. The matters that the appealers seek for referral are not mere discovery matters. Instead, it goes to whether certain expert witnesses, actually all the expert witnesses, may testify, and if they may, to what extent may they testify. The key issue then, and the primary basis, Judge, for our objection, is that it is the trial judge, you, who will conduct the trial of this matter. It is one thing to refer discovery matters, such as whether a privilege applies, or how documents might or might not be redacted, which was the focus of the Mancias court that Mr. Guerrero cited. But it's quite another thing when the matters for referral go to how the trial itself is going to be conducted. Indeed, the Mancias court noted that even as to discovery, quote, it remains the duty of the trial judge himself to review the documents and make the ultimate determination concerning discoverability. The other cases cited in our opposition support this very strict limitation on referrals to special masters under Rule 171. This court is the gatekeeper, not a special master. This court will be ruling on objections at the time of trial as to the testimony from these 17 witnesses, and it needs to hear and consider these motions as a preview for the things that are going to be objected to at the time of trial. And it is this court, not a special master, that will decide more broadly how this case is to be tried and what issues are to be submitted to a jury. Rule 171, Your Honor, and the case law simply do not support a referral of these motions. Referral will create more work for everyone, not just the court, but the parties. Moreover, it will increase the costs to the parties, and it is therefore unfair to the litigants who oppose it. Finally, last year, the court announced that it would refer one specific, discrete discovery matter to a special master. That was the Burns and McDonnell report, and the question was, do certain privileges apply, and if so, to what extent? And is that document discoverable in whole or in part? And the court announced to us that it thought referral to a special master made sense. And you then asked us to agree upon a special master. So it was the court, not the parties, that sought that referral to the special master. And we agreed, the parties agreed, to Carl Baer as the special master for that one discrete discovery matter in dispute, not for anything else. And no order's been issued with respect to Carl Baer, and nothing is already there that suggests that Carl Baer is the one who this could be referred to for other matters. We made the agreement for that particular and isolated referral for that purpose only. We did not, and we do not agree to a further referral, and believe that under Rule 171, Your Honor, it actually would behoove this court and save this court's time not to refer to any special master.
Mr. Guthrie?
Your Honor, Mark Guthrie, Kiewit Mining Group. We agree with everything Mr. Schick just said. I want to emphasize that ruling on experts and the court's role as a gatekeeper is a uniquely judicial function. And in addition to creating extra expense and extra time requirements that the special master would inject, the court will hear a number of motions for partial summary judgment in the coming months. Many of those will involve or may involve expert testimony. You will already have a preview of that expert testimony by virtue of hearing these expert motions. You will have to reinvent your wheel, as will the parties, to argue the expert issues in connection with the motions for summary judgment. Kiewit Mining Group does not consent to the requested referral to the special master, and that's all I have, Your Honor.
Mr. Butler, you're just went away. Okay.
Your Honor,
Said us
we
too.
don't have anything to add on that. We stand by what San Miguel has stated.
Okay. Mr. Guerrero?
Just very briefly, Your Honor, I just want to hit a couple of points. Again, what you didn't hear from Mr. Schick, Mr. Guthrie, is they didn't cite any law. If you read Simpson closely, it doesn't stand for the proposition that referring expert challenges to a special master. It doesn't say that that's an inappropriate use of a special master. And again, the fact pattern was very specific in Simpson. What the Texas Supreme Court said was an abuse of discretion was a trial judge who basically did nothing in terms of discovery, and from the start referred all pending motions plus all future motions to a special master. That's not what is being asked here. What we are asking is a mechanism to help narrow the issues before the court. And Mr. Schick and Mr. Guthrie say that appointment of a special master will only create more work, but it leaves open for the potential that a special master could resolve certain issues within the motion, if not complete motions. As the court is aware, each of these motions tends to have 5 or 6 different arguments. If a special master can look at that and he can make a recommendation on each of those arguments, it's possible that we can narrow the issues that are before the court, and it's possible for certain motions that there won't be any objections filed. Again, we are suggesting this as a manner in which to approach this in a systematic method. Obviously, the discretion is with the court, and that's all I have. Thank you, Judge.
All right. And one more time.
Two quick things, Judge.
Hold on, please, Mr. Schick. Is there any, which of the 17 motions would the special master's qualifications give him any particular insight into? I understand you said that there's some overlap, but.
Yes.
Your Honor, I think in particular, it would be Dr. Lauren Ross, Gordon Johnson, Anthony Brown, Mary Sitton.
Hey, hold on. I'm looking. Which Mary Sitton is number 8? Okay. On this list I was given, who else?
Gordon Johnson.
Okay, that's 13. Ross is 10.
Anthony Brown.
Okay.
Mark Hemingway.
All right, which number is that on my list?
Sorry, I don't have the motion in front of me.
I don't see a Mark Hemingway. All right.
So, so the San Miguel experts, I think Mr. Bear would have specific expertise on, would include Mark Hemingway, Timothy Verschlicki, Jeremiah McKinney, William Meister, and then for the peeler experts, I think it would be Lauren Ross, Mary Sitton, Mike Owen, although I don't think they filed a motion to exclude on him, so I apologize, scratch that. Gordon Johnson, Anthony Brown, and then the motions that you've already heard on Bowman and Pemi also would probably fall within his area of expertise, Your Honor.
Okay, and see, I have no idea until we start what these experts are testifying about. So Timothy Verschlicki, what is that individual testifying about?
He's testifying as to the site investigation, Your Honor. He is an ecological risk assessor.
Okay, and then Jeremiah McKinney and Michael Barrett, were they on your list?
Jeremiah McKinney, Your Honor, is a contractor who works for San Miguel, who works on their mine permit, and he is testifying as to the natural conditions of the Peeler Ranch. So soil and endangered and threatened species.
All right, so it's not someone that would, the special master has any particular knowledge about the condition of the ranch for? I'm trying to ask, is this someone that you're saying the special master would have particular knowledge of?
I hesitate to answer only, Your Honor, because I happen to not believe he's very scientifically technical, but I'm sure that was the purpose of what San Miguel designated him for. So I think that you could probably look at his without needing any specific expertise.
All right. Mary Sutton, what is she testifying about?
She is a geospatial expert, and she is looking at historical photos of the ranch over the years and has opinions about what has happened over the years based on her analysis.
And you said that Mark Hemingway was one?
Yes, Your Honor. He is their San Miguel's site investigation expert. He's a hydrologist.
And Dr. Lauren Ross?
She is highly technical, Your Honor. She does a statistical analysis for determining background conditions on the Peeler Ranch using a sampling investigation. She is a statistical specialist in environmental contamination cases.
Okay, Gordon Johnson?
He is the Peeler's geotechnical engineer who has also, he's done site investigation on, and also has designed the remedial plan.
And Anthony Brown?
He is the Peeler's main site investigation expert who has opines on the presence and extent of groundwater and soil contamination on the ranch, Your Honor. His report is something like 3,000 pages long.
Okay.
And then Bill Meister, Your Honor, William Meister. He is San Miguel's reclamation expert.
Okay, and the expert's area of expertise was in?
William Meister is reclamation.
No, I'm sorry, the masters.
Oh.
And the other issue, his area of expertise was?
Carl Bayer's area of expertise, Your Honor.
Yes.
He is an engineer with lots of experience in these types of cases. I think he has been a special master in cases that are pretty wide ranging, from patent law and through environmental contamination. I think judges refer all kinds of technical matters to him.
Okay. All right, Mr. Schick.
Thank you, Your Honor. Judge, with all due respect, we really think you need to hear these motions. This stuff isn't any more complicated than any other case that you've tried over your course as a trial judge. It's no different from the kinds of experts you see in like pharmaceutical cases with epidemiologists, or in the oil and gas cases. You hear testimony from hydrogeologists, from petroleum engineers, from reservoir engineers. None of these experts present anything more complicated than that, and you're going to have to be the one making those rulings at the time of trial anyway, and it would behoove the court, in my opinion, with all due respect, for you to hear these in advance as they come up on these motions to exclude, and it will give you the preview that you otherwise will be deprived of, except if we go and put everything back in front of you once again, and then you're going to be jammed up in the month of February having to hear these 17 re-argued motions, which is a waste of time and resources for all of us. And I would simply repeat, Your Honor, this is within your wheelhouse as a trial judge. I have no doubt about it. And second, we do not agree to the appointment of Carl Baer for any purpose beyond the initial appointment for the Burns and McDonnell review for discoverability purposes. Thanks, Judge.
Your Honor, Mark Guthrie, if I may.
Yes, go ahead, sir.
Mr. Baer's background is that he has degrees in electrical engineering and biomedical engineering, which have very little relevance to the issues involved with these experts, if any. And again, we don't think that he is any more qualified than you to hear these motions. Now, Mr. Guerrero said twice that San Miguel and Kiewit Mining Group and Steck didn't cite any case law supporting our position. What's more important, I think, is as the movement, the Peelers cited no case law supporting their position that it's appropriate to appoint a special master to hear motions to exclude expert testimony.
Okay.
Thank you.
I will take these under advisement. Let's go ahead and what we have today. That's Dr. Powell.
Yes, Your Honor.
Both Dr. Powell and Carl Kellyan, Mr. Carl Kellyan.
Okay. All right, so who is going to argue this? Ms. Whittle, Ms. Guerrero?
I will argue both motions, Your Honor.
All right, go ahead.
Okay, may I share my screen with you?
Yes.
I'm going to try something new, so if anyone can see my notes, please let me know. Okay, can you see that slide?
Yes, it looks like a PowerPoint presentation.
Yes, Your Honor.
Hey, just a moment. Clerk's office. Go ahead.
Okay, Your Honor, the Peelers ask the court to strike and exclude expert and opinion testimony offered by San Miguel for their designated expert, Dr. Robert Powell. They have designated Dr. Robert Powell to opine on, number one, the historic construction and operation of the lining systems for the ash ponds and equalization pond on the San Miguel power plant property. Number 2, the pond's conformance with then applicable regulatory standards, so the 1970s and early 1980s. And number 3, the standards of practice and operation of these ponds in comparison to analogous facilities in the same time frame. And I'd like to just give you a little background on why we're talking about liners. So the Resource Conservation and Recovery Act, or RCRA, is a comprehensive federal statute regulating solid wastes. Under RCRA, hazardous wastes are regulated under Subtitle C, while all other solid wastes are regulated under Subtitle D. In the early morning hours of December 22nd, 2008, a dam at the Tennessee Valley Authority's Kingston power plant collapsed, releasing over 1 billion gallons of coal ash onto the community of Harridan, Tennessee, which you can see in this photograph. It was the largest toxic spill in U.S. history. Following this disaster, EPA finalized the Coal Combustion Residuals Disposal Rule, or the coal ash rule, in 2015. The final rule regulates the disposal of coal ash as solid waste under Subtitle D of RCRA and establishes national minimum criteria for existing and new coal ash landfills and surface impoundments. The federal coal ash rule has several requirements, and with respect to the groundwater monitoring, every regulated site is first required to perform what is called detection monitoring for a list of pollutants known to be indicative of coal ash, including boron, sulfate, and 5 others. These pollutants are listed in Appendix 3 of the coal ash rule. If detection monitoring shows significantly elevated concentrations of one or more pollutants, then the site progresses to Phase 2, or assessment monitoring. The assessment monitoring of pollutants listed in Appendix 4 of the coal ash rule include a longer list of chemicals like arsenic, cobalt, and selenium. The rule establishes groundwater protection standards for each one. If assessment monitoring finds pollution in excess of groundwater standards, then the owner of the site must initiate corrective action to restore groundwater quality. If assessment monitoring finds elevated pollution near an unlined surface impoundment, then that surface impoundment can no longer be used and must be closed. Because of the limited authority afforded to EPA under Subtitle D of RCRA, enforcement is achieved through citizen suits. Both industry and environmental groups challenged the federal rule. There was a settlement over some of the claims and the remainder went to argument. In 2018, the U.S. Court of Appeals for the DC Circuit issued a decision that struck down the provision that allowed for existing unlined impoundments to continue to operate. The court also struck down the provision that allowed for clay-lined impoundments to be considered lined. New impoundments must either have a composite liner, defined to mean a system of comprised of, number 1, a synthetic membrane of a particular thickness, and number 2, a layer of compacted soil that meets a particular standard of impermeability, or the equivalent of a composite liner. If monitoring detects a statistically significant increase in a contaminant above the groundwater protection standard, an existing unlined impoundment must either close or retrofit to meet the criteria for a new lined impoundment. None of San Miguel's coal ash impoundments meet the composite liner requirements. Therefore, once EPA issues a rule implementing the DC Circuit's opinion, which it still has not done, all of the San Miguel impoundments in Texas will have to close or retrofit. This is true even if those units are not currently leaking, although based on the publicly available information San Miguel has disclosed on its website, all of the surface impoundments at the plant are leaking contaminants, including arsenic, boron, cobalt, and lithium, mercury, and radium into groundwater at levels that would be unsafe for human consumption and therefore violate the coal ash rule. Under TCEQ rules, no permit is required for the disposal of non-hazardous industrial solid waste such as coal ash if the waste is disposed on property owned or otherwise effectively controlled by the owner or operator of the industrial plant, manufacturing plant, mining operation, or agricultural operation from which the waste results or is produced, if the property is within 50 miles within the plant or operation and the waste is not commingled with waste from any other source or sources. Similarly, no permit is required for the storage of non-hazardous industrial waste if the waste is stored on property or otherwise effectively controlled by the owner or operator. So this was true in the 1970s and 80s, and it remains true today. Texas also excludes from regulation coal ash that is destined for beneficial reuse, which includes mine filling, the dumping of industrial waste in active and abandoned coal mines. Dr. Powell's opinion, however, relates to disposal of coal ash in these ponds. So here is an overview of the power plant, and I don't know if Your Honor can see my cursor.
Your picture, yes.
Okay. Yes, Your Honor. So these are the ash ponds. This is ash pond A. This is ash pond B. You can see ash pond A in this photograph has lots of solids or coal ash in the pond, filling it up such that there's not a lot of room for water. The equalization pond is over here. This receives scrubber waste and wastewater, and then this is a coal ash pile. The coal ash pile, ash pond A and B, and the equalization pond are the 4 units that are regulated under the coal ash rule. Here's an aerial view of them. So you have the equalization pond, ash water transport pond A and B, and then the ash pile. And based on the publicly available information on San Miguel's website that it has to maintain through the coal ash rule, all of these are leaking into the groundwater. And so in February 2019, San Miguel posted notice on its website that there's preliminary evidence of statistical increases above groundwater protection standards of the following constituents at certain monitoring wells: radium 226 and 228, lithium, and mercury. As a result of this finding, combined with the DC Circuit's decision that it violates RCRA to allow clay-lined impoundments to continue to operate, San Miguel has proposed and begun a retrofit of its impoundments at the plant. And again, all of the impoundments are clay-lined, so they must all be closed. So Mike Kezar at his deposition, and again, he is San Miguel and STEC's general manager, when I asked him, based on your understanding of the federal requirements, will San Miguel need to close or retrofit all of its surface impoundments at the plant? And he stated, yes. Based on my current understanding of the rule, yes. And when I asked, when does San Miguel intend to do that? He testified, we are evaluating proposals right now that have been received from contractors, and we'll get started as soon as we have a definitive proposal or contract to award. So in the very near future. I'll just ask that you remember this testimony, because this and the next slide involve the sum total of Mike Kezar's testimony at his deposition about this retrofit. At page 147 of the deposition transcript, I asked him, you mentioned before a plan to retrofit Ash Pond A. Will you be relying on the current constructed clay liner to be the second liner of the composite liner? And he testified, yes, the current clay liner will be reworked and the composite liner will go on top of that. And then I asked him, and will the current clay liner be evaluated for integrity? And he said, I don't know all of the bid specifications. I can't speak to that, but I know that part of that is to make sure we comply with the CCR rules, and that is the ultimate requirement. So that testimony, this is the sum total of his testimony about the retrofit. And this is important because that's what Dr. Powell relies on for his opinions. So again, these are the 3 opinions that San Miguel has designated Dr. Powell to testify. And Dr. Powell in his deposition confirmed that his expertise is limited to only a fraction of this designation because he testified it was narrowly focused on the distant past, whether liner systems used to construct the ponds in the late 1970s and 1980s complied with the laws and regulations in effect at that time. He stated, quote, "My testimony is narrowly focused on whether the liner systems that were used to construct the ponds complied with the then current rules. I have not attempted to look more broadly at other aspects of the pond management." So we ask that Your Honor exclude Dr. Powell's testimony because he is not qualified to opine on these issues. He is not a geotechnical engineer, which is the area of expertise that he would need to have to be able to testify as to liner design and installation. He has never designed a liner. He is not familiar with Texas laws and regulations, and he's never led a site investigation or designed a site remediation concerning coal ash. He's designated to opine on the specialized issue of surface impoundment liner design and construction and the relevant governing regulations in Texas back in the 1970s and 80s. But he lacks qualification to testify as to these issues. The fact that he has engineering training and experience and has worked in some capacity on projects that involve surface impoundments is not sufficient to qualify as an expert on liner design and construction. And he is grossly unqualified to opine on the relevant regulations. Dr. Powell admits that he's not qualified as an expert in pond liner design or construction or in geotechnical engineering. And he identifies geotechnical engineering himself as the relevant specialty field. So I asked him, can you describe to me how your education and training give you special expertise in liner designs for waste impoundments? And he says, well, as I mentioned earlier, I have had some coursework in geotech engineering. And I said, do you consider yourself to be an expert in liner design? And he said, I don't profess to be an expert in geotechnical engineering, although I have some knowledge of the field and how it's applied in liner construction. And I asked again, okay, do you consider yourself to be an expert in liner construction? No, certainly not the geotech aspects of it. So Dr. Powell himself repeatedly identified geotechnical engineering as the specialty field relevant to liner design and construction, and he stated he is not an expert in that field. Dr. Powell's purported expertise merely comprises membership on engineering teams for which the geotechnical engineering expertise was provided by others. The Peelers do not dispute that Dr. Powell has been involved with such projects and has a long career as an engineer, but such ancillary training and experience is inadequate to establish the credentials required to qualify Dr. Powell as an expert in this case on the matters for which he has been designated. Counter defendants are unable to identify any specific experience or specialized knowledge regarding liner design or construction, the topic about which Dr. Powell opines, which is what is required under Texas law for his testimony to be admissible. Involvement in some unspecified engineering role on projects that contain surface impoundments is inadequate to confer the level of knowledge or expertise required to qualify as an expert in the specialized field of surface impoundment, liner design, and construction. As he testified, I would typically engage a geotechnical engineer or a geotechnical engineering firm as part of the project team, and they would handle the geotech aspects of the project. He's simply not qualified. He is also not qualified to testify as to the Texas regulatory framework. When I asked him what the basis was for his expertise in the applicable regulatory standards in Texas, he stated, I principally relied on the description of those standards as they were portrayed in historic documents written by professionals who were working on the site at the time or subsequently working for San Miguel under the more recent US EPA and that's supposed to be CCR management programs and various certifications that they prepared for EPA. In other
I'm
words,
sorry, I messed up I clicked the wrong thing. There we are. I'm sorry, go ahead.
Okay. So in other words, Your Honor, he is relying on documents that San Miguel's contractors pulled together as part of their compliance with the coal ash rule to try to demonstrate what was done historically to design and install those liners. He has no personal knowledge of it, and he also doesn't have any knowledge of the Texas regulatory standards. His knowledge of Texas regulatory standards is grossly inadequate to support his proffered testimony regarding whether the design and construction of San Miguel's ponds complied or will comply with the governing regulatory standards. Until he was hired to testify on San Miguel's behalf, Dr. Powell was totally ignorant of the relevant Texas laws and regulations. He admitted that his knowledge of Texas regulations came through the research he did in this project. That's a quote from him. To develop his purported expertise in the Texas regulatory regime, Dr. Powell, quote, obtained some of those regulations and reviewed them and, quote, consulted with members of his firm who practice in Texas to clarify. When asked if the person he spoke with who practices in Texas provided him with information relevant to his opinions, he testified that it wasn't. Because this self-study provided only a superficial understanding of the law, Dr. Powell testified that the basis for his own supposed expertise in Texas regulation, essentially he's just parroting the writings of San Miguel's previous consultants. And then when I asked him, when did the reliance on natural soil liners for solid waste disposal end in the state of Texas? He couldn't even answer that. If his opinion is that San Miguel was in compliance with regulations about solid waste disposal in the state of Texas back in the 1970s, then he should know when those changed to require a geomembrane liner. He even admits that he is not familiar with the standard for liner design and construction for a new solid waste landfill under Texas law. And he didn't even know what the Texas solid waste disposal rule is, which is not a gotcha question, as the counter defendants claim. If someone is purporting to be an expert in Texas regulations about coal ash disposal in surface impoundments, they should know it. The Texas Health and Safety Code, Chapter 361, is entitled the Solid Waste Disposal Act. An expert with specialized knowledge about Texas regulations governing the handling of coal ash, as Dr. Powell claims to be, would instantly recognize a reference to the Texas Solid Waste Rule as indicating the Texas Solid Waste Disposal Act, or at least would have enough knowledge to seek clarification, which he did not. But Dr. Powell did testify that San Miguel's management of the CCR waste on the property was regulated by the state as solid waste. Yet his expertise regarding regulations in the 1970s and 1980s does not extend to even identifying which Texas agency regulated solid waste disposal during that time. He didn't know. Dr. Powell also could not identify what provisions of the state code authorized San Miguel to dispose of coal ash in the impoundments. And notwithstanding his supposed specialized knowledge regarding the relevant regulations, Dr. Powell has no idea whether the state of Texas even requires a permit for San Miguel to dispose of coal ash and wastewater in the surface impoundments at the plant, stating only that, quote, he would assume it was required, and that, quote, he assumes San Miguel secured a permit or the state would have shut them down a long time ago. But as I discussed earlier in my presentation, San Miguel was exempt from permitting requirements in the state of Texas. The state's role at that time was to make suggestions based on best practices, and San Miguel could ignore all of them, and at least in a few important instances did. The fact that Dr. Powell does not understand that very basic issue shows his ignorance of Texas regulations. We also think that Dr. Powell's opinions should be excluded because they are not reliable. He has not conducted any of his own testing or research. He's never visited San Miguel's power plant. His lack of understanding of the Texas regulatory scheme is critical. He relies exclusively on select written materials cherry-picked by San Miguel's counsel, which he admits is incomplete. He has no firsthand or direct knowledge of the liners at issue, and he has no firsthand or direct knowledge of the planned retrofit and closure. His opinions essentially amount to speculation. His opinions are inadmissible because they're nothing more than conclusory declarations that are not grounded in the evidence or any reliable methodology. He used no discernible method to reach his conclusions. He relied on numerous unfounded assumptions and simply adopted others' conclusions as his own with no independent investigation or analysis. He read those documents pulled together by San Miguel's contractors, and he just adopted them. He did nothing to make sure they were actually correct. The evidence he relied upon is insufficient to support his conclusions, and even his own account of the record evidence contradicts his conclusory declarations. Because his opinions are not grounded in scientific, technical, or other specialized knowledge and would do nothing to help the trier of fact determine an issue, a fact issue, they are inadmissible. We also, even though the actual design and construction of the impoundment liners could not be more central to the opinions he proffers, because the documentation for the ash and equalization pond construction Dr. Powell received was, quote, somewhat incomplete in describing precisely how the liner was actually formed in these units, Dr. Powell just guessed at how the liners were designed and built, even though he admits he is not an expert in designing or constructing such liners. This gap in the record is not simply, quote, to be expected, as counter defendants allege in their response. The details of the construction go directly to the heart of Dr. Powell's opinions. That the necessary foundational information is missing or unavailable does not excuse an expert from the requirement to rely on an adequate foundation for his opinions. Rather than actually understanding the governing state regulations and applying them to the facts of the liner design and construction, Dr. Powell's method involved assuming that all the regulations were satisfied because the handpicked materials that San Miguel Litigation Counsel provided him included no evidence of violations issued by regulatory bodies. This method is patently unreliable. Dr. Powell admits that materials San Miguel's Litigation Counsel selected for his review did not reveal the violations that TCEQ actually did issue to San Miguel. Furthermore, his method involves no analysis or assessment whatsoever. Dr. Powell does not even know the relevant regulations, and his expert opinion about how they apply in this case reduces to the pronouncement that, so far as Dr. Powell knows, with no independent investigation, San Miguel was never cited by a third party for violating them. Similar, to conclude that the testing performed at the ponds at the time the ponds were originally built was adequate, Dr. Powell relied on the fact of the state having looked at the same information, and that the certifications from the supervising geotech engineers reached that conclusion and approved the design of the pond and the construction and allowed it to go into service. Again, Dr. Powell applied no analysis or independent thought, but just assumes that because the state and San Miguel's hired engineers at the time approved pond construction, it must have been properly constructed. Remarkably, Dr. Powell would just assume that the state of Texas required San Miguel to secure a permit to dispose of coal ash, and further assumes San Miguel secured a permit or the state would have shut them down a long time ago. In fact, no such permit exists. His assumptions about the involvement of the state regulatory agency in approving the installation of these ponds is not a reliable foundation for expert opinions. Dr. Powell's conclusions not only rely on unfounded assumptions, they directly contradict record evidence in this case, even according to his own testimony. In opinion number 3, Dr. Powell asserts that after reconstruction of ash ponds A and B around 1987 and 1990, which was years after they were determined to be leaking, the liners provided an effective barrier to limit migration of waste materials through the pond bottom. And just to go over that again, the ash ponds A and B were determined to be leaking almost immediately after they were put into service. But their liners were not replaced. The constructed clay liners were not replaced until 1987 and 1990. And he testified that they provided an effective barrier to limit migration of waste materials through the pond bottom. But then his testimony later confirms that the pond liners have proven to be anything but an effective barrier since 1990. He acknowledged that although, quote, the reconstructed liners that they put into the ponds in 1987 and 90 were more effective than the initial pond construction, there's going to continue to be some low-grade seepage of water through them. And he admitted that even after reconstruction, a seep has been identified in a more recent geotech engineering report and some remedial measures recommended to address it. He confirmed that the groundwater monitoring showed that there had been an impact on groundwater in excess of what the federal regulations would have allowed. And he admits that in concluding the barrier was effective, he did not consider the surrounding groundwater deterioration, nor did he evaluate how much wastewater has seeped from the ponds over 40 years of operation. How can he determine that they were effective if he didn't actually review the surrounding groundwater deterioration or evaluate how much wastewater has seeped through the bottom of the ponds, which he admits has happened? Dr. Powell's opinions are nothing more than conclusory declarations without foundation in the actual evidence or any discernible analytical method, and thus are inadmissible under Texas law.
Okay, who's going to respond first?
Oh, sorry, Your Honor.
That was not your
No.
finale.
Sorry. So we also argue that his opinions are not relevant. Dr. Powell left no doubt that he was relying solely on the letters from San Miguel's hired consultants to attempt to infer that the governing regulations were satisfied. Again, that's simply wrong, and all of his opinions that flow from that fundamental misunderstanding of how Texas regulates solid waste disposal, which is to exempt it from regulation, should be excluded. So here, Your Honor, we also believe that his opinions are not relevant. Whether the original installation of San Miguel's liners in the 1970s and 80s was proper sheds no light on any claim or defense in this case. Not one of the peeler's claims or counter defendants' defenses turn on the standards of care or the regulatory regime at the time the pond liners were installed decades ago. The breach of contract, the peeler's live breach of contract claim turns on whether the leaks from the impoundments have caused permanent damage to the buffer zone lease. Whether the pond liners conform to regulatory standards when they were installed says nothing about whether discharges from the ponds have permanently damaged the lands. And with respect to trespass, historical compliance with government regulations decades ago does not provide a defense to the tort of unlawful entry with coal ash compounds onto unleased areas of the Peeler Ranch. With respect to negligence, even if Dr. Powell's testimony established the standard of care for installation of the liners 3 or more decades ago, this standard has no relevance to the duty that the peelers allege was breached when San Miguel ignored known discharges, leaks, and seepages from the ponds after installation. Dr. Powell admits that the ponds have leaked onto the Peeler Ranch and began to do so within a few years after being put into operation, which San Miguel knew. The standard of care which the peelers allege was breached is San Miguel's continued operation of the ponds for decades after they were known to leak and overflow, and the failure to take any meaningful action to address the operational concerns at the plant that were causing the water balance problem and the scrubber upsets that were overtaxing the ponds. Essentially, San Miguel uses the surrounding Peeler Ranch as its primary wastewater management tool, and the leaking from the ash impoundments is massive. San Miguel just recently installed an interceptor trench to capture the water leaking out of the equalization pond onto the ranch, and it filled to the top within an hour. Dr. Powell opines that back in the 1970s, you could just dig a hole in the ground and place waste in it under Texas law. We agree. That's not in dispute. As such, his opinions are not relevant and would serve only to waste time and confuse the jury. And just to be clear, Dr. Powell's opinion is that the natural soil liners could have been effective at preventing migration of coal ash constituents to the Peeler Ranch, but his testimony is that they were not effective. Since they were not effective in preventing leaks and seeps onto the Peeler Ranch, the fact that they were originally installed in compliance with the laws in place in the 1970s, which didn't require a geomembrane liner, has no bearing on any material issue in this lawsuit. And Dr. Powell did not evaluate the operation of the ponds. He stated, I didn't look at the operation of the power plant, certainly, and other aspects of the operations of the pond I didn't look at. He also did not look at their overall water management program and how the ponds are part of that and used in that process. While they did not disclose Dr. Powell to testify regarding the adequacy of the planned ash pond retrofit and closure, they now argue his testimony is relevant to Peeler expert Gordon Johnson's opinion that in order to prevent future leaks, San Miguel must retrofit its ash ponds with a double liner with a leak detection system. While that is a relevant issue, San Miguel offers nothing to defend Dr. Powell's lack of qualifications to assess the liner design or construction of the planned liner retrofit, the foundation for his opinions, or the reliability of his analytical method to the extent he even has one. Dr. Powell is not an expert in liner design or construction. His understanding of the current Texas regulations is just as inadequate as his knowledge of the historical Texas regulations. Dr. Powell has never been the engineer of record for any design of a composite liner for solid waste landfill or a composite liner under the federal coal ash rule, such as he purports to evaluate in this case. He has never before offered an opinion regarding what is necessary to comply with the coal ash rule. He simply does not have the qualifications necessary to offer opinions about the retrofit. Additionally, Dr. Powell has no reliable foundation for his opinions on the current and future retrofit of the pond liners. His entire understanding of the construction relies solely on written descriptions and the description of their intentions that I read about in Mr. Kezar's deposition transcript. He testified that the basis of his opinions was Mr. Kezar's deposition. And I went over the sum total of Mr. Kezar's deposition testimony on the retrofit earlier in my presentation. He has not overseen nor in any way been involved with the ongoing construction of the new liners. He has not reviewed any of the inspection documents for the ongoing work to ensure that it is proceeding according to his understanding of the plans. Nor does he even know who is performing the work he speculates will comply with the coal ash rule. He's not even reviewed the engineering documents regarding the retrofit on the surface impoundments. He's merely speculating that the retrofit will comply with the coal ash rule if done properly, which he has no basis to assert. In short, Dr. Powell is not only unqualified to evaluate pond liner design, he does not have adequate information about the current and future retrofit design to reach the conclusions he offers. Because the coal ash ponds fill with coal ash solids, and San Miguel relies on these ponds for wastewater management, those solids reduce the area for wastewater storage, and San Miguel has to clean them out with dredge equipment and swamp buggies. This is one such dredge operation. Dr. Powell's opinion that a double liner with a leak detection system is unnecessary relies on the assumption that removing ash from ponds will not damage a future synthetic liner. Yet Dr. Powell admitted that he is not sure what they're currently doing to remove ash from the ponds. He explained that one of the most common mechanisms for failure of a geomembrane liner is being punctured by equipment that's operating on top of it. And he admitted that some methods of removing ash could damage the liner. Nevertheless, Dr. Powell confessed that his only knowledge of San Miguel's operating procedures for the ponds comes from the deposition testimony of a former plant manager who no longer works there. And he doesn't know what equipment is used now or is planned for future use. Because he admits that a common reason for failure of liners, such as the one he endorses, is damage from equipment, yet he has no information regarding how equipment will be used in the future ponds, Dr. Powell's conclusion that the double liner with leak detection system recommended by the peeler's expert is unnecessary lacks an adequate foundation. San Miguel's plan is to close the equalization pond entirely and divide one of the ash ponds into two. You can see in this video the equalization pond here. This is a massive pond, and they're going to close this and rely on just the two ash transport ponds, dividing one of them into two to serve as the new equalization pond. So because the volume available for wastewater and ash will be substantially smaller, the cleanouts necessary to maintain sufficient freeboard will need to be more frequent. As you can see, they have a water problem. It goes all the way to the top, to the berm here. This is especially true since San Miguel does not plan to change any operational practices. So all the same issues with having too much wastewater and scrubber sludge will remain. Dr. Powell has not made any attempt to evaluate how often such cleanouts with heavy equipment might need to occur after the retrofit reduces the area available for wastewater and coal ash storage. Moreover, Dr. Powell admits that he has never engineered a liner or evaluated a landfill that has withstood a similar practice of cleanouts with heavy equipment that San Miguel uses, which also results in differential pressures that could cause failure. One of the ways a liner can fail is with differential pressures. A common way that can occur is where the liner is built into the groundwater table, and there's upward pressure that is not offset by the downward pressure of the solid waste. Here, San Miguel is going to be removing coal ash waste, which will cause those pressures to go up and down and could lead to liner failure. That differential pressure problem and the puncture risk are part of the bases for the peeler expert Gordon Johnson's view that a double liner with leak detection is necessary here. In other words, San Miguel's specific operational practices pose a risk to a geomembrane liner, both from puncturing and from differential pressures. Notably, Mr. Johnson is a geotechnical engineer and has the experience and qualifications that Dr. Powell lacks. The fact that Dr. Powell hasn't even evaluated either means of likely failure of the new liner means that his opinion rebutting Mr. Johnson is not based on a reliable foundation and should be excluded. In sum, Dr. Powell's conclusions about the adequacy of San Miguel's future plans to retrofit the pond liners are mere speculation made by a general engineer without any special expertise, based on insufficient information and knowledge and no actual evaluation. As such, they do not qualify as expert testimony and are inadmissible under Texas law. And we ask Your Honor to exclude all of Dr. Powell's opinions in this case. Thank you, Your Honor.
Okay. Who's going to respond?
Good afternoon, Your Honor. This is Taylor Holcomb for San Miguel.
Go ahead.
Thank you. I'll address the arguments raised by Ms. Whittle momentarily, but I'd like to first start with some context for Dr. Powell and his opinions in this case. Your Honor, like many other coal-fired power plants, decades ago, San Miguel designed and constructed 2 ponds at its power plant to manage water associated with the plant's process of generating electricity. San Miguel also uses a scrubber system at the power plant to reduce air emissions, and waste associated with the scrubber system are managed in a 3rd pond that San Miguel designed and as well. In accordance with industry and regulatory standards, San Miguel constructed these ponds with thick liners made of clay. Now, San Miguel's use of these ponds and its approach to managing water in the ponds mirror that of other coal-fired power plants in Texas and across the country. And the government regulates these ponds. In fact, like many other operators of coal-fired power plants, San Miguel is currently reconstructing the clay liners on these ponds to meet new government standards. And that project, Your Honor, is well underway. Your Honor, the peelers have put the pond liners at issue in this case. In their pleadings, they have alleged that these ponds are nothing more than giant holes in the ground. They plead negligence claims, and the peelers say that a non-negligent operator would have taken a different approach to the liner system than San Miguel did. And in their pleadings and through expert testimony, they assert that San Miguel's current project to reconstruct the pond liners isn't good enough. And the peelers request as a remedy in this case for San Miguel to install a different pond liner system that exceeds government standards. In order to address the allegations in the peelers' pleading and their experts' reports, San Miguel hired an expert, Dr. Robert Powell, to explain to the jury why the peelers' allegations and claims are wrong and to otherwise explain the context for these ponds. He gives 5 opinions that are all based around the industry and regulatory standards and practices that were or are applicable to the liner systems on the ponds at the power plant. The evolution of those liner standards and practices over the last 40 years, and how San Miguel's ponds conformed with those liner standards and practices. More specifically, Your Honor, Dr. Powell's core opinions are that the clay liners originally used in these ponds met then applicable industry and regulatory standards, that the proposed design for the pond liners currently under construction will meet applicable regulatory requirements, and that a completely different liner system recommended by the peelers through expert testimony is unnecessary. These core opinions directly rebut claims advanced by the peelers in their pleadings and through expert testimony, and will provide needed context for the jury in this case. Now, Your Honor, the peelers filed a motion to exclude Dr. Powell's opinions, asserting that he's unqualified and that his testimony is unreliable and irrelevant. At the end of the day, Your Honor, for purposes of admissibility, the legal standard boils down to whether the expert is qualified to offer opinions and whether those opinions will actually help the jury. In short, Your Honor, since receiving his PhD 40 years ago, the focus of Dr. Powell's career has been on specific facilities and how ponds at those facilities could be designed to contain water and prevent releases into the environment. In fact, he has specific experience with ponds and pond liners used by other coal-fired power generation companies like San Miguel. Powell has analyzed and applied the technical requirements of complex government regulations as part of his work for decades. In fact, government agencies have enlisted his help in reviewing the technical aspects of permit applications as it relates to pond liner design and liner construction and potential impacts on groundwater. Powell works for one of the nation's preeminent consulting firms, and his education, specialized knowledge, and experience qualify him to assess how the liners used in San Miguel's ponds met and will continue to meet applicable regulatory and industry standards. He's qualified, Your Honor. And with respect to helpfulness, Dr. Powell's opinions will help the jury understand the facts and evidence in this case. Keep in mind, Your Honor, it's the peelers who put these pond and liner-related issues into play. Dr. Powell's rebuttal opinions on the liners are reliable because they are based on his extensive educational and occupational experience and based in part on his review of engineering documents associated with the ponds that were compiled by independent consultants for regulatory compliance purposes. These are not topics that jurors are equipped to understand on their own. Powell's testimony is relevant to rebut the peelers' contentions and pleadings and expert testimony regarding these ponds and their liner systems, and will therefore help the jury understand the facts and evidence regarding the peelers' claims and also San Miguel's defenses. Now, Your Honor, I want to address the items that were raised by opposing counsel just a moment ago. You heard opposing counsel say that Dr. Powell is not qualified because he is not a geotechnical engineer. That's completely irrelevant for admissibility purposes, Your Honor. There's no specific geotechnical expertise that Powell lacks that is required for him to render his opinions on the pond liners. He isn't giving a geotechnical opinion, Your Honor. Geotechnical engineers assess things like the stability of pond embankments. Powell's not giving an opinion on the stability of pond embankments. He's opining on the construction and expected performance of liners installed at the bottom of ponds. He's focused on the hydraulic integrity of liners, not geotechnical aspects of ponds, Your Honor. This is like the Helena Chemical case, Your Honor, where a party objected on qualification grounds to expert testimony from a plant scientist because the scientist was not a plant pathologist with expertise on charcoal rot. The Supreme Court rejected the objection because the objecting party had incorrectly framed the issue, as the factual issue in that case was not solely about charcoal rot. That's true here, Your Honor. The peelers have misframed the issue. The peelers have put at issue the pond liners, their performance over time, and how the liner should be constructed in the future or reconstructed in the future. And Powell's qualified to testify on those topics. Remember, it's the peelers in their pleadings who call these ponds nothing more than giant holes in the ground. The construction and expected performance of the pond liners are topics that are squarely within Dr. Powell's educational training and occupational experience. And Dr. Powell's opinions on the construction and performance of the pond liner systems will aid the jury in understanding the peelers' claims regarding the liners in their pleadings and expert testimony. Your Honor, the governing case law for admissibility is that an expert have experience on the actual topic that they're testifying about. It isn't that the expert have experience on the topics the peelers think they should testify about. Here, Dr. Powell is testifying about topics that are in a core area of his expertise developed over 40 years as an environmental engineering expert. Let me give you some examples. Since receiving his PhD 40 years ago, the focus of his work has been on specific facilities like the San Miguel power plant and the effect they're having on the quality of the environment and water systems around them. And also looking at how liner systems could be designed in those facilities to contain wastewater and prevent releases into the environment. He's done this work, Your Honor, as a consultant at one of the nation's preeminent consulting firms. And he's been involved as a design engineer over the years on a number of projects that have involved the construction of liners, either in ponds or landfills. His relevant experience includes assessment of the performance of existing waste management facilities, like San Miguel's ponds, under state and federal standards. He's worked at dozens of sites with many, many ponds where there were natural soil liners used in the ponds. He has experience with clay liners at numerous facilities and has actually modeled the performance of clay liners. He's provided professional services at land disposal facilities that manage CCR in landfills with natural in-place clay soils acting as the liner. He's been involved in the technical review on behalf of government agencies of permit applications related to pond liner design, liner construction, and potential impacts on groundwater. Powell has gained experience with industry practices and standards from working as a consultant for multiple power companies that used clay or soil-lined waste management units to specifically manage CCR, such as Duke, Myrant, Constellation Energy, and Southern California Edison. He did a project, Your Honor, for a power generation company where there was a wastewater pond with a natural clay liner, just like at San Miguel, and he assessed the performance of that liner and negotiated with the state government on reconstructing the pond liner. Again, Your Honor, the key is that the expert have specialized knowledge as to the issue that they are actually giving opinions on, and that is undoubtedly the case here. Your Honor, you also heard opposing counsel question Dr. Powell's qualifications and the reliability of his opinions because he evidently or allegedly isn't familiar with Texas laws regarding solid waste disposal. I'd like to start by just providing a little bit of context here. Your Honor, engineers and consultants are regularly called on by companies to help them specifically understand the technical requirements of rules adopted by government agencies. Even lawyers hire consultants like Dr. Powell to translate the technical requirements of rules adopted by government agencies. And Powell has experience with the regulatory framework that applies to ponds like San Miguel's that manage non-hazardous waste. As Powell said in his report and deposition, he has over 40 years of experience as a practicing consultant in non-hazardous waste management under federal in analogous state regulations. He's been interfacing with regulators on government requirements for his entire career. In the course of his work for this assignment, Your Honor, in assessing whether San Miguel's design and construction of pond liners in the distant past, decades ago, complied with then applicable regulatory standards, he researched regulations that would have applied 40 years ago. That's something any competent expert would do for a historical assessment. To do this, he in part relied on descriptions of regulatory standards and historic documents written by professionals who were working at the site back then, or actually written by the government regulators who were in charge of the ponds, regulating the ponds at the time, or written by independent consultants preparing reports and certifications for compliance with Environmental Protection Agency rules. These historical documents include information on the regulations applicable at the time of construction of the ponds, including specific information from the government agencies that had jurisdiction over the ponds. Your Honor, information on regulatory standards from the government regulators who adopted those standards, that's a reliable source of information. PAL has the training and expertise and experience to take technical standards embedded in rules and compare them to engineering documents for things like construction of ponds and draw conclusions. That's what he did here. He combined that research into the applicable regulatory requirements with his review of engineering documents and his own experience for several dozen similar facilities that operated during the same time period to develop his opinions comparing the San Miguel pond liners to the then applicable standards. And for what it's worth, Your Honor, for reliability purposes, note that the appealers in their response motion that was filed on Friday confirmed that PAL's opinions on legality in conformance with regulatory standards are correct. They stated, quote, "The experts agree that the pond liners were legal when installed." Now, Your Honor, the appealers in opposing counsel seek to exclude PAL on the basis of him not knowing on the spot in his deposition what the Texas solid waste rule is. I objected to those questions, Your Honor, in the deposition for a reason. It's extremely vague. I've been practicing environmental law for over 10 years, Your Honor. I was sitting in the deposition. I didn't even know what opposing counsel was referring to. It turns out that was for a specific reason, Your Honor. It was not until the reply was filed by the appealers on last Friday that the appealers revealed that by solid waste rule, they were referring to Chapter 361 of the Texas Health and Safety Code, which is called the Solid Waste Disposal Act. And so when opposing counsel referenced the solid waste rule in Dr. Powell's deposition, and then again in their original motion to exclude Dr. Powell, it turns out they weren't referring to a rule at all, but to a statute called the Solid Waste Disposal Act. This completely discredits the game of gotcha that opposing counsel was trying to play during Dr. Powell's deposition. And regardless, it misses the entire point. He's qualified to take the technical standards embedded in rules and compare them to engineering documents to draw conclusions. This is what he's done his entire career. You also heard opposing counsel say that Dr. Powell couldn't say which Texas agency regulated solid waste in the past. That's on page 8 of their reply motion, Your Honor. They specifically cite to page 77 of Dr. Powell's deposition to make this point. But if you actually go read page 77, what he said is that he addressed who regulated the ponds and the liners at that time. He addressed that in his actual expert report. And he also said that he recalled that it changed over time. He recalled that it was the Texas Department of Health and later that it was the Texas Department of Water Resources. Opposing counsel completely omitted this in today's argument and also when citing and quoting page 77 in their motion to exclude, Your Honor. Another point, Your Honor, opposing counsel attempts to discredit Dr. Powell by saying that he assumed that the state had issued a permit for these ponds, but in fact, no permit existed. Your Honor, may I share my screen with you?
Yes.
Your Honor, I'm on the Texas Commission on Environmental Quality's website. Do you see this?
Yes.
And if you scroll down with me, Your Honor, on the right-hand side, you can see a description. It says Ashwater Transport Ponds. You see that, Your Honor?
Yes.
And you see that the state has given a registration number for these ponds. The state has registered these ponds, Your Honor. In addition, as you can see, where the state has classified these ponds as permitted non-hazardous industrial units. I'd like to show you one more document, Your Honor. May I share my screen with you?
Yes, y'all don't have to ask permission. Just go ahead.
Your Honor, this is one of the historical documents that Dr. Powell relied on in drawing his opinions. As you can see from the top of the page, it's a 1979 document from the Texas Department of Water Resources. And in the letter that the Texas Department of Water Resources wrote to San Miguel, the Texas Department of Water Resources has described the technical specifications and the rules at the time, such as 3 feet of clay-rich soil as a liner. Your Honor, you'll see there's a permit reference here. And in fact, the Texas Department of Water Resources concluded, please be informed that we consider the permit provisions concerning pond lining requirements as having been accomplished. Your Honor, here we are today. The peelers put the pond liners at issue in this case. San Miguel was compelled to hire an expert witness to address the allegations around those ponds and their liners. And now opposing counsel has asked you to disqualify Dr. Powell. And it's asked you to do so based on facts that are simply wrong. Your Honor, the opposing counsel today also stated that Dr. Powell's opinions aren't reliable because he didn't conduct any of his own testing. Just want to redirect your attention to Texas Rule of Evidence 703 that says an expert may base an opinion on facts or data in the case that the expert's been made aware of, reviewed, or personally observed. In the Southlands case out of the San Antonio Court of Appeals, Your Honor, where an expert was authorized to rely on facts or data contained in a different report informing his own opinion as to the evidence examined. That he didn't do any independent testing, whatever that means, is completely irrelevant under the Texas Rules of Evidence. And the peelers don't even say what testing should have been done. Their own experts didn't do any testing either. The opposing counsel also says that Dr. Powell only relied on documents that were cherry-picked by counsel. Your Honor, other experts in Powell's field would reasonably rely on historical documents informing an opinion on whether a decades-old structure was constructed in accordance with applicable standards. He relied on an extensive set of historical documents collected by an independent consultant in 2016 for the specific purposes of complying with EPA regulations. That represents the entirety of the known historical record on the original pond design and construction. The plaintiff's expert, Mr. Johnson, looked at the same documents in reaching opinions that contested certain aspects of Dr. Powell's conclusions. These materials were not cherry-picked, Your Honor. They're posted to the website that the Environmental Protection Agency requires San Miguel to maintain for compliance purposes. Your Honor, they took Dr. Powell's deposition. They didn't put any new documents in front of him that had any relevance to his opinions in this case. Opposing counsel also suggests that the records were somewhat incomplete, and so Dr. Powell just had to guess. As an initial matter, Your Honor, I just would say that gaps in 40-year-old documents are to be expected. That's sort of the nature of the beast. But with respect to the idea that the record was somewhat incomplete, note that Powell was specifically referencing records with respect to the mechanical process used to form the liner, not the material of construction, thickness, and permeability of the liner. That's addressed on page 8 of his expert report. And in particular, during his deposition, Dr. Powell clarified that it wasn't necessarily that any records were missing, but only that there's relatively less information for the original construction project in the 1970s as compared to the relining project from the more recent 1980s. Regardless of all of that, Your Honor, Dr. Powell testified that he followed up to ensure that he had the complete file of available documents. And he also testified during his deposition that he reviewed everything he felt he needed to support his opinions. In fact, Dr. Powell directly took head on the idea that he was speculating. In response to question from opposing counsel in the deposition, he said he wasn't speculating and he was reviewing the historical documents, the contemporary documents that were written about the project at that time, and applying his knowledge as a practicing engineer as to what those descriptions mean. Quote, "That is not speculation," end quote. The opposing counsel also questioned the relevance of Dr. Powell's testimony as not being relevant to any claim or defense in this case. Their argument is not consistent with their pleadings, their experts' opinions, and even their own motion to exclude Dr. Powell. Let me explain. In their pleadings, the appealers have characterized the ponds as little more than giant holes in the ground. Expert testimony that the ponds actually contain constructed clay liners to rebut this assertion is relevant to the jury's understanding of the appealer's characterization and the actual facts and evidence. The appealers also have asserted a cause of action for negligence, and the applicable standard of care is an element of that claim as it relates to the nature of any duty that San Miguel owes to the appealers. I'll read to you paragraph 273 of their pleadings. San Miguel, Kiewit, and Steck created a dangerous condition by failing to exercise reasonable care in its handling, treatment, storage, transportation, and disposal of coal ash and other solid and hazardous waste and wastewater, and this condition resulted in injury to the Peeler Ranch. And in their motion to exclude, Your Honor, the appealers acknowledge at page 4, quote, they contend that inadequate lining systems at the bottom of the ponds have contributed to their alleged injuries. And of course, Dr. Powell's testimony and opinions, Your Honor, go directly to whether or not the lining systems were adequate or not. Texas courts have held that the applicable standard of care is the subject of expert testimony when the alleged negligence is of such a nature as to not be within the experience of a layman. Current and historical design and construction standards for CCR impoundments are not within the experience of the layman, Your Honor. The applicable standard of care is typically based on practices, procedures, and industry standards, just as Powell has evaluated here. Also note, Your Honor, that appealers have asserted a breach of contract claim, and that relates to whether there's been permanent damage to the area surrounding the power plant. So Dr. Powell's testimony and opinions on the new reconstructed pond liners and how those new liners will effectively perform, of course, that relates to the appealer's claims. And don't forget that as damages, the appealers are seeking a special kind of liner system that exceeds government regulations. Powell's testimony that this sort of special liner system would provide minimal additional protection will be relevant and helpful to the jury. A couple of last points, Your Honor. You heard the appealers today say that Dr. Powell's opinions are not reliable because he didn't consider surrounding groundwater deterioration in forming his opinions on the quality of the liners. Specifically on page 15 of their motion, Your Honor, they say that, and they said that today in argument as well. If you were to go 2 pages later in their motion to page 17, they quote Dr. Powell's deposition, where he said that groundwater monitoring at the site showed that there had been an impact on groundwater. So which is it, Your Honor? They can't have it both ways. Either he didn't consider groundwater deterioration or he did. They present it both ways in their motion. In fact, the testimony cited proves that he took a holistic view. And Your Honor, the contradiction here in the appealer's argument brings up an important point that actually illustrates Powell's value to the jury. As Dr. Powell testified in his deposition, it's possible that the liners were constructed properly and still may have developed a seep, because that's an inherent aspect of that type of a design. Clay is not permeable, Your Honor. Now, federal rules, new rules that EPA published in recent years, are designed to address the realities that older clay technology may result in seeps. In fact, Powell includes information in his report on the number of power plants across the country that have had seeps and that are retrofitting their liners with newer technology accordingly. This is important context for the jury on industry standards and how San Miguel compares. But the bottom line is that Powell's opinions on the construction of the pond liners in conformance with the industry standards do not require him to get into the details on groundwater monitoring or to calculate how much water may have seeped out of the ponds over time. That's left for other experts. Mark Hemingway, for example, is another one of San Miguel's experts. He takes on issues like that. Those topics are unrelated to PAL's opinions in the end. Now, last point here, Your Honor. Opposing counsel suggests that with respect to Dr. Powell's opinions 4 and 5, which specifically relate to the reconstruction, the ongoing reconstruction of the pond liners, that he doesn't have enough information to draw opinions and conclusions about the current projects. Specifically, they contended today that the only documents he looked at was a couple of snips from Mr. Kezar's deposition testimony. Page 4 of his expert report, Your Honor, shows that Dr. Powell reviewed the engineering drawings from Newfields for the retrofit of the ponds. You were told today, Your Honor, that he didn't look at engineering documents. In fact, he did. In fact, Ms. Whittle asked about those engineering documents in the deposition on page 199 of the deposition. And he said, I did look at the Newfields reports about the liner design or the reconstruction of the ponds with the new liner. So again, Your Honor, you were told today that he only looked at Mr. Kezar's deposition. In fact, he looked at much more. He looked at the specific engineering and bid documents that opposing counsel suggested to you today he didn't look at. And last, Your Honor, opposing counsel suggests that with respect to his opinion 5, Dr. Powell is not qualified to say that a double liner system, which is what's being recommended by the peelers, isn't needed because he doesn't know if future operations with different types of equipment at the plant may puncture the liners. Of course, his focus is on the construction and design of the liners and whether those liners will be effective. Hypotheticals about future operation put forward by the peelers is irrelevant to his opinions on the performance of pond liners. Even so, Powell discussed these issues with opposing counsel during his deposition. He reviewed the plant manager's sworn deposition testimony on how San Miguel operates and cleans out the ponds. And when presented with a complete hypothetical about how San Miguel might clean out the ponds in the future, literally opposing counsel on page 209 of the deposition transcript asked him to assume certain facts and whether under that hypothetical there could be problems with differential pressures. You heard Mrs. Whittle refer to differential pressures today across the liners. He said there should not be a problem with stresses on the synthetic liner that San Miguel is installing right now on those ponds. He said he's had many opportunities to look at the geomembrane material that's being used. He's also had an opportunity to look at samples of it. And that is a very dense and durable material. And that's why, Your Honor, it's called high density polyethylene. He also said that there shouldn't be problems with stresses on the underlying clay liner either, because it's been operating under full loads for 30 years now. And as such, quote, the clay is likely not going to expand as a result of that and cause any kind of undue movement. Your Honor, Dr. Powell is qualified. He has a long distinguished career looking at pond liner systems and waste management units across the country. His testimony is reliable and relevant. His understanding of industry practices and how they've evolved over the last 30 to 40 years since San Miguel originally installed these ponds will be helpful to the jury. And I ask Your Honor for you to deny the peeler's motion.
Anything from Mr. Guthrie, your firm?
I'm sorry, Your Honor, I was muted. No, nothing on that.
Mr. Butler?
No, Your Honor, we stand with San Miguel.
All right. Very, very briefly, Ms. Whittle.
Yes, Your Honor, just to show you what the registration for solid waste disposal has on it. Oops. Just want to share my screen with you. So here, Your Honor, this is the actual registration that Mr. Holcomb was referring to, and you'll see right here, it very clearly states, this is not a permit and does not constitute authorization of any disposal facilities listed below. In other words, They were exempted from permitting requirements, but they did have to register the waste disposal units. And this is a registration. It's not a permit. Just to reiterate, Your Honor, Dr. Powell's opinions about whether liner construction in the 1970s conformed to then existing standards is irrelevant to any material issue in dispute. We concede that the liners were installed in conformance with the regulatory standards, which was to exempt this disposal. I don't know what more to say than that. It's not a material fact in dispute. And Dr. Powell doesn't go beyond that in his opinions. He does not look at operations of the ponds over time and how the liners actually performed. That is not part of his opinion. When I asked him about that, he said, no, it hasn't been effective. No, it has actually caused leaking. So also, Your Honor, even if it was relevant to any material issue in dispute in this case, Dr. Powell is not the person qualified to opine on it. Dr. Powell is qualified to opine on other issues in this case. And I spent a lot of time in his deposition asking him about, are you planning on testifying about A, B, C, D, E, F, G, and each time he said no. So all the areas on which he is qualified to testify for, he has not been designated and will not be offering opinions on those issues. But for this issue, the geotechnical aspects of liner design and installation, he is not qualified. And so for whatever reason, they designated someone who is not qualified to testify as to this specific issue for which he's been designated, nor is he qualified to testify as to the Texas regulatory standards. I didn't just ask him about the Texas solid waste rule. I then went into the details. Do you know the general prohibitions? He didn't know what that was. Those are all things that, again, any environmental person who works in the state of Texas would know what those are. And Mr. Hemingway certainly did when I asked him about them. So to the extent that doing research on regulatory standards is sufficient to make one an expert, here his method wasn't reliable because he was wrong. His conclusions were wrong. His assumptions were wrong about the regulatory landscape, which demonstrates that he just isn't qualified and his methods weren't reliable. And just to further reiterate, he is not, his testimony about the historical records being incomplete, that was his testimony, that they were somewhat incomplete, and he didn't have enough information so that he had to make assumptions about how it was built. And his assumptions were predicated on the idea that the state of Texas could have stopped them if the state of Texas had wanted to. So he didn't have the historical record. He made assumptions based on the lack of violations issued by the state of Texas. And yet he didn't know that actually the state of Texas didn't regulate such things. So his whole foundation of his opinions is based on speculation and assumptions and is not reliable. And that's the same with respect to how San Miguel is going to install its new liners. He did say that he had seen the bids by one bidder for the retrofit, but he didn't know who had been chosen. He'd never spoken to them, and he certainly doesn't have any actual engineering or as-built drawings, nor has he gone to look at it. I think anyone who has put in a bathroom knows that you might have some great ideas about what it's going to look like, but when you pull the tiles back, everything changes. So he cannot make speculation and assumption about what San Miguel is going to do in the future to comply. when he hasn't made any effort to figure out any of that out. So in sum, Your Honor, we ask that his opinions be struck in their entirety. Thank you.
Your Honor, may I just say one quick thing?
Yes.
Just as an initial matter, for the purpose of saving time here, I'm just going to say I disagree with the characterization just given of his deposition testimony. To the extent there's contested facts, they should ask those in cross-examination. They're not a basis for exclusion today. He specifically said in his deposition that he was not speculating. Quote, "That is not speculation." He said he had all the documents he needed to support his opinions, period. And as a last point, Ms. Whittle just said that he doesn't have the engineering drawings for the retrofit project. Literally listed in his expert report are the engineering drawings from Newfields. He absolutely has those. And opposing counsel is just flat wrong on that point. Thank you, Your Honor.
Okay, we'll come back at 3:05 and then we'll start on the coal company's motion to exclude.
Yes, Your Honor.
Okay, and who's going to argue the coal company's motion?
I will be arguing, Your Honor. This is Stephanie Noble on behalf of San Miguel.
Noble, with an N or a K?
With an N.
Okay, thank you.
Noble.
And this is Cody Schneider, Your Honor, that'll be arguing on behalf of Kiewit Mining Group.
All right. And are the peelers ready?
Yes, Your Honor. I'll be arguing for the peelers.
Go ahead, Ms. Noble.
Thank you, Your Honor. The peelers have asserted a number of different categories of damages in this case, and they have designated two different damages experts. One is Mr. Bolton, and he is their appraiser, and he is opining regarding the decrease in property value of the peelers' property, and he's opining about $36 million in damages. We're here today regarding the peelers' other damages expert, Mr. Carl Killian, and Mr. Killian opines on three separate categories of damages. He has a category of damages related to the surface damage payments that are due under the mining lease. He also has a category of damages related to the peelers' investigation costs. And then the third category of damages, and the largest category of damages for Mr. Killian, are the remediation and reclamation costs that he has calculated that he's intending to require San Miguel, STEC, and KMG to pay in this case. And this motion, our motion to exclude the opinion testimony of the peelers expert, Mr. Killian, relates to only that third category of Mr. Killian's opinions related to the remediation and reclamation costs. Now, Mr. Killian has tallied up over $102 million in remediation and reclamation costs. And Mr. Killian is not a technical expert. In doing this work, Mr. Killian took proposed reclamation steps that the peelers' other experts came up with, and then looked at those same experts to look at their opinions to assign costs to each of those steps. And then Mr. Killian assigned percentages to those costs and then tallied up the total amount that he claims are the reclamation and remediation damages. This motion concerns the underlying costs which form the foundation of Mr. Killian's entire assessment. There is no support in Mr. Killian's report for those underlying costs or in the work of any of the other peelers experts. Without the required support for the underlying critical assumption for the entire cost estimation exercise, the entire model is faulty and unreliable. That failure to provide support for the underlying data on which the expert's opinion is based is fatal to the admissibility of that opinion. But it's particularly glaring here where the peelers seek remedial damages, because in Texas, the law is clear. A party seeking remedial costs must show that those costs are reasonable and necessary. And there is simply no support whatsoever that these costs that they're claiming are reasonable and necessary. Now, the reasonable and necessary damages standard has been repeated by the Texas Supreme Court multiple times, including in the Mustang Pipeline case, which we cited in our brief, and the Cnty v. Hennon case, which came out in 2012. That's cited in both of our motion and our reply, but for the court's reference, it's 372 Southwest 3rd, 625, and that opinion came out in 2012. There, in the Texas Supreme Court in McGinty held that a party seeking to recover remedial damages must prove that the damages sought are reasonable and necessary. And courts across the state, including the San Antonio Court of Appeals, have applied that standard in a variety of cases. The San Antonio Court of Appeals in the GATX Tank Erection Corp v. Tesoro Petroleum Corp case applied that in a deceptive trade practices case, where the plaintiff claimed damages for repairs required for oil tanks. And McGinty and Mustang Pipeline, the two Texas Supreme Court cases I was just referring to, for holding this standard, the reasonable and necessary damages standard applied, they relied on an older Texas Supreme Court case, the Dallas Railway v. Gossett case, which originally held that a plaintiff in a personal injury case that was seeking...
Okay, and I'm sorry, I need to take a...
see what else. That's pretty much it, Consuelo.
Okay, I'm sorry, I'm back.
Okay, may I proceed, Your Honor?
Yes.
Okay. I was discussing the Dallas Railway v. Gossett case, which was a 1956 decision from the Texas Supreme Court that was cited by both the Cnty Court and the Mustang Pipeline Court for the underlying assumption that remedial damages must be reasonable and necessary. But the Dallas Railway v. Gossett case was a personal injury case where the plaintiff sought medical fees for injuries that she sustained during a rail car accident. Now, this standard has been applied to analyze the reliability of expert testimony, specifically in the Ergon Energy Partners v. Sheffield case, which we cited in our reply brief. The Beaumont Court of Appeals applied the reasonable and necessary damages standard to determine whether an expert's opinion in an oil and gas contamination case was reliable. In that case, the landowner sued its oil and gas lessee, and the jury returned a verdict which adopted the remediation costs provided by the plaintiff's expert. But the verdict was overturned by the Court of Appeals because the court found that the expert had not provided any support for the reasonableness of the projected costs. The court noted that the expert did not opine, or that the projected costs that he opined us to were not reasonable in amount, either as a whole or as component parts. In reaching its decision, the court cited the Cnty decision, which we've already discussed from the Texas Supreme Court, for the proposition that remedial damages must be reasonable and necessary. And the court also cited expert admissibility cases such as City of San Antonio v. Pollock, another Texas Supreme Court case, which held that to be considered probative evidence, the law requires that the basis of an expert's opinion be revealed to show that the basis of the opinion is supported by evidence. The court also cited the Texas Supreme Court case in Kerr-McGee Corp v. Helton, the 2004 case, for the proposition that the record must contain sufficient data to show that the expert's projection for the total cost of the project represents a reasonable sum for a project of that type. Similar to the situation in Ergon, there is simply no support at all that Mr. Killian's $102 million estimate is reasonable. So what did Mr. Killian do? As I explained at the beginning, Mr. Killian is not a technical expert. He relied exclusively on the Peeler's other experts for determining what were the steps for the reclamation and remediation plan that he was going to cost out. And then, in determining what those costs actually were, he looked again to the Peeler's experts, primarily Mr. Gordon Johnson of Burgess Environmental. And then Mr. Johnson relied on Aqualogic. And Aqualogic is the company where Mr. Anthony Brown works, another of the Peeler's experts. So there's a lot of finger pointing among the Peeler's experts as to who the various experts are relying on for these costs. But what we don't have is the underlying support. There's no documentation whatsoever. And I think the best way to do this is to walk through the spreadsheet that Mr. Killian produced in connection with his report. So Mr. Massington, could you please pull that up for me? Thank you. Your Honor, can you see my screen?
Yes.
Okay, thank you. This is the document that was produced to us in connection with Mr. Killian's May 11th, 2020 supplemental report. And this is the summary page. Tony, if you could just scroll down a little bit so we can show the judge how this exactly was produced. I want to show the tabs at the bottom. I
can see the tab.
Oh, you can see it. Okay. I just can't see it on my screen. So This was produced to us in a spreadsheet format, and this is the first tab that shows the summary of Mr. Killian's estimations. And you can see there's 4 categories or 4 areas for which he's estimated these remediation and reclamation damages: the impacted ranch area, the mine area, the power plant area, and the site-wide. And we'll come back a little bit later to the power plant area. And for support for these numbers, he has a number of different tabs and that lead to different spreadsheets. So let's go to the remediation cost tab, please, Tony. And both San Miguel and the Peelers refer to this page of the spreadsheet in their briefing on this matter. But as we look through the remediation costs tab, we can see there's certain activities listed in the most left-hand column under the remediation activity column, and then there's costs in unit, and then a unit column, and then there's a column listed as source. And if we kind of scroll down through this tab, we can see that the majority for the entries are sourced as the unit cost summary. And I just want to point out a few of these. We're already at the bottom, so I'll point out under the water treatment grouping, under the site-wide column, there's a cost unit for over $8 million, $8,350,000, a one-time fee, and the source is unit cost summary. And if we move up a little bit, Tony, under the groundwater controls and monitoring section, there are 2 entries there. Install extraction wells, $70,000 per well. That's sourced for the unit cost summary. Groundwater monitoring, $250,000 per year. That's sourced at the unit cost summary. And if we go up a little bit further, Tony, please. There's a few entries related to release treated water to La Parita Creek, $10,000 per event for the unit cost summary. And if we go up even further, there's a pilot test at the very top. I believe it's the first, right, under the contaminated soil management. There's a pilot test for $50,000 per event, and that's also sourced to the unit cost summary. Essentially, Mr. Killian takes all of these costs and uses it to tally up his ultimate $102 million calculation for reclamation and remediation costs. But the question that we have is, where do these underlying costs come from? So, Tony, if you would mind, please, turning to the unit cost summary tab.
Okay, that's a bit small. I can't read that.
Right, we're going to zoom in a little bit, Your Honor. Thank you. I just wanted to make one broader point about this chart first before we zoom in on the text itself. That this chart is copied and pasted almost entirely from a similar chart in the report of Gordon Johnson from Burgess Environmental. So this is just copied and pasted directly into this spreadsheet. And if we look in a little, zoom in a little bit, Tony, and we can see that there's items and activities again on the left-hand column, and then a column for Golder 2018 plus 2% escalation, Aqualogic, and then there's a column recommended, which includes some notes there. And we're going to see, and again, I mentioned that Aqualogic is the name of the consulting firm where the Peelers expert Anthony Brown works. So if we look at the items that are listed in the left-hand column, we're going to see a lot of the same activities that we saw in the remediation cost summary tab. For the water treatment capital item that's listed there in row 17, there's the over $8,350,000 cost that we saw on the previous tab, and it's listed under the Aqualogic column. If we go down to row 20 for groundwater monitoring per year, there's the $250,000 estimate that we saw in the remediation cost tab. It's also under the Aqualogic column, as well as the 2 following, the water discharge release in row 21 and in row 22, the soil treatment pilot test. Those estimates also are sourced to Aqualogic, and the recommendation is to use the Aqualogic number based on experience and professional judgment. And if we scroll up a little bit, Tony, just to see. Most of these are, the recommendation is to use the Aqualogic number. In none of these, unit cost is the Golder figure adopted outright. And so this is the basis, this is what we have to explain the very unit costs that are the very foundation and are the inputs that Mr. Killian put into his model to then calculate $102 million in remediation and reclamation costs. Thank you, Tony. You can take that down. Each material part of the expert's opinion, of any expert's opinion, must be reliable. The Peeler's experts all rely on each other, but don't support the costs themselves. Killian says he relied on Gordon Johnson, and that's clear where he copied and pasted the chart from Mr. Johnson's report and put it into his spreadsheet that is now the unit cost summary of his spreadsheet that he sourced for the remediation costs, which then he used in his calculation. Gordon Johnson says either I don't have any documentation for these costs that I've estimated, or he says I relied on Aqualogic. But Mr. Brown from Aqualogic says that he didn't talk to Mr. Killian at all or provide any help to Mr. Killian in preparing these unit costs. And so I'd like to show you Mr. Johnson's deposition. Tony, if you could please pull that up. And this is page 230 of Mr. Gordon Johnson's deposition. And I'd like to focus on 230, right, the highlighted portion, starting on line 20. Mr. Johnson was asked, I didn't find any backup for those cost estimates in your file materials. Does that exist somewhere and I just missed it? Answer, no, they're my reasonable estimates based on my experience. And then if we go to the top of the next page. Question, so it's just sort of came out of your head based on your experience. Answer, it came from my experience, yes. Question, and there's no document that I can go to, you know, check to see the basis and sort of truth test what it is that came from your experience, right? Answer, there's no document for the values that I have included. I can't speak for the ones that Aqualogic provided or Wade and Anthony. Question, so for those particular numbers, if we want to know sort of what the supporting detail is, we would have to talk to Wade and Anthony at Aqualogic, correct? So specifically for those items, that's correct. That's what Mr. Johnson said. And then if we look at Mr. Brown's deposition, Tony, if you could pull that up, please, on page 23.
And Brown, Aqualogic?
Yes, Your Honor. This is Anthony Brown's deposition. He is with Aqualogic. And I'm looking at page 23, starting at line 16. And can you see this, Your Honor?
Yes.
Okay. On line 16, it starts the question, and you haven't provided any cost estimates as to what remediation or reclamation would cost at the San Miguel mine or the power plant to Mr. Killian, correct? Answer, I have not. Question, have you had conversations with Mr. Killian regarding his damages model? Answer, I'm sorry, I do not recall who Mr. Killian is, so I do not believe I've had such conversations. Question, okay, so as you sit here today, you don't recall ever having a conversation with Mr. Killian, who I can give you his whole name. I forget what his first name is, but hold on. Carl Killian with Claro Group. You don't recall any conversations with Mr. Killian as far as his litigation. I met with an individual from the Claro Group during one visit to Peeler Ranch and during a subsequent presentation that I gave to various parties in this litigation, but I cannot recall the gentleman's name. And it would have been during the early stages of our involvement in this matter. Question, and just to be clear, none of those communications would have included a cost estimate or scope of work for what your opinion would be of the necessary remediation reclamation at the power plant and the mine, right? Answer, I do recall that at meeting there was some discussion of remediation and reclamation activities, but I do not recall providing him with any cost information. That's what was discussed in Mr. Johnson and Mr. Brown's depositions. And so what we're left with is a statement from Mr. Johnson that he came up with certain estimates and they're reasonable based on his experience. But he admits there's no documentation for the estimates that he's provided. He says they're reasonable. That's classic ipsa dixit, because I said so, expert testimony that's not supportable under Texas law. It's not admissible. You have to provide the underlying support for what your opinion is. And then Mr. Brown, who both Mr. Killian and Mr. Johnson point to as a major source of this cost estimation data, says, I never talked to Mr. Killian about these cost estimation numbers. So what we don't have, and also, Your Honor, Mr. Brown's report is completely silent as to these unit cost numbers. We don't have anything in his report to support these numbers that are shown in Mr. Killian's spreadsheet that he ultimately uses in his report for these unit costs. We don't have anything to support that. Typically, what you would have from a cost expert is analysis that would employ some industry accepted norm for determining the cost, and then that expert would document the work and provide backup documentation for the estimates. Killian didn't do that. At page 8 of our motion, we cited an EPA study for ascertaining cost estimates. One of the 4 necessary steps for cost estimating is development and documentation of the backup for cost estimates, including the methods and resources for preparing the cost estimate, including vendor quotes, computer models, etc. Killian hasn't done that work. Neither has any of the Peeler's other experts. We raised all of these issues in the motion to exclude Mr. Killian's opinion testimony, so the Peelers had an opportunity in their response to direct the court to the support for the reasonableness and necessity of these costs. They didn't do that. They claimed, 1, that the reasonable and necessary standard doesn't apply here. That's incorrect. As we've discussed, Texas law is clear that for remedial damages, the party seeking those damages must show that the damages are reasonable and necessary. But 2, they claim, or in their response, they don't dispute that Mr. Killian has not opined at all as to the reasonableness or necessity of the unit costs themselves. Instead, they point to 1 paragraph of Killian's report that they claim supports the entire supposed reasonableness of the entire $102 million assessment. And Tony, if you wouldn't mind pulling up page 10 of the Peeler's response, please. So the paragraph in the middle of the page, this is the paragraph for Mr. Killian's report that the Peelers put a lot of weight on now to support the supposed reasonableness and necessity of the $102 million in remediation and reclamation costs that Mr. Killian has estimated. But if we look at this paragraph, it doesn't support that weight. But because of the importance that the Peelers place on this particular paragraph, I think it's important to break it down a bit. So the first sentence says, the Claro's analysis is consistent with the principles contained in the National Contingency Plan in terms of necessity, reasonableness, and cost effectiveness of remedial options. We have not included extreme or certain high cost, yet realistic and possible cleanup options in our damages analysis. All remedial option scenarios included in Claro's analysis are believed to be technologically viable and preferred among other less effective or higher cost solutions. First, it's important to recognize here that, or it's important to note here that Mr. Killian recognizes the importance of considering necessity, reasonableness, and cost effectiveness in preparing a cost estimate, yet he provides no analysis with respect to those concepts. And this statement is entirely conclusory. Again, this is without support. It's plainly ipsa dixit, because I said so type of testimony that's not permitted. Second, this paragraph says nothing about unit costs, not to mention the reasonableness and necessity of those costs. And again, it's the unit costs that make up the very foundation of the entire $102 million house that Mr. Killian is intending to apply it on. That's his damages model. It's entirely based on these underlying cost estimations. And with respect to this paragraph, Mr. Killian is discussing the use of various remediation activities and scenarios. Again, not the underlying unit costs. But finally, if you take—
I'm sorry, would you repeat that?
Oh, sure. Yes, Your Honor. What Mr. Killian is talking about here in this paragraph are the actual remediation activities that are a part of his model.
Okay.
So what he's had to do in this case is, or what he's been asked to do, is to take what the other peelers experts have opined to be the reclamation and remediation steps that they would like to see done on the peeler's property, and that he's assigned costs. And so what he's talking about here about including extreme or certain high cost cleanup options are the actual remediation steps that are being opined on by the peeler's other experts, primarily Mr. Johnson. And then he's also referring to all remedial option scenarios. Again, those are the actual steps of reclamation and remediation. He's not referring to the underlying unit costs that he's used to cost out all of these steps. But finally, if you take the peelers at their word, that this paragraph means that Mr. Killian, intends to opine that his entire damages assessment, the $102+ million in costs, is reasonable, even though that's not what this paragraph says. That is the classic analytical gap between the underlying data and the ultimate opinion that renders expert opinions inadmissible. Because the very foundation of his entire model are the unit costs. If there is no support for the unit costs, then they aren't reliable. Without that critical foundation, the entire house falls. One final point, Your Honor. Texas law with respect to the standard for remedial damages is clear. Repair costs must be reasonable and necessary. And the reason, the intent behind that rule, and really for any damages standard, is to make the plaintiff whole. Otherwise, it turns damages into punitive damages rather than true compensatory damages. The concept is critically important to apply here. To illustrate this point, and actually, Tony, can we pull up the summary page of the spreadsheet, please? I mentioned at the outset about the power plant area that's listed on the summary tab. Okay, so Mr. Killian is intending to, or seeks to opine that there are over $21 million in remediation and reclamation costs related to the power plant area. At his deposition, Mr. Killian explained that the power plant area is actually the property where the power plant sits. That is land that San Miguel owns. So Mr. Killian has assessed over $21 million that he claims the movements here should pay the peelers for remediation activities that are going to occur on the power plant area. So essentially, Mr. Killian is proposing to pay the peelers for remediation work on land that the peelers do not own. That's not proper remedial damages at all, but it certainly doesn't represent costs that are reasonable and necessary to repair the peeler's land, because the land he's talking about here with the power plant area isn't even owned by the peelers. Because Killian's work fails to adhere to the applicable standard for remedial damages, it's irrelevant. And because there is absolutely no support for the underlying cost assumptions that make up the foundation of his entire analysis, his methodology is fatally flawed and unreliable. For these reasons, we ask the court to exclude Mr. Killian's opinions related to damages for remediation and reclamation costs. Thank you.
Okay, Ms. Whittle?
Your Honor, if I may.
Oh, I'm sorry. Go ahead, Mr. Schneider.
No, thank you, Your Honor. And I'll try to be as brief as possible. I do want to emphasize, though, that what we're talking about here is a cost estimate for reclamation and remediation of over $100 million. $100 million. So Mr. Killian's opinions, his underlying data, and his methodology should be rigorously examined if the peeler is going to ask for $100 million. Notably, with respect to Mr. Killian's opinions, he states in his report that it's limited to just damages, and it's not concerning or regarding liability. So in essence, Mr. Killian is saying he's not stating how much out of that $100 million San Miguel or Stack or Kiewit Mining Group should pay, but specifically that the peelers should just be awarded $100 million. And that's important in light of what the peelers are now asserting in their response. And I'll share with my screen real quick. As the court can see, this is from the peelers' response to the motion to exclude Carl Killian. And they state, in an attempt to counter the reasonable and necessary law by the state of Texas for being awarded remedial damages, that those reasonable and necessary cases do not apply here at all, because there is no case applying the reasonable and necessary requirement to an action for breach of lease. As the court is well aware, and it is undisputed, Kiewit Mining Group is not a party to the mining lease. But yet, the peelers continuously try to assert those contractual or alleged contractual obligations under the lease against Kiewit Mining Group, whether it be with respect to liability or now with respect to the $100 million in damages that they're trying to assert on to San Miguel, Steck, and Kiewit Mining Group here. And I want to share a portion of Mr. Killian's report itself. Here's paragraph 26 of Mr. Killian's report. And this is what he uses before he even reaches his conclusions of the $100 million. The standard for remediation that I've applied in return of the peeler's land to its original and intended use as a ranch land capable of sustaining native species of plants and animals, namely taking care of cattle. This standard is consistent with the mineral lease and lease amendments requirement to restore the peeler's land to as near its original state and conditions as is possible. Again, that's a condition or alleged condition under the mineral lease or its amendments that Kiewit Mining Group is not a party to. Then it goes on to state, also consistent with the restoration standards expressed in testimony from counter defendants' corporate representatives. If we go down to that portion that they cite Derek Brummett and Dave Burris. Neither one of those are representative for Kiewit Mining Group. Again, what they are attempting to do here, Your Honor, is apply alleged contractual obligations on parties for $100 million. And they do that in the sense of saying, well, the court should apply the breach of lease obligations, so therefore the reasonable and necessary standards should not apply. Well, they can't have it both ways, Your Honor. If they want to allege that this is only a breach of lease claim and the reasonable and necessary law doesn't apply, which Kiewit Mining Group does not concede and actually believes it doesn't, that in that situation, reasonable and necessary should still apply. But if they're going to claim that it doesn't apply because it's a breach of lease claim, then they can't recover that $100 million against Kiewit Mining Group. Now, if they're going to move forward and say, okay, this isn't just a breach of lease claim, then in that situation, the reasonable and necessary standard under Texas law clearly applies. And the peelers, with Mr. Killian's opinions clearly do not satisfy that standard. As San Miguel's counsel went into with very great detail and very good detail, neither Mr. Killian, Mr. Brown, Mr. Johnson, or any other expert provides any verifiable or reliable underlying data with respect to these alleged unit costs. And without that verifiable underlying data, there are just gaps, analytical gaps, that make Mr. Killian's $100 million damages model unreliable. And although an expert can rely on other experts' opinions or factual foundations, he has to confirm that those are reliable. It is incumbent on an expert to connect the data relied on and his or her opinion, and to show that the data is valid to support the opinion reached. That's what the decision in Whirlpool, as the Texas Supreme Court decided in 2019 or 2009, said. The data itself has to be valid. But however, there's a gap here. There are huge gaps here. There are three main types of gaps here, Your Honor. There's the gap of what standard should be applied by Killian to arrive to these $100 million numbers and who those should be applied to, if anyone at all. And then there's a gap on where these alleged unit costs came from. And finally, there's a gap of whether these unit costs are reasonable and necessary to award over $100 million. Because of these gaps, Mr. Killian's opinion about $100 million is simply not reliable and shouldn't be admitted as expert testimony in this case, Your Honor. And that's all I have.
Okay. Ms. Will?
Yes, Your Honor. Ms. Carl Killian was retained to provide expert opinions related to the damages suffered by the peelers. Mr. Killian is undisputedly qualified and offers a relevant opinion on the damages sustained by the peelers for the cost to clean up the environmental contamination on their land. To calculate the peelers' damages, Mr. Killian strictly adhered to a promulgated standard methodology relied upon by professionals, businesses, and regulators engaged in the financial evaluation and cleanup of environmental contamination.
And let me ask you, Ms. Whittle, just to assume for a moment that the only question I have is where his numbers came from. He produced a report that says, okay, we're going to have to install 100 widgets out there on the peeler ranch to clean this up. Where did his numbers come from for how much it cost and what it costs to install it and maintain it?
Yes, Your Honor. Let me share my screen with you, and I will go through that same Excel spreadsheet that Ms. Noble went through. Okay, so Your Honor, what I'm showing you now is Schedule B3, which shows the various sources for costs for remedial activities. You'll note that in the coal company's motion, they altered this chart to exclude the 9 cost inputs sourced from Railroad Commission permit application submitted by San Miguel or expert consultants hired by San Miguel. But this is the total spreadsheet. And Ms. Noble did show you the correct spreadsheet today, although their motion misrepresented it. So here, Your Honor, there are 3 inputs that are from the San Miguel permit renewal. And down here, there are 6 inputs from San Miguel's consultant. And if you come over here to the sources, Your Honor, these are the consultant's numbers. These are pulled directly from San Miguel's consultant. And then if you go back to Schedule B3, it has unit cost summary. And the unit cost summary is here. And so here they've got Golder numbers, and then they also have Aqualogic numbers. Some of these are provided by Gordon Johnson at Burgess Environmental, and some are provided by Wade Major at Aqualogic, who is a civil engineer. Both have decades of experience as lead engineers and in cost estimates, and sourced their numbers based on that experience. And I don't know why there was a question about who at Aqualogic provided these numbers. Wade Major did, which I think Mr. Johnson testified to. The fact that Mr. Brown had not spoken to Mr. Killian is of no moment. Mr. Killian can rely on a consulting expert such as Wade Major for his numbers. And some of these numbers, they chose the Aqualogic numbers. Sometimes they chose the Golder number. Sometimes they chose a little bit of both. So it is not true that they didn't just use, that Mr. Killian didn't just use or ever use San Miguel numbers. As you can see from here, he used San Miguel numbers clearly for 9 different inputs. And for the most costly input, Your Honor, which is topsoil, I'll look to another. So this is a comparison, Your Honor, of what they provided you in their motion versus what is actually in Mr. Killian's report. And these highlighted numbers are the ones that are sourced from costs directly or based on unit costs from documents utilized and produced by San Miguel. So it's actually more than what I had mentioned before, but this is based on those unit cost summaries. For topsoil costs, Your Honor, RS Means is a program that San Miguel and the other coal companies suggested was an appropriate place to get unit costs. Well, here we look at RS Means for topsoil costs. It's $37.50 in the San Antonio for topsoil, in the San Antonio area for topsoil costs. And I'll need to stop sharing and I'll go back to my notes, Your Honor. I believe that Mr. Killian used a topsoil number that came from Kiewit, or sorry, not from Kiewit. It was for, okay, so Mr. Killian used a $1.06 cost per cubic yard for backfill and topsoil, which was extracted from the San Miguel mine closure study prepared for San Miguel by Golder. And it takes into account the economies of scale that San Miguel was able to capitalize on by utilizing their large class mining equipment, dozers, excavators, haul trucks, already owned by San Miguel to load and transport backfill and topsoil to the Peeler Ranch. So by utilizing this cost, Mr. Killian accepted that San Miguel's own equipment and soil resources would be available and within close proximity. So had he used the table from RS Means that the coal companies suggest is a reliable remediation cost estimating tool, the damages would be significantly higher in this case. Because soil costs are a significant driver of the costs required to remediate contamination and restore the Peeler property to its intended use as a cattle ranch, had Mr. Killian used the $37.50 rate from the RS Means cost system advocated by the coal companies in place of the much lower unit costs that he used in his model, the total expected value for just that soil placement would be $60 million or higher. In other words, Mr. Killian's calculated damages would be millions of dollars higher, not lower, if he had used the RS Means cost data. So that's just one example where he's using a conservative on the low end of the reasonable range. So to calculate his damages, the Peeler's damages, Mr. Killian strictly adhered to a promulgated standard methodology. He is a qualified expert who provides a relevant opinion based on reliable methodology, and his testimony should be admitted to aid the jury. Mr. Killian is a founding partner and managing director of the Claro Group, a financial advisory consulting firm, and his practice focuses on the economic and financial aspects of complex commercial claims, including the evaluation and management of environmental damages. He has more than 25 years experience as an economic and management consultant and has served as an expert witness in various forums more than 50 times, including matters involving substantial disputed environmental damages. He has a Master of Management with a major in managerial economics from Northwestern University and a Bachelor of Science in Engineering from the University of Oklahoma. He is actually often engaged by Ms. Noble's firm, Vincent & Elkins, and no one has challenged his qualifications to offer an opinion. He provided an expert report, a supplemental report, and deposition testimony regarding damages to the Peelers. Those damages included amounts for San Miguel's failure to pay surface damage, loss of use payments, site investigation costs incurred by the Peelers, and expenses the Peelers will incur to remediate their land as a result of the coal company's mining and coal ash disposal activities.
But only one of those is being disputed, the motion to exclude?
Correct. As I understand it, Your Honor, they're only challenging the costs to remediate the Peeler Ranch. And I'd like to address the case law on which they rely for their motion. They rely primarily on authority that is inapplicable to the determination of reliability and admissibility of expert testimony. Only one of the cases they cite relates to the admissibility of expert testimony at trial. And even that case is off topic and doesn't support exclusion. In fact, the motion doesn't cite any cases in which the testimony of an economic expert like Mr. Killian was excluded as unreliable for any reason. Even the one case cited in the motion that addresses admissibility of expert testimony, and that's Mack Trucks versus Tamez at 206 Southwest 3rd, 572, the Texas Supreme Court warned that its jurisprudence for determining the reliability of scientific expert testimony is not applicable to non-scientific expert testimony related to technical or other specialized knowledge. And that's exactly the type of testimony offered by Mr. Killian in this case, non-scientific expert testimony related to other specialized knowledge. He will not offer scientific testimony as to the presence or causation of contamination on the Peeler's land, or even to what measures are justified by the principles of environmental engineering to remediate the land. Instead, he will apply his expertise on the economic and financial aspects of environmental property damage to offer expert testimony based on financial models that allow for the calculation of future cleanup costs. Mr. Killian performed the financial analysis that will inform his trial testimony using standards established by accepted professionals, business and regulators engaged in financial evaluation and cleanup of environmental contamination. And Mr. Killian, as I showed, adopted many cost figures supplied by San Miguel and its consultants as inputs into his analysis. And just as a reminder, as we're going through these motions on experts, the court's task is not to second guess the expert's conclusions. The court's task is to judge the reliability of the expert's methodology. Mr. Killian has closely adhered to his methodology for calculating damages to the promulgated technical standard for doing so, in both his actual calculation and in the way that he sourced the cost inputs. In this circumstance, that close adherence assures the court that his testimony will be reliable and his testimony should be admitted. Specifically, Mr. Killian applied a probabilistic cost methodology based on a decision tree analysis to determine an expected value of the Peeler's costs to clean up the environmental damage on their land. This method adheres to the industry standard, which he refers to as the ASTM standard entitled Standard Guide for Estimating Monetary Costs and Liabilities for Environmental Matters. The 2011 standard and the updated 2017 standard, which are substantially similar, are attached as exhibits B and C to our response for the court's review. The same methodology that Mr. Killian applied was also used and applauded by the judge in the landmark settlement involving more than $1 billion of environmental cleanup liability in the Asarco bankruptcy in the Southern District of Texas. The court called it the, quote, generally recognized standard for evaluating environmental liabilities. So Mr. Killian does not simply say that the analysis he undertook is based on an industry standard known to him only through his experience. He cites the standard, which is promulgated by the ASTM, and he shows his work in complying with it. This methodology was not created as a unique approach to determine the Peeler's damages without application outside the courtroom. It's been applied in a variety of contexts, and Mr. Killian has applied the same methodology, always relying on input from environmental engineers for hundreds of millions of dollars of environmental cleanup costs in numerous matters involving both litigated and non-litigated claims, in which Mr. Killian's analysis using the same methodology applied in the same way has resulted in millions of dollars of claim settlements over more than 20 years for some of the largest U.S. companies, including several multi-million-dollar liability insurance cash-out settlements for companies such as General Electric. Nowhere have counter-defendants suggested that Mr. Killian does not rigorously and faithfully follow this industry standard methodology. And there cannot be serious dispute about this standard because it is promulgated literally as an announced standard specifically for this purpose. This is not merely a standard that Mr. Killian claims to have inferred or synthesized from his own experience. Yet, counter defendants argue that it violates the methodology prescribed by EPA in its guide to developing and documenting cost estimates during the feasibility study, which is a guide developed for the CERCLA context. Counter defendants offer no evidence or argument whatsoever to explain why the EPA publication for CERCLA cleanups would be applicable to the peeler's damage calculation, and I know Ms. Noble didn't bring it up today during argument. They also offer no evidence that the methodology prescribed by the EPA in that publication is intended to be used to calculate probable costs for specific remedial actions, whereas here, significant uncertainty exists regarding the ultimate remedy and scope of cleanup. The standard used by Mr. Killian, ASTM E2137, contemplates the use of its methodology specifically to quantify costs in the presence of inherent uncertainty. Consistent with E2137, Mr. Killian calculated future environmental remediation costs using the decision tree approach to provide the most accurate calculation given the available information. So even so, Mr. Killian's analysis has in fact met the requirements argued by counter defendants. They argue that a reliable methodology would include project scope definition, identification of individual cost elements, the development and documentation of the backup for those cost estimates, and evaluation of the uncertainties associated with the project. His analysis considers and involves each and every one of these elements, and he's thoroughly shown his work at Appendix B of his report. Even if the court were to reject the standard methodology used by Mr. Killian, his analysis still meets the EPA CERCLA standard preferred by the coal companies. In addition, Mr. Killian's cost inputs comply with the ASTM E2137 standard. To calculate an expected value of the peeler's damages to cleanup, Mr. Killian necessarily and correctly incorporates input costs into his decision tree. The standard allows for those cost inputs to be based on quoted prices, expected values, most likely values, a range of values, or known minimum values. Each of the cost inputs used by Mr. Killian fits one of those methods. The coal company's argument, and Ms. Noble repeated it today, is just to claim that Mr. Killian has no evidence to support the costs associated with each step of the proposed reclamation. But that's clearly not true. Mr. Killian does quite thoroughly show the sources for each of his cost inputs that he incorporated at his analysis at Schedule B, which you have seen. And contrary to the altered and misleading figure presented by them, many of the cost inputs actually come from San Miguel and its own experts. Had they taken the time to understand the basis for Mr. Killian's unit costs and their integration into the cost model, it would have been evident that he did in fact utilize a number of costs sourced from San Miguel documents outright. Also, contrary to their arguments, Mr. Killian may rely on information provided by other experts in the case, including consulting, not testifying experts like Mr. Wade Major. And that would include, because those are the types of information that's routinely relied on by Mr. Killian and other experts in his field, which is allowed by Texas Rule of Evidence 703. So to the extent that counter defendants argue that those sources are not sufficient, their quarrel is not with Mr. Killian, but with the ASTM standard he adheres to, which quite clearly allows cost figures to be based on a much broader array of methods than just the disinterested contractor's arm length bid proposed by the coal companies. They suggest that Mr. Killian must use contractor bids. First, Mr. Killian did not rely on contractor bids or estimates because addressing the extensive contamination at the site has not reached the point of contractors bidding or providing quotes to perform the needed work. Second, Mr. Killian's analysis is well supported by unit costs obtained directly from San Miguel produced documents, as well as unit costs provided by expert in the environmental and remediation field. Some of the costs used by Mr. Killian were provided by Mr. Johnson and Mr. Major, environmental experts with many decades of experience in the field. And if Mr. Killian had relied on contractor bids only, none of those contractors would have to be qualified as experts or tender reports on their bids. And each of those contractors may have some subcontractor bids built into their own bid, nor would Mr. Killian have to show how each came up with their bids or prove it was done in a reliable method. It's the same here. Just because some of the unit costs come from other experts hired by the peelers, Mr. Killian does not have to prove that each of them reached the unit costs in some reliable method. He only has to show that his economic methodology allows him to source the cost inputs in a way that he has done and from the people he has used as sources. Sections 5.4.1 through 5.4.5 of the ASTM standard used by Mr. Killian shows the various ways he can use, he's allowed to determine cost inputs, which he followed. And the decision tree analysis that Mr. Killian used specifically incorporates any uncertainty surrounding those cost inputs, which would be true even if he had gotten bids from third-party contractors. So the decision tree applies probabilities to various costs and outcomes, and the output is a range of potential damages. Mostly we've been discussing the mean of that range, but Mr. Killian's opinion is actually a range of likely cleanup costs. And this is a perfect area for cross-examination. In other words, Mr. Killian's choice of selection between available cost alternatives for incorporation into his model goes to the weight of the evidence rather than the admissibility of the evidence. And the coal companies will have the opportunity to vigorously challenge Mr. Killian's basis for the selections of costs over another one at trial. They have no expert who rebuts Mr. Killian, and they did not present him with any alternate cost inputs at his deposition. In essence, they're asking this court to exclude Mr. Killian based on a made-up rule not found anywhere in the case law and based on a misrepresentation to the court based on Schedule B3. They offer no basis, no standard whatsoever, not even the EPA standard they espouse that would require cost inputs to be based exclusively on contractor bids. The argument is made out of whole cloth. In fact, the US EPA standard that they prefer specifically supports the use of cost estimates based on experience. It states at pages 5 to 6 that, quote, experience with similar projects, including both estimates and actual costs, can also be used as a source of cost data. Mr. Johnson's and Mr. Major's more than 30 years of experience qualifies them to provide pricing data that Mr. Killian may rely on for use in his cost analysis. Finally, although not subject to any express requirement to be reasonable and necessary, much less as a condition of admissibility, Mr. Killian's damages are in fact reasonable and necessary. First, the cases cited by the coal companies in support of their position that the peelers may recover only reasonable and necessary remedial damages, which are Mustang Pipeline Company versus Driver Pipeline Company and McGinty versus Hennon, do not support the exclusion of expert testimony and are not relevant to the court's determination of the reliability or admissibility of any expert's opinion. Instead, they relate to the issue of the sufficiency of evidence to support a jury's findings on damages and are not applicable to the issue of reliability or admissibility of an expert's opinion. Second, these cases do not apply here because, as the Corpus Christi Appellate Court found in First Cash versus JQ Parkdale, there is no case applying the reasonable and necessary requirement to an action for breach of lease. The appellate court affirmed the trial court's award of damages in a breach of lease case and specifically rejected the argument that remedial damages must be proven as reasonable and necessary. In this case, the peelers do bring their suit for breach of lease agreements, among other claims. So the attempts to inject a requirement that the peelers must prove that their damages are reasonable and necessary is not supported by applicable law and doesn't support exclusion of Mr. Killian. But even if
would that be a different rule with Kiewit?
So even if the court were to apply Mustang Pipeline and its progeny to the tort claims, those cases only say that damages must be reasonable and necessary. They don't stand for the proposition advanced by the coal companies that each particular cost input into a damage expert's calculation must be individually proven to be reasonable and necessary. If you compare the language in Mustang Pipeline and McGinty to their motion, the language in those cases is that the damages sought must be reasonable and necessary. But what they're asking this court to find is that each cost input must be proven reasonable and necessary prior to testimony by an expert. In addition, Mr. Killian states that his analysis calculates reasonable and necessary damages based on compliance with specific industry standards. And you saw the paragraph from his report where he states that his damage assessment is consistent with the National Contingency Plan in terms of necessity, reasonableness, and cost effectiveness of remedial options. And just a note on the National Contingency Plan, in order to recoup cleanup costs from other potentially responsible parties under CERCLA, the person performing the cleanup must demonstrate compliance with the National Contingency Plan. So while not required here, Mr. Killian's analysis is consistent with those principles. And the unit costs used by Mr. Killian are reasonable, and in some cases much lower than the market values Mr. Killian could have used for his analysis. And we went over the backfill and topsoil numbers. He used $1.06 versus the RS means number, which the coal companies support, which is $37.50 per cubic yard. That would have extremely increased the total damages in this case. So, Your Honor, what they're trying to do with this motion is convince the court to apply the criteria for sufficiency of evidence on damages. In other words, evidence that showing that the damages awarded were reasonable and necessary to the admissibility of expert testimony for a damages expert. It's well within Mr. Killian's expertise that the damages, So Mr. Killian states in his report that his damages are reasonable and necessary. And he uses a standard reliable methodology to perform his calculation and to determine inputs or costs into that calculation. He follows the methodology totally, and no one suggests that he doesn't. But this just isn't a requirement for admissibility of expert opinion. I'm just going over my notes, Your Honor. Your Honor, if the coal companies really believed their argument that we cannot show our costs of remediation are reasonable and necessary, then they should have filed a motion for summary judgment on that issue and tried to get the costs knocked out. They didn't do that because they could not win it, in no small part because the peelers are entitled to ask for removal of all the coal ash from their property, which would be far more expensive. The Ergon Energy case that Ms. Noble discussed today supports the argument that Mr. Killian does not have to show each individual cost input was reasonable. The court in that case based its holding on the fact that the expert had failed to testify that his estimate for remediation was reasonable in amount. But Mr. Killian in his report specifically states that his damages calculation is reasonable and necessary. In sum, his expert reports and deposition testimony establish that his opinion is based on reliable methodology established by an official standard promulgated specifically for the purpose of calculating the costs to clean up environmental contamination. In undertaking his analysis, he has rigorously adhered to this methodology, and the coal companies do not even attempt to argue otherwise. So we're asking the court to decline to create new law and instead deny this motion to exclude Carl Killian in its entirety. Thank you.
Ms. Noble?
Yes, just a few things very briefly, Your Honor. I wanted to discuss the law that Ms. Whittle was referring to, and then I'd also like to go over the standard that she cited that Mr. Killian used that they referred to in their response. So I'll go over those two things briefly, and I'll start with the cases. The cases that discuss the legal sufficiency of the evidence when a plaintiff is seeking remedial damages, of course, is relevant because they're discussing the relevant standard in those types of cases. And when you're analyzing an expert's opinion, particularly a damages expert, you need to look, what's the relevant damages standard? And here it's whether the damages that they're claiming are necessary or they're claiming they want to do on their property are reasonable and necessary. And that's the link that we're missing here. You have the experts pointing to each other without anyone standing up and actually opining, look, these costs are actually reasonable. And I wanted to briefly talk about and Ms. Whittle did say that we didn't cite any expert admissibility cases in our motion. That's incorrect. And I would actually disagree with her characterization of the Mack Trucks Court, in which I believe she said that in that case, the Texas Supreme Court warned about using jurisprudence related to scientific testimony in the case of non-technical experts. The Mack truck dealt with both scientific and technical and other expert testimony. And in that case, and we discussed this at length in our reply brief, Your Honor, in that case, the court found that no matter the type of expert testimony, the trial court must conduct a rigorous analysis of the underlying assumptions that the expert is using and how the expert ties those underlying assumptions to the ultimate opinion. And that should be done no matter the type of testimony, scientific, technical, or other type of expert that the expert is intending to opine on. And I wanted to also touch on the first cash case that Ms. Whittle mentioned in support of her argument that the necessary and reasonable damages standard should not apply to a breach of lease case. That is not what the first cash case held. In that case, a plaintiff, a tenant, a commercial tenant, sued its landlord for improper termination of a lease. The tenant was a pawn shop, and so the plaintiff had to find another property to build out its business. And it went out, found another unit, and incurred actual costs in building out the new property so that it could conduct its business there. And they had a trial. The plaintiff presented evidence of the actual costs it incurred, and after receiving a negative verdict, the defendant appealed, claiming that the plaintiff had to prove that the damages were reasonable and necessary for these improvements for brand new property. And the court distinguished, in the first cash court, the Corpus Christi Court of Appeals, distinguished McGinty and Mustang Pipeline on the basis that those cases dealt with remedial damages. And in this case, in first cash, they weren't dealing with remedial damages. The plaintiff wasn't asking the landlord to fix or improve the property that they had leased. They had gone to a new property and built out that new property and incurred actual costs. The Ergon case that we cited applies this reasonable and necessary standard precisely how we're asking the court to do it here in connection with expert testimony. And there I explained the Beaumont Court of Appeals looked at the reasonable and necessary standard, asked whether the expert, the contamination damages expert that the plaintiff had put up at trial, whether that methodology was reliable when there was no opinion, evidence, or support that the underlying costs that were being used were reasonable and necessary. That's the same standard we're asking the court to apply here. And I want to turn briefly to the standard that Ms. Whittle referred to that is attached as Exhibit B to their response, and go over that briefly. Tony, could you please pull up the Peeler's response? And let's go to page...
I have it.
I'm sorry, Your Honor?
I pulled it up. Go ahead.
Okay. Page 20 of the Peeler's response is the standard guide for estimating monetary costs and liabilities for environmental matters. This is the standard that Ms. Whittle said that Mr. Killian applied. So if we could go to page 23 of the PDF, please, Tony. Okay, and this is the copy that was attached to the Peeler's motion, and they've highlighted it for the court. And if you could scroll up a little bit for me, Tony, I wanted to get to the paragraph just before expected value. So initially, so section 5.4 explains the detailed description of approaches for estimation. And under 5.41, it states that the most preferred approach is quoted price. When possible, marketplace information should be used to determine a fair market price. We definitely don't have that here. As we explained in our motion, and as Mr. Killian agreed in his deposition, he did not use bids. He did not use contractor bids. And contrary to Ms. Whittle's assertion during argument, that's not what we're claiming is the only basis for determining whether a unit cost is reasonable. That's certainly one way, a commonly accepted way of determining whether costs are reasonable. You get a number of bids and take an estimate or an average of the bids from the marketplace to determine what something will actually cost. But here we have a situation where the underlying assumption, these unit costs, they're not supported at all, and there's no documentation.
And let me ask, there was reference made to a Wade Major of Aqualogic providing numbers for the, whatever the cost sheet is called, the cost summary.
Right. Yes, Ms. Whittle referred to Mr. Wade Major, a consulting expert, apparently from Aqualogic, that gave Mr. Johnson these prices or these estimates that are included in the spreadsheet that has now become a part of Mr. Killian's report. We don't have any backup documentation for Mr. Major's estimate, and now we're asked to rely on his experience. But as a consulting expert, the jury won't hear about Mr. Major's experience. And that is a critical piece of information that we're missing. And then for Mr. Johnson, he provides these estimates and at his deposition said, I don't have any documentation for these estimates. So we're left with just numbers that are included on a spreadsheet without any way to test that. And I wanted to, we went over the quoted price. I wanted to go to the expected value approach, which is the approach that the peelers say that Mr. Killian used. And so that's section 5.4.2. And looking at the first paragraph there, there's a list of a few steps that are required for the the expected value approach to cost estimation. The first is to identify key issues contributing to the magnitude and timing of event costs. The second, develop a decision tree or simulation model of potential event outcomes. And the third, estimate the cost for each potential outcome. Mr. Killian did not do that. He did not estimate the cost for each potential outcome. He looked to someone else to develop those costs, and that's what we don't have the support for. And I'd also like to go down to page 25, please, Tony, of the PDF. And I'd like to blow up 5.10, please, for documentation. And it says documentation should include the identity of the estimator and a description of their relevant knowledge, training, and experience. The estimation documentation should be sufficient for a user to evaluate the estimate. So what we don't have is any information about Mr. Major's knowledge, training, and experience to test that. We certainly don't have the information to test for the user to test or to evaluate these estimates. And there was at one point, Ms. Whittle was talking about, Mr. Killian's comparison and how the costs that he used were within a reasonable, low end of a reasonable range or less than the market value. we don't have the market values for these unit costs. As Mr. Killian admitted in his deposition, he didn't look at contractor bids. We don't know the market price for this, so we can't compare it to market values. And whether it's at the low end of a reasonable range, we don't know that either, because no one expert is opining that any of these unit costs are actually reasonable. And lastly, Your Honor, Ms. Whittle mentioned that that we haven't cited any support for the proposition that any of the individual unit costs must be determined to be reliable. Actually, she said Mr. Killian does not have to show that the underlying unit costs are reliable. And we would vigorously disagree with that. We would contend that is not a correct statement of Texas law. Under the Gamble case from the Texas Supreme Court, each material part of an expert's opinion and methodology must be reliable. Here, where Killian is using inputs to support his entire damages methodology, those inputs have to be carefully and vigorously analyzed to determine whether they're reliable. If they're not, the entire methodology falls apart. And that's all I have, Your Honor. Thank you.
And Your Honor, I'll be brief. With respect to the arguments made by the Peelers Council, first off, the motion to exclude didn't challenge Killian's qualifications or his use of the decision tree, although we reserve the right to do so later on. But the Peelers decided to use a vast, extensive part of their paper in response, as well as their time and argument today, for some reason to detail his qualifications and his use of the decision tree. The issue with Killian's opinions is the underlying data that he used and basically picked out of nowhere that's not supported. Now, when the court asked for where these unit costs came from for this $100 million damage model, we all anxiously waited because we had not seen it before. And what we got instead of an answer was where these numbers did not come from. For example, RS means. Mr. Killian didn't use RS means, as Peelers Council noted. And we didn't see any work from Mr. Killian documenting his evaluation of RS means in this situation. Although the Peelers Council pointed out that there were some items that were taken from the permit and from Golder, the vast majority of the units for this $100 million damage model came from alleged estimates or unit cost numbers from the Peelers' other experts. And I want to point out the reference to Mr. Wade Major. First off, specifically, I want to share my screen real quick. There's nothing in Mr. Killian's report here that was attached as Exhibit D listing any documents from Mr. Wade Major or any opinions from Mr. Wade Major relating to these unit costs. And although during the deposition of Mr. Killian, no Wade Major was referenced or questioned about. However, another one of the Peelers experts, Mr. Bowman, that we had a recent hearing about in this case, did discuss Mr. Wade Major at Aqualogic and basically described him as.
And I'm sorry, I've got to take a call.
Yes, Ron. Do you,
Okay, I'm sorry. I get calls at all hours from officers wanting search warrants, and that was one. So
completely understanding, Your Honor. Absolutely. I was discussing Mr. Wade Major, and like I was saying, although Mr. Killian doesn't list Mr. Wade Major in any of the documents or support, nor was he discussed during Mr. Killian's deposition, another one of the depositions of the Peelers retained expert, Mr. Bowman did discuss Mr. Wade Major. And basically, Mr. Bowman described Mr. Wade Major as basically the point of contact at Aqualogic. He was kind of more or less a glorified secretarial librarian, as it's shown here in his deposition. Mr. Wade Major was just a point of contact to get information from. So the idea that he was providing opinions and stuff like that is not, as a retained expert, it's just not there. And Your Honor, I want to bring back the point to when this court specifically asked about where these unit cost numbers with respect to either Aqualogic or from Mr. Johnson with Burris came from, what the court got, and I'll quote, was they sourced those numbers based on their experience, i.e. it came from their heads, i.e. it's Ipsy Dixit. That is not a reliable source, Your Honor. And with respect to the question that the court asked about with respect to Kiewit and whether that first cash case should apply to Kiewit and the mineral lease standard should apply to Kiewit, the answer is obviously no. The reasonable and necessary standard should apply for all of the tort and statutory tort claims. And with respect to this idea that each substantive item within this damage model doesn't need to be reasonable and necessary is unfounded. That's like saying in the bathroom example that the Peelers Council provided earlier, if you get an estimate from somebody redoing your bathroom, if they provide unreasonable quotes and estimates for each pieces of tile, well, the overall estimate, of course, is not going to be reasonable and necessary. So saying that each item under this $100 million damage model doesn't have to be reasonable and necessary to allow for the $100 million to be reasonable and necessary is just completely unfounded. What Mr. Killian's testimony is going to be offered to do is, just like what the Peelers Council mentioned, future cleanup costs that are based on standards from the mineral lease, which Kiewit Mining Group's not a party to, and are based on unit cost that are, quote, sourced those numbers based on their experience, not verifiable, reliable, underlying data that can be tested. And that makes Mr. Killian's opinions unreliable and inadmissible, Your Honor.
Right. Anything else, Ms. Whittle?
Yes, Your Honor. I just want to show you again the Schedule B3. Your Honor, all of these highlighted costs from Schedule B source.
Okay, I'm sorry. Somebody's got noise going on. Right, that sounds better. Go ahead.
Your Honor, all of these highlighted costs are sourced directly from San Miguel or its contractors. The non-highlighted costs are sourced from Aqualogic, and you can see here, this shows there are sources from Golder, which is San Miguel's consultant, and sources from Aqualogic, who is the Peelers consultant. And no, Mr. Wade Major is not listed by name, and perhaps he didn't always supply the specific number, but someone from Aqualogic did. And I think that this was used both for Mr. Johnson's numbers and for anyone at Aqualogic who provided numbers. Mr. Killian referred to Aqualogic repeatedly in his deposition, so I'm not sure why the coal companies feel they didn't have appropriate disclosure on that. And should the coal companies take issue with any specific input number, they could attack the subject matter opinions by the experts who provided those unit costs, specifically Mr. Johnson. It's not appropriate to attack Mr. Killian's opinion, which is based on the methodology provided that is followed in these types of cases in which he adhered to, and no one has suggested otherwise. So thank you, Your Honor.
Right, but again, do we know how these numbers were obtained from Aqualogic? Who they were obtained from at Aqualogic?
Well, I believe almost all of them were obtained from Mr. Johnson. I'm actually not sure which might have been obtained from someone else, but that was what, to the extent that it was obtained from someone else, it would have been another person at Aqualogic. Just because Mr. Brown wasn't aware of it doesn't mean it wasn't obtained from an environmental engineer.
Your Honor, if I may just
Let me
briefly.
just ask, my note on Gordon Johnson, one of my notes on Gordon Johnson says that he has no data, that he relies on Aqualogic.
So, Your Honor, that testimony is incomplete. Mr. Johnson, this has been his business for 30 years. He's the lead engineer, the engineer of record on mining and reclamation projects. Part of his job is to come up with budgets. He knows the unit costs for various things, just as any contractor would know when they're producing a bid. They have numbers in their head based on their experience, and Mr. Johnson can rely on his experience and those standards that that Mr. Killian relies on, and the EPA standard that the counter defendants present, both allow for experienced environmental engineers to provide inputs. And then the decision tree analysis on top of that accounts for any probability that that there might be uncertainty about numbers. And any bid has uncertainty about numbers. And I think, to the extent there's a question about any specific number, they can raise that with Mr. Johnson or with Mr. Killian on cross-examination, but it's not a basis to exclude an expert from testifying.
And who is Mr. Johnson with?
Mr. Johnson is with Burgess Environmental, but he was contracted through Aqualogic, which I think is where some of the confusion arises.
And does Mr. Killian, either in his deposition or his report and his list of sources for his report, refer to Mr. Johnson?
Yes. He refers to Aqualogic, Your Honor.
Okay. All right. Anything else?
Yes, Your Honor, just briefly, I think this entire discussion that's happening right now, and that we're still having questions about who at Aqualogic may have provided the source of these unit costs, shows the problem with the entire methodology that relies upon these unit costs. To the extent that Mr. Killian relies upon, as Ms. Whittle described, other experienced engineers that can provide input, the standards that she cited don't say that these experienced engineers can provide input without any support and just come up with numbers. But to get to your question, we're not sure, based on the spreadsheet that is attached to Mr. Killian's report, from Aqualogic those numbers came from, whose experience and judgment those numbers are coming from, and there belies the problem.
All right, Mr. Schneider, anything?
Yes, Your Honor. I just want to simply state, as the court referenced earlier with respect to Mr. Johnson, your notes were correct. In his deposition, when asked whether he had backup for those costs, for the estimates he provided, he said no. They're my reasonable estimate based on my experience. As the court saw earlier, he testified that it just basically came from his head. And simply because another expert used the Ipsy-Dixit from another expert doesn't mean that it's reasonable and reliable. An expert can rely on another expert's opinions or foundational data if that data itself is shown to be reliable. But if that underlying data that's even provided by another expert is unreliable because it's just simply Ipsy-Dixit, means that it's not reliable foundational data, and the whole house of cards falls down, Your Honor. That's all I want to say.
Your Honor, I just wanted to clarify, I did, while we've been on this, emailed with Mr. Killian, and he says that he relied solely on Mr. Johnson's numbers. It looks like if you look at that, he discussed this directly with Mr. Johnson, so he got all of his numbers from Gordon Johnson. He also, if you look at the deposition testimony that Mr. Schneider was just showing you, if you look right above it, Mr. Johnson says he got certain numbers from discussions with other members at Aqualogic. So to the extent they have concerns with where these numbers came from, they can discuss those with Mr. Johnson. But Mr. Killian was reasonable in relying on the expertise of Mr. Johnson, and that complied with the methodology that he followed. And in addition, he relied on other cost inputs that were provided by San Miguel and its experts. So to the extent there's a specific cost that they feel should be excluded from the damages model, that can be raised in cross-examination, but is not a basis for excluding Mr. Killian.
Okay, all right. And we will end this, and I said I have all Thursday off. Get as many of these out as I can. We'll see y'all soon. Anything else?
Your Honor, just one quick housekeeping matter. When we were talking about referral of the expert motions to the special master, you asked about Mr. Baer's qualifications. The qualifications were set forth in the appealer's request for appointment of the special master that you granted back in November of last year. Would you like to do that motion via chat?
I'll still have it. I don't necessarily remember what I did this morning, much less what was in a motion last November.
Understood. Okay.
All right, then y'all are excused.
Thank you, Your Honor.
Thank you, Your Honor.
All right, Ms. Poppy, if you would end the motion, in the meeting.
Yes, sir, I will.